We are live. Hello, everybody. We got day 4 of Michelle Troconis. I know you guys the last couple days were kind of dragging. This is going to be the good stuff, though. From where we're at. I think we're looking into the really good part of this here. The nanny's starting to testify, and from what I've heard, there have been some interesting happenings going on. So that will be the very interesting way that it'll be worth it. It's going to get better. It's going to get a lot better and a lot more fun. I think we'll be able to get caught up this weekend. The trial is still going, but there's a lot going on there. There's Ashley says first. Hello. Mike says re. Perfect Cap says hello, hello, hello. Good to see you. So we are going to get this fired up here. Video. Michelle Troconis trial. I was told that with day 4, there were some issues with the jurors. So we should be able to see that as it happens as well. But the person first up is the nanny. And Mr. Sheffield. Not that nanny. Not that nanny. Thank God. But a nanny. Jennifer Dulos is Nanny. Not Mammy, Nanny. Oof. God, that was bad. So, Ronnie, hello. How are you doing? Frozen Cedar Rose. Yeah, it snowed really bad after I got going today, but yeah, this morning it was pretty clear on the roads. All right, so we're gonna give I don't know. We'll give everybody a couple minutes to get here. If you guys were not aware, Alec Baldwin was just re-indicted for the manslaughter of Helena Hutchins. So that just happened. And, there's a lot to go from there. Although the neat part is now I've got an excuse to go out and buy I got an excuse to go out. Can you remember what I said? I was going to go out and buy a Pieta single action army. Well, now I've got a great excuse to go do it. So, and I'll be like, it's a show aid, and maybe I can write it off. Tom is saying, "Wow, jail for Alec. If he gets convicted, yeah. Oh, I could see it. But I also could see him taking this all the way to the end. So it'll be tough for us to know what's going to happen with Eric Bauerand. I did also want to just introduce really quick. There is new merchandise up at the merch store, including this bag boy right here, as you can see. And then on the back side, we've got that. And the rest of it, though, is over at Teespring. And Teespring logged me out because I haven't been on in a couple minutes. It's frustrating when they do this. So this is a potentially criminal it's called Creator Spring now, but it's Teespring. And one of the things we have is the for Sarah Boone, it's the possible defenses, it's battered spouse. And we have a couple of those. We have some options there. We have as a coffee cup. There's some glasses. And what I will tell you is I ordered a proof and I sent that out for some of the locals' Christmas gifts. It actually looks a lot better in person. It's not as stretched. It's actually very well balanced on the pint glass. You can get a coffee cup like that. We got a couple other things that I'll be getting uploaded soon, but there is a if you want to have a camping cup, you can have one of those. Sadly, there are no Stanley options available. So just want to let you guys know that's some of the stuff that's coming up there. The luggage tags, yes. Very, very possibly. I think I might have that all squared away. The back of this says, just because you did it doesn't mean you're guilty. So, but yeah, Tom, you're saying jail for Alec? Yeah, it could be possibly, but we'll see if he is foolish enough to want to go to trial, because remember, it's up to, it's the client's decision. Tom says golf shirts. I'm gonna have to look, see if they have those as an option. I'll look for that. So we are gonna get started here. We got 30 people, and that's good enough. We are gonna start day 4 of Michelle Troconis. So here we go. The last one we started off, the nanny was testifying, and she hadn't gotten very far yet. So we are gonna get going on her. All right.
I'm reading it as we speak, Judge.
So we've got an issue, apparently. But it has not started, so apparently...
I'm reading it as we speak, Judge. And good morning, and may it please the court.
Apparently there was a juror issue.
This morning first, you may be heard on the motion.
Thank you, Your Honor. Maybe I misunderstood yesterday when Ms. Almeida was testifying and she was explaining what she said, and I had objected on the grounds of hearsay, and I believe that Your Honor had indicated that because she was present and able to be crossed, that it did not constitute hearsay. If there's another reason why it should be admitted because there's an exception to the hearsay rule, or it's not hearsay because of something other than the fact that she's present and able to be crossed, that I understand. But I would like to ensure that just because she is here, that does not mean anything that she had said outside of court.
Oh, crap. Sorry, guys. Sorry.
Well, this is a motion to eliminate to preclude certain evidence that the defense considers hearsay. And the court is not inclined to rule in the defense's favor on a motion to eliminate to preclude hearsay statements, because as those statements or as those questions are proper, the defense has an opportunity to object. The court will take up the objection when the objection is made.
Thank you, Your Honor.
Our counsel prepared to argue the motion concerning the STR mix evidence.
Yes, Judge.
Thank you. First, the court recalls that the defense had indicated that it would essentially challenge the STR mix evidence by way of a quarter hearing. First, is that the defense's position today?
I've had some opportunity to discuss this with Mr. McGinnis. I am not seeking to preclude any evidence from the STR mix program. I've had a fair amount of opportunity to research, read up about it. My claim is more narrow, that there needs to be a quarter hearing on the so-called likelihood ratio. I'll just be clear on what I'm not challenging. I'm not challenging the fact that this program does what's known as a deconvolution analysis. It takes what is essentially multiple depositors of DNA and runs a number of odds, for want of a better term. In other words, it takes mixed DNA that could be anywhere from 2 to 6, 7, 8 different depositors of DNA, touch, any kind of fluid, anything that sneeze, anything that has DNA in it. It determines, based on certain input by the lab assistant, that they determine how many contributors they estimate. This program then runs statistics, thousands, hundreds of thousands, I think in some cases, millions of scenarios, and comes up with odds. And that's why I'm challenging this part of it. What the odds are that one scenario, that is the prosecutor's theory, is more likely than the defense assumed theory. Again, they don't necessarily know what our defense theory is, but they put in a suggestion that maybe it's someone else's or it's a third party's or whatnot. So this program, which is proprietary from a New Zealand company and no one has access to, again, the only scientific studies of validity have been conducted by a team that's made up of the company's vice president. There's been no independent study. And I'll just say this, the PCAST report, that is the President's Commission on the Admission of Scientific Testing, concluded in 2000, I believe, 20, that STR mix has promise, but there are no scientific validity peer-reviewed studies. There are only studies that have been conducted by the company itself and people that they themselves have brought in. So the only portion for this hearing and for this trial that I'm challenging are the odds. In other words, this computer runs I think it's called the Markov Monte Carlo analysis algorithm. It's the same, not exact algorithm, but the same process that's used to calculate the odds of winning the lottery, the Powerball, when it's $1 billion. So the problem with that is that just because they're giving out odds doesn't mean that only 1 in 1 billion people could win. If that were the Powerball, if that were the case, that if it happens that 2 people guess the numbers, the misconception is that, well, someone must have cheated, someone must have gotten the numbers in advance because the odds were 1 in 1 billion, and here 2 people in 1 billion got it. So my concern has to do with these numbers. These are not these numbers do not mean that it's 100 billion or 10 billion, or in one case, 250,000 to 1, that a particular profile, DNA profile, may have been the source of a mixture on a sample. Instead, what it is it's the odds that the person's DNA is on there as compared to X number of other unknown persons, even if the other people were known. And the problem with that in this case is that there are going to be, some of these tests are going to show that, for example, all of the children, all the Dulos children are included in some and are partially included in some. So we've got this problem, and that's the reason for the Porter hearing, which would require the witness to substantiate it, and I would then cross-examine about the lack of peer review of the odds. We're just talking about
this
those
is a good argument.
numbers. In the past, Your Honor, I'm sure has had cases where the DNA lab has said someone's included, someone can't be excluded, or something is inconclusive. And inconclusive, according to the laboratory, is that it's too small a quantity, or it's too many contributors, it's too convoluted, therefore there's a high risk of error. So they say it's inconclusive, has no validity. So there are those 3 potentials: included, cannot be eliminated, which I think they recently changed to consistent with the sample, but is lower than included, and inconclusive, which they say is, they can't make a determination. The thresholds are too low, too much chance for error, so and misidentification. So they call it that. I am only challenging these odds that the computer program has calculated based on this the Markov chain Monte Carlo algorithm, because it's just based on a computer program calculating odds. And I believe the only case in Connecticut is the one that the lower court case that was cited. I'm not seeking call experts that beyond using the laboratory personnel as the basis for that. But I'm just indicating that because there's no appellate level case in Connecticut, and the cases from elsewhere have only dealt with whether the program itself has any validity, and it has at least the program they've used. In those cases, they've used known samples, let's say lab personnel, and they've run the program and it's come out correctly. That's not the same thing as a peer review of the odds that it was correct. And that's the problem I have. It's assumptions that are programmed into it. So I don't know how the court wishes to proceed, but the state is the proffer of this evidence, and I'm suggesting that we need some evidence, maybe a half hour to an hour. I don't want to preclude the state from playing more than that, but based on my understanding of what I intend to elicit, I don't think it's going to take more time than that.
Well, the court has this question first based on counsel's explanation. The first question is, how can you deconstruct the STR mixed software from what it produces, which is the likelihood ratio? The second question is, it appears counsel's argument is not that the STR mixed software producing the likelihood ratio predicts the right odds. It's just that the odds that counsel believes are not correct are not subject to peer review. In other words, this set of odds versus that set of odds. That's how the court understands the argument. Not that there are no odds that should be calculated at all.
So, poignant observation, Your Honor, but let me just say this. The program itself is mysterious. No one that I've consulted with or cases that I've read can testify as to how this program operates. It's proprietary, it's secret. They have refused to release it, except I think a federal judge allowed an expert to review it, but only by promising that they could not divulge to anyone else what they saw in this program. That's my understanding of how this works. So to answer your question directly, I believe that because no one knows how the odds were calculated, and they're not done by the expert using a calculator or chalkboard, like I saw in the movie Oppenheimer, where they're figuring everything out on a giant chalkboard. It's just somebody punches in some numbers and the computer runs for 5 minutes and it spits out percentages and odds. What I'm not challenging here are what's called the deconvolution. That's the portion that separates out how many different people they believe are in it, and some may be stronger than someone else. I'm challenging the numerical odds, which is all it is. It's percentages that this computer program is saying, how much more likely are the odds that the sample that's been deconvoluted has a principal or majority source, because they don't know how something got onto a particular object. We're not talking about blood here. I want to emphasize we're talking about touch DNA, skin cells, which is my understanding is as little as 3 cells, which is approximately 22 or 21 picograms. And just for the court's edification, a picogram, 6.6 picograms is 1 cell. Picogram is a trillionth of a gram. So we're talking about something that is so tiny that it would require an electron microscope even to see. So I'm not challenging any of that. It's the calculated odds that those trillionths of a gram of DNA are more, the odds, the number is more likely from one source than an unknown source. And I suggest that's for litigation purposes. It's not a scientifically reliable calculation.
Well, as the court understands the argument at this point, the question that solves the mystery is, what equation did you use, proprietary entity, to come up with the odds that you have calculated? They know the equation that they've used. And the extension of that argument, as the court understands counsel's argument, if you know the equation and no one else knows the equation, how could it have been peer reviewed? Correct.
When you say you mean the company in New Zealand. Yes, that's right. That's exactly right. Sort of like, I'll use an analogy, an everyday analogy. Right on my screen right now is a image of looks like a desert scene with a road. That's the screensaver. That's made up of millions of pixels. I could tell you somebody obviously took a photograph, maybe in, it says North Africa in the corner, so I'll accept that as the screensaver on my screen here on my desk. But I could not describe the program on how a computer took a million pixels, put it together so that it would show up on a screen. Someone knows how to do that, and someone could testify to that. We're not here to challenge that, but it's the same concept. It's a secret that only this company knows, and it keeps it so well protected so that no one else can copy it. And if nobody can copy it, it can't be peer reviewed whether it's accurate.
Well, is it
Oh my God, I did unmute. Okay, sorry. So this is not uncommon where you have like the computer software itself being protected, because breathalyzer machines are a great example of this. Attorneys will ask for the breathalyzer machine, the operating software, the algorithms, to have it examined, and they'll say, nope, that's a trade secret. It's our protected. Can't have it. And yes, that means it's not able to stand up to scrutiny or look at it in that way that happens. So that's not an uncommon thing there. I do think it's interesting that they're having that issue. So here we go. This is getting... yeah, there's a problem when no expert can testify. Yes, that creates a problem there.
possible that there can be a peer review without disclosure of certain proprietary information?
An interesting question. I don't know the answer to that. However, enough cases I've read on peer review means it was reviewed in a scientific journal that anyone in the scientific community can review, and they have a peer review group that then writes something saying, yes, we reviewed the algorithm, we tested it out, we used scientific method, and we find that it meets the standards of scientific, the scientific standard that we can substantiate it. I'm referring to the Presidential Commission that said, you know, it's an interesting concept, but we have not seen any independent review, and they criticize the fact that the only reviews that are out there are by a fellow named Buckleton, who's a corporate vice president of the company that he came up with it. He's doing his own self-substantiation, which they said does not meet the standard. So that's all I'm going on. Now, if we wanted to take even more time, I could challenge the entire process because it has not yet been fully reviewed. I'm limiting for our trial here because of the fact that there's so little DNA that's in any contest at all here, in terms of whose it is, or whose it might be. And that's why I'm limiting it to the issue of the odds, which I submit. Well, because I can't cross-examine that because nobody knows, including the lab scientists, how it came to that conclusion. It will be confusing to the jury. They will, as inevitably will occur, think it has more significance, these numbers, than they do. You know, they're as high as, the odds are as high as 100 billion to 1. Even the, I'll just note, even the warrants that the police applied to misapplied the findings when they stated somebody was a match or not a match. That's not what it even does. But again, I'm not here to criticize what the police did. But if the police got it wrong in the warrant, in some of these warrants, the jury's going to get it wrong. And that's why we need to establish, I believe under Porter, the court is a gatekeeper to decide whether it has relevance, whether it can be explained or even cross-examined, and whether or not it will be of an aid to the jury, or perhaps it will be confusing, and therefore maybe the prejudice would outweigh any probative value. So that's the purpose, and it's limited to them. But I think the state, as the proffer, has to make the proffer in the first place. Whether it's done partially in front of the jury and then we excuse the jury, that's up to your honor. But the state has the burden of showing, and the fact that there's one Superior Court case by Judge Dadabo that allowed it in, that was not the challenge. It did not have to do, that was a challenge to the whole program and whether it was reliable. I'm not doing that. I'm only challenging the use. If the state wants to exclude the use of the likelihood ratio, and emphasize, it is not a scientific result. It's the likelihood that the state's theory is more likely than the assumed defense theory to the contrary. So it's calculating odds. It's not calculating science.
Well, what the court is going to refer to is Judge Dadabo's decision, because the court is not persuaded that the likelihood ratio calculates the likelihood of the state's theory against the likelihood of the defense's theory. The STR mix software produces what is called a likelihood ratio. Now, a likelihood ratio expresses the probability that a match between a sample and an individual is X times more likely than coincidence would have it.
And that's the point. It's how likely is the match to be matched up? Not, is this 100% Jennifer Dulos' DNA, but it's 1 in a trillion odds that it's someone else's. So yes, that is the point. The judge kind of steals my job for me at this point, but it is nice for him to say it. He's very eloquent.
The SDR mix is more likely to yield a likelihood ratio favorable to including true contributors to a mixed DNA profile and favorable to excluding true non-contributors to that profile. So how does the probability description, the likelihood ratio, favor the prosecution rather than the defense, if the favoring goes to both inclusion and exclusion? That's a question for Attorney Shelton.
Let me give the court just one example. When it comes to certain samples that are of the known sample of Jennifer Dulos, they used a toothbrush, for example, from the bathroom, master bathroom in New Canaan. The STR mix calculated the odds of that being Jennifer Dulos' DNA of 1 in 100 billion to 1. So 100 billion to 1 that the...
Okay, no. I wish it was just not... No, it is not narcolepsy. It's just... It's the end of the day, and it's also being a very fat guy. So, just saying. I wish I could say it was that.
Contributor to that DNA sample was Jennifer Dulos versus an unknown third person that they just assume is like an unknown third person. Now, there aren't 100 billion people on Earth. So the only conclusion one could reach is that the only person who could possibly have contributed that sample is Jennifer Dulos. But that's not something I'm contesting about her toothbrush. Much of the samples are partial DNA. They don't even have a match. So the problem is the machine and the calculation is adding fake alleles. And it's saying, well, if we add this one, then if we add that one, if we add that one, but it's doing multiple, and I mean millions of calculations. If we add in this allele, what are the odds? If we add in the next allele, what is it? If in a different locus on the DNA strand, we add this. So it's doing all this, and then it's calculating odds. Now, if it's less than those odds of 1 in 100 billion, there is a threshold where the lab will say, this is too low, it's too unreasonable. We may not be able to exclude somebody, but even if there's only one allele, that person may be included because of that. And the problem is it's too easy for a jury to think, well, if one allele is in there, and if the defendant, or for that matter, Fotis Dulos, is included in that, then it must be him. And the problem is there's all these issues with the children matching in some cases. In some of the children match. As I'm not objecting to all that. There's a PowerPoint that I don't know if Mr. McGinnis has been put in. I'm not objecting to how DNA, it's how you inherit from each parent, et cetera, et cetera. So this is all science that I'm not objecting to. So there's a lot of this that's going to come in. The only thing I'm challenging is they're not going to say it's a match. They'll never say it's a match. They will say it's 100 billion to 1 more likely that it comes from that toothbrush than it is that if it was a totally random person. And again, since there aren't 100 billion people on Earth, this calculation is what's prejudicial, not the fact that they said it's a match, that they say that it's consistent with, or the DNA matches the individual. That's my point.
Well, of course, peer review is only one basis for determining whether a methodology is valid. How would you respond to the argument, Attorney Schoenhorn, that the STR mixed software, which yields a likelihood ratio, is better than the extraction amplification method?
What's interesting about that, Your Honor, is that's what Mr. Ladd testified to at that hearing, according to what I'm reading. I don't know if the court would reach the same conclusion about that. The challenge to the extraction method requires a fair amount of individual assumption and eyeballing by the scientist. There are, of course, videos or photographs. If one wished to challenge that process, one could, although that's been established over the years. That's going back 20, 30 years. They've had electrophoresis. The lab person will take, I think it goes back to when Your Honor was practicing law. There would be a form of, they would run a sample through electrophoresis. They would determine peaks and valleys and come up with a DNA profile from that. If it was a mixture, it would be a estimate based on the particular lab assistant's proficiency as to whether that was 2 or 3 or 4 individuals. I'm not, in this case, challenging the manner in which they have extracted the DNA. They recently changed. They used one program.
I thought I said hello, but I was muted.
They just started using it. And I understand that just in the last month, they reran my client's DNA and the numbers came out lower than in the previous one. So again, I'm not going to challenge, especially since those numbers are more favorable, but be that as it may, I'm not getting into the challenging of the extraction method that's been used for 15, 20 years. They've changed from one brand, one company that they use to another. There's been a number of hearings on that over the years, a number of cases on that. So I don't know if I agree with a conclusion by a coordinate judge that that's better than the extraction method. I don't agree because there's, other than Dr. Ladd saying that at that hearing, I don't know of any independent analysis that says that. That's my response.
How would you respond, Attorney Schoenhorn, to the argument that the peer review doesn't go to, we will call it the exactitude of the odds. The peer review goes to whether STR mixed software is just better than extraction and amplification. That's what we peer review, not the component parts of proprietary information.
Well, it's, to my view, and again, I'm not a scientist, but in reviewing this, I think it's apples and oranges because the extraction is a completely different method, a different program. So if one is saying that, I don't know, a program like Photoshop is better than a PDF program that also can create photographs, I don't speak to that. The difference is, does the program that creates the photograph, is it better than a program that calculates the weather patterns for the next week? So I can't compare the two. The fact that Mr. Ladd likes it better, since he doesn't know, as I understand that he doesn't know how it operates, the fact that it's more efficient for his purposes doesn't make it, quote, better, unquote. I don't know how else to answer Your Honor's questions. I mean, I understand Your Honor's concerns and I'm trying to meet them, but I don't have that expertise. I can only go back to the fact that the state, we have a lower court opinion. It was not appealed, that case. And so therefore, if the court is just going to adopt what another judge says, at least the court needs to have reviewed the transcripts. I mean, I'll say what I want to be perfectly candid about this. The Nunez case was my case. I was there for that entire case. I don't know if Mr. McGinnis knew that, but that, I mean, I know that I did this like 3, 4 years ago, had a hearing, but in that case, it was still brand new. I challenged the entire use of that program. There were only 1 or maybe 2 cases, and some had rejected it, one had rejected it, and one had permitted it, but never got to the issue of the putting in the numbers of the likelihood ratio. And we're talking now just about those numbers. That case was an alleged sexual assault. It resulted in acquittal. So there's no appeal, no appellate review. But I'm just letting the court know, I'm not speaking like I'm just reviewing a decision. I was there. I spent many hours with Dr. Ladd, but the issue there wasn't the numbers. It was the program itself being convoluted, for want of a better word.
Attorney McGinnis.
Good morning, Your Honor. Good morning. Judge, of course, we do object to the motion for order hearing. I think that this, Your Honor, can succinctly be rejected on a couple of different grounds. The first is that at this point, STR mix, as we stand here in 2024, is generally accepted in the scientific community. And I'll rely primarily, Your Honor, on our memorandum of law or objection in opposition to the defense's motion for a order hearing. The cases that we cited, Your Honor, extensively detailed the reliability of the STR mix. And in fact, the only case that the state was able to find in which the STR mix was initially rejected as unreliable was subsequently reversed by the Sixth Circuit. So as near as the state can tell, if this court were to find that STR mix is unreliable, he would again be the first court in the country to do so, because the one decision that found so no longer stands. So if we look at State versus Rayner, which provides the court with guidance on how to handle a motion for proposed order hearing. Number one, if the court finds that STR mix is generally accepted in the scientific community, then the burden shifts to the defense to produce, and Rayner describes it as a heavy burden, to produce some evidence that calls into question the scientific validity of STR mix, and they haven't done so in this particular case. The PCAST report that Attorney Schoenhorn mentioned is from 2016 and was actually in front of Judge Dodavo at the time that he made the decision in the 2019 Nunez case. The court will review Judge Dodavo's decision. It was entered in as an exhibit, specifically Defense Exhibit A. So once the court finds that this is generally accepted in the scientific community, the defense fails to meet their burden. But even if the court disagreed with the state and decided that it wasn't generally accepted within the scientific community such that it's reliable enough for admissibility, Rayner gives even additional guidance which cuts against a order hearing in this instance. And that additional guidance is the court can take judicial notice of Judge Dodavo's opinion. You're not required to do so, but you can take judicial notice of Judge Dodavo's opinion. And one of the things the court can consider when taking judicial notice of Judge Dodavo's opinion is whether or not the defense has produced any new information which calls into question Judge Dodavo's opinion. Now, respectfully, the defense has not done so in this particular case. They haven't even admitted the actual PCAST report for purposes of this hearing that was in front of Judge Dodavo as part of their proffer. So the defense, frankly, Your Honor, has done nothing to call into question Judge Dodavo's opinion except try to distinguish Judge Dodavo's opinion and say, even though I challenged the entire software back then, I didn't challenge the likelihood ratio portion of it. That makes no sense. If you're challenging the entire software, you're necessarily challenging any data that software produces. And so, frankly, Your Honor, I think that this can be very easily disposed of because number one, the cases that we've cited to the court show that this is generally accepted in the scientific community. And number two, Judge Dodavo has already subjected this to a court hearing and the defense has done nothing to call into question Judge Dodavo's opinion here as part of their proffer. So I'm asking that the court exercise its discretion under Rayner and deny the defense's request for a court hearing. And let's get on with the trial.
Thank you. The court has had an opportunity to review Judge Dodavo's decision. The court has had the opportunity today to listen to the arguments of counsel concerning the validity of the methodology that yields a likelihood ratio. The court's first consideration, just based on the representation by defense counsel, the first concern, the court should say, is the court is not clear on how the STR mix software can be valid, but a component of it not be valid. If A plus B plus C equals D, how can A plus B equal D without C? So the court is not clear on that argument. Concerning the Porter factors themselves, there are a number of factors that are considered. According to the case law, the weightiest of which is acceptance, general acceptance in the relevant scientific community. So the list includes general acceptance in the relevant scientific discipline. The methodology has been tested and subjected to peer review. There is a known or a probable rate of error. The prestige and background of the expert testifying about the methodology, and whether that expert's opinion about the methodology is based on his or her subjective opinion or is based on verifiable objective criteria, and whether the expert can explain to the jury methodology well enough for the jury to understand how to apply it to the facts of the case. Now, the finding in Nunez was that the STR mixed software is generally accepted in the relevant scientific and legal community. The finding was that the methodology was tested and peer reviewed, and the known or potential rate of error was low. Judge Dodavo concluded that the expert witness was highly competent and was capable of presenting the data and processes to the fact finder in a way in which the fact finder could reasonably use the information to make a decision. The court is relying on Rayner. New information coming to this court's attention was only in the form of the PCAST report, which indicated, as the court understands it today, that the calculation of the odds is a mystery and it cannot be, as a mystery, peer reviewed. That's how the court distilled that information. That is not enough information for the court to require a Porter hearing. So the court denies the request for the Porter hearing.
Well, hold on. Wait. There's an admission. It's a literal mystery how you determine the science to the test. And that's not enough. And the state's not contested. How is that not enough to have your Porter or Daubert hearing? What? That's... I mean, what more do you want? And that I do not agree with that at all.
Are we ready to proceed with the state's witness?
Yes, Judge.
Your Honor, when the witness comes in, if Your Honor could please request that she keep her voice up so everybody could hear, I'd appreciate that.
Thank you.
Thank you.
Well, let's see if she's going to keep her voice up anyway.
Thank you, Your Honor.
Thank you. Well, first, let's bring the jury in.
Kind of important. You do need the jury.
You hold the witness right there before the jury comes in, please.
Just want to remind everybody, new merchandise over on the Teespring down below in the link. I like to dissect women. He argued it well.
For the presence of all the jurors.
Yes, Judge.
Good morning, ladies and gentlemen.
Here's the problem. He argued it well. The issue is we have like 40 years of DNA evidence being allowed in court. So basically he's looking at that as we've got all this precedent and now you're telling me it's not 100% accurate, this issue. That's the issue there. As he stated, like every court in the country has accepted DNA evidence and the STR testing. So, and PCR testing and all of these issues. Polymeric chain reaction, all that crap has been, decades of it. So that's what he's basically punting. He's taking an out here. I mean, I don't know what more you can do to make this true or bring it up as an issue, but hey, that's why he's a judge and I'm not.
We resume with the testimony of the witness you last heard from yesterday evening. And you are still on the roll. You may take a seat. Thank you.
Good morning.
Morning.
Ms. Almeida, if I were to show you a photograph of Jennifer and another photograph of Jennifer with her children, would you recognize the individuals?
Yeah.
May I have these marked, Your Honor?
Has counsel seen them?
I have, Your Honor.
I'm handing you what's been pre-marked for identification as State's Exhibit 15 and State's Exhibit 14. I'm just going to ask that you please begin by looking at State's Exhibit 14. What is that photograph of?
It's of Jennifer.
And approximately how old is Jennifer in that photograph?
Well, it looks like she has Noelle next to her, so she was maybe in her late 40s, early 50s.
So, Almeida, it's difficult to hear you.
Oh,
So would you
sorry.
please keep your voice up?
I would say her late 40s or early 50s.
Judge, I move in.
Objection.
The number again, please.
State's 14.
State 14 admitted as a full exhibit.
And now just directing your attention to State's 15. Can you tell the members what's depicted in State's 15?
Yeah, this is a picture of Jennifer and the 5 kids.
And how old are the children in that photograph?
If I had to guess, I think maybe Christian and Constantine are 6 or 7, and the boys are 9 or 10, and Noelle 3 or 4. And it looks like they're in a classroom.
Move it in, Judge.
State 15 admitted as a full exhibit.
May I publish to the jury, Judge?
Yes. Well, it's going to take a long time to do it that way, Attorney McGinnis. You should hold it up and show it to the jurors.
That's fine, Judge. Thanks, sir. Publishing states 15 and 14. Where we left off yesterday, Ms. Almeida, you had indicated that you were familiar with the defendant. Is that correct?
Yes,
Where did you meet the defendant?
in Miami at the ski club,
When did you meet the defendant?
March of 2017.
How long after your arrival in Miami did you meet the defendant?
Probably like the next day or a few days after, because we went right to the ski club.
And can you describe the ski club for the jury?
There was like a gate that you kind of drove in, and then there was everyone's boats like kind of in like a port, and they would take out the boat to go into the water. And it was a pretty narrow like lake, and basically it was used for water skiing. And there was like a little outdoor area that had a tent and a table that you could hang out in if you weren't skiing.
Was it a public ski club or was it a
Fancy.
private ski club?
Private.
Did Mr. Dulos own a boat?
Yes.
When did he purchase a boat?
I'm not entirely sure the exact like month, but I think it was like maybe 6 months to a year prior to that trip in 2017.
What type of boat was it?
I don't need a ski nautique. I might be getting that wrong. It was a ski. It was made for skiing. So
Where did he keep the boat?
in Miami.
And would he travel to Miami?
Yeah, often, yeah.
And did he keep the boat at a particular place in Miami?
He kept it at the ski club.
When you met the defendant, was she with anyone else?
Her daughter,
And what's her daughter's name, if you recall?
Nicole.
Approximately how old was her daughter at the time?
She's the boy's age. The boy's the 17-year-old boys now, so maybe 12, probably 11, I think, around that age.
Did Jennifer ever go to the ski club in Miami?
No.
Where would Jennifer stay if she wasn't at the ski club?
Well, her mom was visiting at the time too, so she was with her mom at the hotel or with the youngest, Noelle, who would come to the ski club sometimes, but not as much as the other kids.
How many times while you were in Miami during this March 2017 trip would you say you were in the defendant's presence?
A few times.
Who introduced you to the defendant?
Fotis.
Did Mr. Dulos introduce his children to the defendant as well?
Yeah, I think prior to that trip.
Okay, when you say you think prior to that trip, can you explain to the jury what you mean?
Yeah, so when we got there, they were calling her Mitchie. And so and they hugged her, so like they already knew her. I believe it was just the two boys, so Petros and Theodore. I don't think Krishan and Constantine or Noelle had met her yet.
Would Mr. Dulos travel to Miami with the older boys, Petros and Theodore?
Yeah.
Prior to this trip to Miami?
Yeah, prior to this trip.
Can you describe your interactions with the defendant at the ski club for the jury?
Yeah, so Fotis introduced her as a friend, and she was nice. She was with Fotis a lot, like they'd go on the boat to ski, but there was one time I had a conversation with her when we were underneath the little tent where you can kind of just hang out. I remember
were
the conversation.
friends.
She was telling me she just got back from Colorado. She was looking at schools to go for her daughter to go to because her daughter was a very good snow skier, so she wanted her to, I think, get better or more opportunities there, I guess. But she was friendly.
When you interacted with the defendant, what language did you speak to her in?
English.
Did she have any trouble communicating with you in English when you spoke with her?
No.
Did the Dulos children interact with the defendant's daughter, Nicole?
Yes.
And I want to direct your attention specifically to Petros. What was his interaction with Nicole?
It was kind of known that maybe Nicole was his girlfriend. He was 11, but in that sense.
Was Jennifer ever in the defendant's presence during the Miami trip in 2017?
No.
Did Jennifer stay in Miami with the family for the entire trip?
No, she didn't.
Can you describe to the jury or explain to the jury why Jennifer did not stay in Miami for the entire trip?
So her mom was with us, like I mentioned, and she tripped and she ended up breaking her ankle. So they had to fly back early so she can get it taken care of. And she took Noelle with her. So they left a few days before the trip ended.
Where did her mother trip?
I think it was by the pool. She slipped.
And when you say by the pool, which pool are you referring to?
Oh, the pool in Miami at the hotel.
And just to remind the members of the jury, what hotel were you staying at?
The W?
And if we can be as precise as possible, approximately how many days were you in Miami before Jennifer left?
I think it was like 2 or 3 days. So it was towards the end of the trip.
And after Jennifer left Miami, who stayed behind?
I stayed with Fotis and the other 4 kids.
Did you guys ever go to the ski club again?
Yeah.
And was the defendant present?
Yeah.
Did there come a point in time when you were no longer staying at the W?
Yeah.
Can you tell the jury what happened?
There was one night where Fotis said that we had to stay in a different hotel, and so we drove to the Ritz-Carlton, but it was only going to be me and the 4 kids, and so because he was going to stay with a friend, and he didn't really go into specifics. It was just kind of odd, but I just agreed, and so it was the 4 kids and myself, and we stayed in one room together for that one night, and then we had to get up at like 5 a.m. to get an Uber to meet him at another ski club.
And when you say all of you stayed in one room, how many beds were in this room?
One bed.
Where did everyone sleep?
We squished on the bed. I think I was with Christian and Constantine in the bigger bed, and Theodore was probably sleeping. We had a cot, and then maybe someone on the floor.
When Jennifer was in Miami, were you all sharing a room like this?
No.
What were the arrangements when Jennifer was in Miami?
Objection relevance.
Well, the court does not know if this is preliminary to a more material matter. The court will overrule the objection.
What were the arrangements prior to Jennifer leaving Miami?
We had more of like a suite room, so there was multiple bedrooms, so that way there was more space for us to be, and like a common living space and a kitchen space also.
Did you ever see the defendant outside of the Miami Ski Club?
Yes.
Where did you see her?
We went to laser tag one day.
Approximately what time did you go to laser tag?
It was after the ski club, so it was probably like later afternoon into the evening.
And what type of facility was this?
It was like one of those places that had an arcade and a pizza and laser tag. I don't remember the name.
When you got to the facility, can you describe to the jury what happened?
Yeah, so I went in and I just kind of went right to the register to like pay for everyone. And Fotis kind of ran in after and he's like, no, you can't, like, he wanted to like make sure that he was the one paying. It was just kind of odd, or have Michelle pay. It was just a weird interaction. And I just told him, I don't want to do laser tag because I was tired and I didn't want to play laser tag. And laser tag with that many kids is very tiring. But he was pushing me to play laser tag, which was just kind of weird. So I ended up having to play laser tag while Michelle and Fotis hung out outside of the laser tag room.
And I just want to be clear about this. When you say he was pushing you to play laser tag, who are you referring to?
Fotis.
And where you indicated that they did not play laser tag, they being the defendant and Mr. Dulos.
Yeah.
Where did they stay while you were playing laser tag?
Well, because it was like that arcade kind of space, there were tables and stuff that you can kind of hang out on while the kids were on laser tag.
Was anyone else present besides you, the children, Mr. Dulos and Michelle Troconis?
I think Nicole was there also.
And did she play laser tag?
Yeah.
You indicated earlier that Mr. Dulos did not spend the night with you at the hotel when you were with the children after Jennifer left. Is that correct?
Yes.
Did Mr. Dulos strike that? Where did you end up meeting with Mr. Dulos after spending the night at the hotel with the children?
We went to a different ski club in Boca. So we took an Uber there to meet him there in the morning.
And was the defendant present at that ski club?
No.
When did you leave Miami?
Shortly after that, we took like an evening flight because we got in around 11 and we went back to their house in Farmington until about midnight.
Who was on the flight with you?
Myself and the 4 kids.
Mr. Dulos did not travel back with the family?
No, he extended his trip.
How did you get back from the airport to, I assume, Fort Jefferson Crossing?
Oh, we took an Uber
And what time did you arrive?
around midnight.
When you arrived, what did the children do?
Oh, they were all tired, so they like ran upstairs and like got into bed. So
Do you recall what day of the week this was?
I don't.
Was Jennifer awake?
Yeah, she greeted us.
And did you speak with Jennifer?
I did.
Did you spend the night at the home that night?
No, I went back to my home.
Did Jennifer discuss with you a belief she had about Mr. Dulos?
Yes.
What did she say to you?
She told me he is having an affair and I have proof.
What was her proof?
I think through email and receipts, she found out that he went on a trip to Utah with Michelle and a friend of his and his girlfriend.
What was her demeanor like as she said this?
I think she just was just like, I knew it. And she's again, very soft spoken. So she seemed sad, but also just kind of like she was trying to figure out what to do.
Did she indicate to you whether or not she was going to be confronting Mr. Dulos about the affair?
She told me that she was going to talk to him about it. And she asked if I not mention
Objection,
anything.
hearsay.
Well, the court's concern is relevance. So this appears just to be a series of events that, of course, the jury is hearing this testimony, but it just appears to be a series of events. And the court is going to keep a short leash on this chronology because it has to lead somewhere. So the objection is overruled as far as hearsay is concerned. The court concern is relevant. Overruled.
You can answer the question.
Can you repeat the question?
I will try. Did she indicate to you whether or not she planned to confront Mr. Dulos about the affair?
Oh yeah, she asked me, well, she told me that she was going to, and she asked me not to mention anything to him or to anyone.
And did you eventually speak with Jennifer about her intentions regarding the future of their marriage?
Not that night, no.
When did you?
It kind of changed throughout time, what her intentions were.
Okay, can you describe to the jury what you mean by that?
So I was in the house the next day, and when Fotis arrived too. And so when I got to the house, she pulled me aside and told me that she spoke to Fotis, and he admitted to the affair, and that she was going to try and have this be as civil as possible. Because she opened up more, saying that she was no longer in love with Fotis, but she had 5 kids, so they were going to try and work out what they could.
And directing your attention now to April 2017, did Jennifer make any requests of you as to whether or not you would stay on as the nanny?
Yeah, over the next few weeks, things were changing, and so her plan changed. And she asked me to go with her when she was planning to move, and I agreed.
Where did this conversation take place?
At a coffee shop in Avon, which is a town right next to Farmington.
Were you still employed by 4 Group at this time?
Yes,
Why did you decide to go with her?
because she was my friend, and I trusted her, and I wanted to help her.
Did you ever talk to Mr. Dulos about your future with 4 Group?
Yeah, at that time, I've been working for 4 Group for a few years, and I just had no interest in it at all. And so I didn't see a future with 4 Group anymore.
Did you give your notice?
I did. It was going to be for the end of May.
I want to direct your attention now to April and May of 2017. Was Jennifer still living at 4 Jefferson Crossing?
Yes,
Was Mr. Dulos still living at 4 Jefferson Crossing?
yes.
Were they still sleeping in the same bedroom?
No.
Where were they sleeping?
Jennifer was in their master bedroom, and they had a 3rd floor office, but also bedroom. And so Fotis was up there.
Can you describe the dynamic between Mr. Dulos and Jennifer in April 2017?
It started to become very tense and uncomfortable being in the presence of both of them. They were arguing a lot. It was, again, just very uncomfortable.
Were you still working for 4 Group at this time?
I was.
You had mentioned that you witnessed arguments between Mr. Dulos and Jennifer.
Yes.
I want to direct your attention now to an argument that involved a piece of paper.
Mhm.
Can you describe for the jury what you saw between Jennifer and Mr. Dulos and their interaction?
Objection, Your Honor, prior bad acts relevant as to Michelle Troconis.
Well, could you describe what you saw? We don't know what the testimony is going to be. So the jury has heard testimony that there was a lot of arguing. That's not at the level of a prior bad act. We do not know what this testimony will be. The question is, can you describe what you saw? Overruled.
You may answer the question.
So one day I drove their family car often. It was a Suburban, and I was driving through their garage. There's kind of this like little, I don't know, I guess like bridge. There's a garage in the garage, and then you drive through. So I was driving through and pulling into the garage, and as I was doing that in the backyard patio, I saw Fotis kind of chasing Jennifer with this piece of paper.
Objection, Your Honor.
Ground.
Same grounds, Your Honor, prior bad acts related to Fotis Dulos relevant as to Michelle Troconis.
Well, the grounds has to be, you're stating 2 grounds. You're stating prior bad acts, and you're stating relevance.
Yes, Your Honor.
Overruled on relevance. Concerning prior bad acts, counsel, do you wish to be heard?
Well, Judge, I would just indicate that Matt, you'd proffer now if the court wants to do it at sidebar.
Well, prior bad acts are not admissible to prove action in conformity therewith on a particular occasion.
Absolutely. And that's, I'll tell the court that that's not the offer from the state. Obviously, everything that we are about to discuss as part of the offer yesterday goes to the tension in their marriage during that time period. So that's the purpose of this offer.
You wish to be heard, counsel?
Your Honor, this was heard outside the presence of the jury, and this is one of the things that we discussed, and my objections based on that.
Well, of course, prior bad acts are not admissible to show bad character, criminal tendencies, or propensity, but they are admissible to show other things. And so what are you offering it to show, counsel?
Your Honor, we're offering it to show Mr. Dulos' animus, the growing tension in their marriage, and what his intent and motivation was in this particular case.
So intent and malice are grounds on which prior bad acts can be admitted, unless the probative value is outweighed by the danger of unfair prejudice. What is your argument, counsel, on unfair prejudice?
Your Honor, these incidents that are going to be described and that are being described right now involve a very short period of time in 2017. The incident for which we are here today is one that is alleged to have occurred in 2019. the incidents that are being discussed here today involve marital discord involving yelling and disagreements in the context of an impending dissolution of marriage. The charges for which are being brought today involve a conspiracy murder.
So, in other words, your argument, counsel, here to the court is that these incidents are too remote in time to essentially give life to intent and malice.
And not similar in nature, Your Honor.
Well, at this point, the testimony is that Fotis was chasing around Jennifer with a piece of paper. So, the description of that act as a prior bad act is not evident to the court. Cross-examination is available on what chasing around means. So it's overruled.
Thank you.
I don't remember the exact question, but we were discussing an incident that you observed between Mr. Dulos and Jennifer involving a piece of paper.
Mhm.
Can you just describe to the jury what you saw?
So after I pulled into the garage, they saw me pull in and they both went inside. And so I had some of the kids in the car. I don't remember where we were coming back from, but we walked in through the garage to the mudroom, to the kitchen. And I just kind of like focused on the kids, getting them to where they needed to be. And it was later on that Jennifer told me what Fotis was saying.
Well, it was later on that Jennifer, and then the court did not hear the balance of the
Told me, Your Honor.
testimony. So if the objection is, well, first, the objection has to be timely. If it's not timely, you have to move to strike.
Your Honor, I heard Jennifer told me. It's a hearsay objection.
So if I may,
No,
Judge,
you object to the question, not the response. You can have the response stricken. What's the question, counsel?
well, the question was for her to describe what she had seen. I'm not claiming what counsel's objecting to, so perhaps I can just ask another question and we can move this objection out.
Okay, so the last sentence.
David, this
Jennifer
is the
told me,
nanny of
That's non-responsive to the question.
she
So
worked
the
she watched the
objection
kids because the wife had
essentially
custody of them
moves
and the
into
wife
a
is
narrative
dead.
That's not responsive. The court will strike that answer.
Thank you.
Don't tell me what Jennifer said to you about the interaction. I want
Okay.
you, though, to describe Jennifer's demeanor as you saw her being chased with a piece of paper.
She looked scared and worried.
And can you describe Mr. Dulos' demeanor for the jury during that same interaction?
He looked angry.
Did you ever witness Mr. Dulos make any threats about the children?
Yeah.
And did he make these threats in Jennifer's presence?
Yes,
What type of threat did he make to Jennifer?
that he would take the kids to Greece and not come back.
And did Jennifer ever express her fear to you that that would happen?
Yeah, a lot.
When was this threat made?
Throughout those couple months, so April, May 2017.
Did there come a time when Jennifer made a decision to leave for Jefferson Crossing?
Yes,
Did she ask for your help in doing so? Can
yes.
you describe for the jury what you did for Jennifer?
We were slowly moving things out of her Fort Jefferson house to a property that her parents owned in Pound Ridge, New York, and to a friend's house in Farmington.
I don't
Things
know,
that
Charlie. We
Fotis
might
would
just
really
do a
notice
normal
being
live
gone.
show tonight. I'm not sure.
Did she tell you why she believed she needed to secretly move out of the house?
Yes.
Oh, did she tell you? In other words, it calls for what Jennifer told her.
I
The
don't-
answer is yes or no. It's the next question that may run into the objection.
Did she tell you why she believed she needed to secretly move out of the house?
Yes,
What,
Objection, Your Honor.
Because the question is probably, what did she tell you? Objection is hearsay. Counsel.
yes, Your Honor, this is a statement of an existing belief under 8.3 subsection 4, and I do claim this.
Well, a statement of belief is not the same as a statement of then existing mental or emotional condition.
If I can be more specific, Your Honor, it's a statement of fear, which I think undoubtedly meets the hearsay exception.
So if the testimony is she was afraid, if that's the testimony, what's your response? Afraid of Fotis Dulos. What's your response?
Speculation, Your Honor.
The objection's overruled.
What did she tell you about why she felt she needed to secretly move out of the house?
because she was afraid of what Fotis would do to her or with the kids if she filed for divorce while they were living under the same roof.
During this time period where Jennifer was moving out of the home so secretly, can you describe her emotional state for the jury?
At first, she was really calm. So when she first found out about the affair, she was calm and she really wanted to try and make it work, which I thought was really good of her because I wouldn't have been that calm. But she was very calm. But then over the weeks from after we got back from that spring break until we left in June, she was increasingly getting more afraid. Like her anxiety was really bad. You could tell that she lost weight. Like she was just afraid and expressed that a lot.
And did there actually come a point in time when Jennifer was involved in a car accident?
Yes.
How did you become aware of the car accident?
Jennifer called me because she was in Pound Ridge where she was bringing stuff to the house that she was moving from Fort Jefferson. And she called me to tell me about the accident because she needed someone to come pick her up. And she didn't want Fotis to know because she didn't want Fotis to know that she was moving things into another house.
Describe her demeanor when you picked her up.
Like terrified, like shaking, like he's going to find out. She was really worried.
I want to direct your attention now to May 2017. Did there come a point in time when Mr. Dulos had family members visit Fort Jefferson Crossing?
Yes.
Who visited Fort Jefferson Crossing?
It was his niece, Clea, and her, I don't know if it was her boyfriend or fiance at the time, Nacho.
And where were they from?
They were living in Madrid,
You said Madrid.
I believe. Yeah, it was Spain, I think.
And while they were visiting, did you witness another argument between Mr. Dulos and Jennifer?
Yes.
Can you describe to the jury what happened?
I was in one of the kids'
Objection,
rooms.
Your Honor, same grounds.
Can you describe what happened? Not a hearsay objection overruled.
So I was in one of the kids' rooms and we were just doing a puzzle together where all of a sudden, like, we started to hear screaming and Jennifer ran through the bedroom door. I don't believe that she knew that we were in there, but she ran through the door. Fotis was yelling. I'm not sure what he was yelling. And she closed the door behind her and pushed her body up against the door. And he was trying to get in. And her face was just, she was terrified. And she saw that myself and her daughter were there. And to be honest, I kind of froze because I didn't know what to do. And then when he pushed the door more, he saw that his daughter and myself were in there and his demeanor totally changed. He went from yelling to like, Jennifer, I just want to talk, like very soft spoken. It was so weird. And so eventually he walked away because myself and her daughter were there. She told me she needed to get out of the house. And so she left me with the kids and she just got in the car and I think she just went down the street to really just like kind of catch her breath.
What we'll do at this point, because we started late with the jury, we will take our morning recess and come back in at 11:40. Please do not discuss the case.
Yes, David, this is a problem. Oh my God, their names. Yes. Fotis, Fotis.
All rise. This honorable superior court now stands in recess. You may exit the courtroom.
Yes, Fotis. He's from Turkey and he's of like Greek descent, I think. So that's why some of the kids are named Petros and all of that as well. So all right, we're going to catch ahead to, we're going to skip the break here. No breaks for us. No pee breaks. Got to hold it, guys. All right, here we go.
Your Honor, I'd like to be heard before the jury comes in.
Yes.
Your Honor, yesterday we had a hearing on a motion in limine, and it involved all of these alleged prior bad acts. And we had made arguments on it, and Your Honor had determined that we would address them as they came in. The purpose of having the hearing on the motion in limine is so that it did not need to be litigated in front of a jury each time one of these acts were proposed to be admitted and heard before the jury. I would move to strike the testimony that came in regarding the prior bad acts that came in already. I'd like to be heard about the fact that the ones that have come in are remote in time, do not go to intent. And if Your Honor has found that they are not too remote in time, and they do in fact go to intent 2 years later, that they are not relevant as to Michelle Troconis based on any evidence that's come in until now. Your Honor, if you are inclined to continue to allow this, I would ask at the end of direct that you give the court a limiting instruction.
What the court is not inclined to do is call the game before pitches are thrown. The court is not inclined to give a limiting instruction at this point because the pitches haven't been thrown. Motion denied. Bring the jury in, please. Counsel stipulate?
Yes, Judge.
Yes, sir.
Okay, thank you. The witness can be brought back in.
Yes, Judge. And just before we begin, I did indicate to the court at the break, I had transposed exhibits 14 and 15. 15 was actually 14 and 14 was 15. I apologize. I just want to make the members aware of that.
Thank you.
morning again.
Morning.
May I proceed, Your Honor?
Yes.
Ms. Almeida, you had indicated that you had driven the family's Chevy Suburban, is that right?
Yes.
How many vehicles did the Dulos family have in the spring of 2017?
So they had the Chevy Suburban. Fotis had a Porsche Cayenne. Jennifer had a Range Rover, and they had a Jeep, but I don't know if that was it was a Florida car. I don't know if it came to Farmington yet or not at that time.
I want to direct your attention now to the Porsche Cayenne.
I have a Florida car.
First of all, what type of
fancy.
vehicle is that?
Just, you know,
It's like a small SUV.
gotta get that pinky up.
And did you ever witness an argument between Jennifer and Mr. Dulos over the Porsche Cayenne?
Yes.
Can you describe that argument for the jury?
Objection, Your Honor.
Well, the question is, can you describe the argument over the Porsche Cayenne? What's the relevant, counsel?
So the relevance, Your Honor, is that once again, this goes to the antagonistic relationship that was developing between Mr. Dulos and Jennifer Dulos during those spring months of 2017. And specifically that this particular incident involved the Dulos children and the fact that Jennifer became greatly upset based on something that Mr. Dulos was doing.
Well, if this is testimony about what happened in 2017, every incident that occurred during the course of a strained marriage is cumulative. So at this point, the court is going to sustain the objection.
I want to direct your attention now to June 19, 2017. Can you tell the jury what happened that day?
That was the day that Jennifer planned for us to leave Fort Jefferson.
When you say Jennifer planned for us to leave Fort Jefferson, who are you referring to?
The 5 kids, Jennifer and I was helping her along.
Was Mr. Dulos aware that you were going to be leaving Fort Jefferson?
No.
What was the plan to leave Fort Jefferson without Mr. Dulos becoming aware?
The plan was she told him that we were all going to be visiting her father's grave and we were going to New York. We went to New York often because that's where Jennifer's parents were. And we left like that afternoon, I believe. And we just got in the car and the plan was to stay at a hotel that we've never stayed in before. So we stayed at the Mandarin Oriental in the city. And Jennifer hired an armed bodyguard to be outside of her room because she was afraid, because her plan was to file for divorce once we were in the city in the hotel.
Did you ever hear from Mr. Dulos on June 19, 2017?
Yes.
How did you hear from him?
He called me a bunch that evening.
Did you ever answer the phone?
No, I didn't.
Did he leave any voicemails?
Yes.
What did he say on the voicemail?
He accused me of kidnapping their kids and that he was going to call the police, which he did.
And how long did you stay at the hotel?
I stayed for like half a week, but they stayed for a full week.
Where did Jennifer end up residing after leaving Fort Jefferson Crossing?
She rented a home in New Canaan, Connecticut.
What was the address, if you recall?
153 Chichester Road, I believe.
So not 69 Wells Lane initially?
No.
Directing your attention now to approximately 8 days later, was there a family case pending between Mr. Dulos and Jennifer at that point?
Yeah.
And did you testify in the family case?
Yes, I did.
Was that in this building?
Yes.
Did you see Mr. Dulos in this building prior to testifying?
Yes, outside in the hallway.
Was he with anyone?
He was with his lawyers.
Did he approach you?
Yes.
Can you describe his demeanor as he approached you?
He came at me, yelling at me, again, accusing me of kidnapping his kids. And then I just walked away. And then he tried to approach me later with his lawyer in a different demeanor, just apologizing, saying that he's just really upset. But I just walked away.
And did you testify on Jennifer's behalf in the custody case?
Yes.
Going forward from June 27th, 2019, did you continue to work as a nanny for Jennifer?
Yes.
Hello.
June 27, 2009.
Sorry, strike that. Let me rephrase the question. June 27, 2017, did you continue to work as a nanny for Jennifer?
Yes.
And were you still working for Ford Group?
No.
Oh, Brandon.
Did your responsibilities change with the kids given the new location?
Yes. I think I became more.
Okay. So we need to answer this question. What did Fotis Dulos have to do with anything? He murdered Jennifer, and Michelle is accused of helping Fotis dispose of the body. So that's why it's important. They have to establish Fotis killed her. And then he called Michelle, and he's like, Michelle, you must help me cut up the body. And, because Michelle apparently doesn't speak English very well, she's Spanish. Probably sound like Sofia Vergara, like, oh, los míos, let me go choppy on the, tibia. Ay, ay, ay. So that's the argument, basically. Somi saying, isn't it prejudicial to include bad stuff someone else did? Yes, but she's being charged with the conspiracy to commit murder. So when there's a conspiracy to commit murder, you're showing there's a conspiracy to commit that murder. That's an actual argument you have to show. Now, all this stuff, the Fotis and Jennifer and their marital struggle, yeah, that becomes prior bad acts, but the actual bad act of killing her, like, she came over right after that and helped chop it up. So, so yeah, that part's important there. But yes, this other stuff is prejudicial, but they're allowing some of it. I mean, like, oh, he chased her with a piece of paper. Well, that's not scary. Some of this isn't too scary yet.
Chased her with a piece of paper. I missed that.
Yeah.
Okay.
So.
Also, did you see that Nancy Grace was playing a little piece of the interrogation of the defendant?
No.
And yeah, okay, I'll find it for you. And the whole thing about her not being able to speak English very well, really, that it's not fair the way it's being portrayed. So I might just send you a link.
That's fine, and I think we'll see at some point in her interview, which I'm curious. Like I said, I'm very curious to see it because I'm curious to see how well her, as my people would say, how well she can habla anglais. So
exactly, not very well. I don't.
We'll see. We'll see. All right, here we go.
Or it was only myself and Jennifer. So there was no other babysitters or anything, other than she met some people in her time in New Canaan. So there'd be a babysitter on a day I couldn't go, or she needed an extra hand. But it was mostly just Jennifer and I. So my responsibilities became more.
And were you ever tasked with the responsibility of dropping the children off at Fort Jefferson Crossing for visitation with Mr. Dulos?
Yes, I was in the beginning.
Approximately for how long were you tasked with that responsibility?
Just a few times, and I told Jennifer that I no longer wanted to do it.
I want to direct your attention now to September 20th, 2017. Did you drop the children off at Fort Jefferson Crossing that day?
Yes.
Did you see Mr. Dulos on that day?
Yes.
Did Mr. Dulos approach you on that day?
Yes.
Can you describe his demeanor when he approached you?
He was angry and yelled at me, and again is accusing me of kidnapping his kids and telling me that the only reason why I was there for Jennifer was because she paid off my student loan, which is an absolute lie, and that he was going to make sure that I never see his kids again, but yelling in front of the kids. So it was very uncomfortable.
Did you ever do a drop off with the children again?
After that time, no. I told her I no longer wanted to be around him.
Did Jennifer and Mr. Dulos ever officially finalize their divorce?
No, they did not.
Was their divorce ongoing in May of 2019?
Yes.
In May of 2019, how often was Mr. Dulos permitted to see his children?
He had supervised visitations, so he had to have someone from the court along with his visitations, which was every Wednesday for a few hours. And with that visitation, it needed to be agreed upon with the supervisor and Jennifer through something I believe was called the family wizard, for them to communicate, because they no longer could communicate through text or through phone. Everything.
Okay, so real quick, family wizard. There is a messaging app. It's called Our Family Wizard. This is used in family courts and domestic relations courts. It is a messaging app that you cannot delete the messages on. It's a messaging app that courts have access to, and that attorneys can access it too, as part of, if there's hearings going on, like, and parties are communicating, well, you really get to see who's doing what. So, for example, Fotis and Jennifer should be using that to communicate about the children, and that's the exclusive way they should. That way it's shown what's going on. It's a very effective tool. So when she's talking about this messaging app, that's what she's referring to. I just want to make sure people are aware of that.
Never heard of such a thing. Very cool.
Yeah.
Needed to be recorded. So it was supervised visitations once a week.
I want to direct your attention now to the week of May 20th, 2019.
Mm-hmm.
Were you working as a nanny for Jennifer during that week?
Yes.
And I want to begin with May 21st, Tuesday of 2019.
Okay.
Where were Jennifer and the children living at that point?
So they now have moved to 69 Wells Lane in New Canaan.
Did Jennifer own that home?
No, she was renting.
In addition to yourself as the nanny, Were there any other individuals who were frequently in the home besides the family itself?
There was a cleaning person that would come often. Her name was Edie. I don't know if it was like once or twice a week.
And how often were you working for Jennifer in May of 2019?
So the weekends were less, but it was usually Monday through Thursday and Sunday most of the time. But I would always have Friday and Saturdays off.
Had you had any contact with Mr. Dulos from September 2017 until May of 2019?
He was emailing me back and forth.
But other than that,
No contact.
how did you typically get into the house at 69 Wells Lane?
So they had a 3-car garage, and I would enter through the middle because they had a keypad, and that's what the keypad would open. And I would enter through the garage, and then there was a door that led to the mudroom, and that's how I would get in the house.
What types of vehicles did Jennifer own?
So she had a Suburban and she had a Range Rover.
Where would she typically keep the Suburban and the Range Rover?
So the Suburban was on the left side of the garage, and in the middle was the Range Rover. And then the third and last bay was, we had a bunch of shelves for sporting equipment and the garbage can, so that was typically left open.
Are you familiar with something known as WeatherTech lining?
I think that's like a Suburban or line your cars with. Maybe not. I don't know. I think yes.
Well, let me ask it this way. Did Jennifer have lining in her Suburban?
Yes.
Where was the lining?
It was in the car, so it was like the mats and then the trunk because the kids would throw their sports stuff in there all the time. So it was like, I think a way to protect the car.
And had you actually seen the lining in the trunk of the Suburban?
Yeah, it never came out of the car unless she brought it to a car wash and they took it out to clean it, but they always put it back in.
What type of material was this made out of?
Like rubber.
When you would enter through the garage, you indicated that you accessed a mudroom. Is that correct?
Yes.
Was the door to the mudroom ever locked?
No, that was kept open.
When would it be locked?
The door leading into the garage,
Yes.
that door was never really kept locked. It was kind of just open.
Now, I want to direct your attention to that day, Tuesday, May 21st, 2019. Was there a basketball hoop being installed at the residence?
Yeah, so the boys got a basketball hoop as a gift from their grandmother. So they were getting it installed in their driveway. It was one that you had to dig a hole for it and put it in that way.
And were you present when that was taking place, the basketball hoop being built?
No, I showed up after. So it happened earlier that morning.
Did you have a conversation with Jennifer about the garage that day?
Yeah, so she went to show me the basketball hoop because she was like really proud of it. So we were on our way outside and just in passing, she's like, this is a mess.
Objection, Your Honor, hearsay.
So the hearsay came in at the end of the question. What is the question?
Whether or not you had a conversation with Jennifer about the garage?
So the answer was yes. And then the response was, she said, hearsay.
Well, my response, Your Honor, is that I'm not offering this for the truth of the matter asserted, and so I'm not offering it for a hearsay purpose. It's meant to explain why this witness took subsequent action in the garage.
The counsel approach, please.
He's pushing it. Trying to use that hearsay statement there. I'm impressed the judge is not letting us hear this one, but yeah, he's like, okay. Obviously, he's using it to get it in, but he's trying to get it in without actually claiming to use it.
He's very good.
Well,
The
I
judge
mean,
has got him.
yeah, well, the judge is very good about not letting things get past him, so I'm curious to see how he's going to handle this one.
Hmm.
So we're going to...
What did Jennifer say about the garage?
She said the garage was a mess and that was it. So I decided to clean it that day.
What area of the garage did you clean?
I cleaned that third open bay that had all their sports equipment in it.
And how did you clean the area?
I guess it was just more like organizing the shelves and organizing what was on the floor and just putting things in certain spots.
Were there any cleaning supplies in the garage?
Yeah, there was a bucket of cleaning supplies.
What color was the bucket?
To be honest, I don't remember. I believe it to be white or red.
Can you describe the bucket for the jury? I mean, is it one of these 5-gallon buckets or?
Yeah, it was one like, I guess it's 5 gallon. I don't know. But it would just have things like Windex and cleaning solutions, sponges, things like that, that the cleaner would use, like grab on into when she would enter the house to clean the rest of the house.
And while you were cleaning the garage, did you notice any camping pillows?
Yeah, so the kids would go on a day-night trip with their school where they had to bring camping supplies, like a camping pillow and sleeping bag. So I kind of put that in the corner. That just kind of lived in the garage.
So the camping pillows were in the garage?
Yes.
I want to direct your attention now to the next day, Wednesday, May 22nd, 2019. Were you working that day?
Yes.
And what time did you arrive at work?
I usually arrive around 12-ish. It depends. Sometimes I come in earlier.
Do you remember what you did upon your arrival at work that day?
On Wednesday? Well, Jennifer, there was a visitation that day. So I usually go to the house first and kind of like pick up after the kids or their rooms and stuff. So probably like make the beds.
You mentioned there was a visitation that day. Who had visitation?
Fotis had visitation.
And what time would Fotis arrive for visitation?
4:30.
And what time did he arrive on this day?
This day he arrived at 4.
Was this unusual?
Unbelievably unusual. Fotis was notoriously late to everything, including supervised visitation.
Did you see him arrive at the house?
I didn't see him arrive at the house until Jennifer noticed him through the window because he pulled in up the driveway, and part of their agreement was that he had to wait at the bottom of the driveway for the supervisor to arrive, and then together they would drive up the driveway and get the kids for the supervised visit. So it was strange that he drove his car all the way up the driveway with nobody noticing. So Jennifer saw that he came down and got me and said, she just said, I'm gonna go talk to him and see what's going on. And he said he was confused. And so he just went back down the driveway and waited for the supervisor to arrive.
Now, at some point, did you leave did you leave 69 Wells Lane?
Yeah.
Why did you leave 69 Wells Lane?
I didn't want to be around Fotis.
So what did you do?
I went into town with one of the kids. I think we grabbed lunch. I believe she had, they did horseback riding. And so we were going to that right after. So we just grabbed something to eat and then I took her to where she needed to be.
And how long did that last where you took her out to, what was it again?
I think it was horseback riding.
How long did that last?
It's usually, I believe it was like an hour and a half or so.
And at some point, did you message with Jennifer?
Yes.
And what was the purpose of messaging with Jennifer?
I wanted to make sure that Fotis left the house before I came back. So she was just letting me know if he'd left or not.
If I can have this marked, Your Honor. Judge, this has been marked by Madam Clerk as State's Exhibit 16. We did have an opportunity to show Attorney Nelson what was on State 16 yesterday. I don't present objection.
State 16 will be admitted as a full exhibit.
So, Maida, there is a gigantic TV behind you
Yep.
that we're going to turn on and we're going to show you some things.
Okay.
Is Your Honor's TV on?
Yes.
So within State's Exhibit 16, there is a file entitled Number 1, Text with Jennifer. I'm just going to ask if my colleague can pull that up. And we're displaying page 1 of Text with Jennifer at this point. Ms. Almeida, do you recognize this text message exchange?
Yeah.
Well, firstly, can you just explain to the jury what this is?
These are texts between Jennifer and I that Wednesday, going back and forth on what to do that evening of Wednesday, because I was just checking in to see if Fotis was there and how I could essentially waste time if he was still there, so I didn't have to be at the house.
And were these screenshots that were taken from your cellular phone at the time?
Yes.
And did you provide those screenshots to police?
Yes.
And many of us have iPhones, but just for the record, is this an iPhone text message exchange?
Yeah, so I was in the blue and Jennifer was in the white.
And so Jennifer writes, Fotis is still here. I know you're going to do Noel's braids. Petros is picked up by 8:30. I think he should wrap it up, ... I'll let you know when he goes. And Jennifer wrote that to you?
Yes.
And what is the message about Noel's braids and Petros being picked up? Can you explain to the jury what she meant by that?
Yeah, Noelle she had like a colony day or something at school, so she had a little outfit and she had a dress and she just wanted to wear braids. And Jennifer had many talents, but hair was not one of them. So I did her hair the night before. And Petros was at lacrosse, so it was a practice to get picked up from.
And you write, I'll just go out and gas to waste some time.
Yeah.
And you continue, Constantine wants Dunkin'. I assume that means Dunkin' Donuts.
Yes, that does.
So maybe we do that, get gas, and then get Petros. And then she replies, okay, great, but he left so you can bring him home. Is that right?
Yep.
So she was letting you know that it was okay to return?
Yes.
Now, did there come a point in time where Fotis actually returned to 69 Wells Lane on May 22nd?
Was that Wednesday?
Yes.
Yes, actually, in between his visit or during his visit. Yes.
And were these text messages before or after he returned?
I think it was after. I'd have to look at the time. I believe it was after.
Okay. Did there come a point in time where Mr. Dulos ate dinner on the back patio of 69 Wells Lane?
Yes.
Objection, Your Honor.
Right.
Personal knowledge.
Well, we do not know. if this witness was there. So that predicate question can be asked.
Let me ask it this way. Did you become aware that Mr. Dulos was going to be returning to 69 Wells Lane to have dinner?
Yes,
How did you become aware of that?
because Jennifer talked about it.
Same objection.
Well, did you become aware that the Dulos was going to go back to 69 Wells Lane to have dinner? Response, yes. How did you become aware of that? Because Jennifer told you.
I'm sorry, Mr. Cole.
Because Jennifer told you.
Yes.
And the objection is essentially hearsay.
Yes, sir.
Overruled.
Jennifer told you this in person?
Yes.
And when would she have told you this in person? Was it after you had taken Noel or?
Yeah, it was when I dropped Noel off, and then by that time he had left with the kids. And so I went back to the house, and I was then taking Constantine to his lacrosse practice. So it was in between that time before I left with Constantine, or to go, yeah, his practice.
Did you and Jennifer do anything to prepare for Mr. Dulos' visit?
Yes,
What did you do?
we locked all the doors
Why did you lock the doors?
because she did not want him entering the house at all. And in their living room at 69 Wells, it was all opened windows with doors, and so you could enter. And so we made sure all of those, including the mudroom door, was all locked.
And after you assisted her in locking the doors, what did you do next?
She, we were preparing the food that was going to be eaten on the patio. That way they didn't need anything coming in. So they had all the cups, utensils, napkins, plates, everything was out there on the patio.
The food as well, or that came later?
No, the food as well, because he came with the food and gave it to Jennifer. And so she had it in the fridge. So we just put it out.
Now, I want to direct your attention now to May 23rd, 2019, which is the next day.
Mhm.
Did you work that day?
Yes.
What types of things did you do at work that day?
I don't remember exactly, but I'm sure the kids had practice or horseback riding or something. I usually pick the kids up from school, or I'll pick Noelle and the other 4 kids. They had different times in which they were out of school. So I would usually or Jennifer would hang out with Noelle until the other kids were picked up. And I would also cook dinner, and I did like tidying when the cleaner wasn't there. I did the tidying around the house.
So let me sharpen my question a little bit. Did you do something with paper towels?
Yes.
Okay. Can you tell the jury what you did with paper towels?
Yeah, so we buy in bulk, and so we were running out of paper towels that we keep in the pantry. And so I went down in the basement to get a 12-pack of paper towels, and I unloaded it in the pantry before I left that evening.
Where's the pantry located at 69 Wells Lane?
It was to the left of the kitchen.
And did you have any conversations with Jennifer about what she would be doing the next day?
Yes.
Were you going to be working that Friday?
Yes.
And specifically Friday, May 24th, 2019?
Yes.
Why were you going to be working that Friday if you didn't ordinarily work on Fridays?
So she asked me originally to maybe stay over on Thursday night because she had appointments in New York City to go to. She still kept her doctors here, and she had an early morning appointment on Friday. And so doing overnights was something that I would often do. It wasn't abnormal. And so the plan was for me to spend the night Thursday and then be there Friday. And I was going to take 4 of the kids and drive them up to New York to meet Jennifer at her mom's because they had an orthodontist appointment that was also located in the city.
When you say the city, you're referring
To New York City.
Manhattan.
Yeah, Manhattan.
And where did the children attend school?
New Canaan Country Day.
And you may have said this, I apologize, but what time were you supposed to be picking them up on Friday, May 24th?
So on Friday, I was picking them up like 12:15, 12:30. They had a half day that day, which they usually don't. It's usually they have half days, but it's on Wednesdays. But that day it was on a Friday.
On May 23rd, did Jennifer tell you which vehicle she planned to take to the city the next day?
Yeah. So ultimately, she decided that she was just going to spend the night Thursday, so I didn't need to sleep over. And she told me she was going to take the Range Rover because she'd only have 4 of the kids, and the Suburban is very difficult to park in Manhattan.
What time did you leave on May 23rd?
So I picked them up, and we came back to the house to have Subway sandwiches that I bought them. And I think
I'm sorry, on May 23rd.
I was May 23rd. Sorry. I left my usual time, probably like around 9ish.
Directing your attention now to Friday, May 24th, 2019. Did you receive any text messages from Jennifer's phone on the morning of May 24th?
Yeah.
I'm just going to ask that we call. Sorry. And actually, I'm just going to just before we get to there, I want to just button up. Okay, can you, those are difficult. This is where we, I think, left off. If we can just continue on to the next page. This is page 2 of folder 1, text message from Jennifer. So this is now page 2. And directing your attention to Wednesday, May 22nd at approximately 4:59 p.m. You indicated okay to come back. She responds, yes, we'll be back about 6:15, 6:20. I'll explain. And you responded, okay. Was that in between when you took Noelle and then returned to take Constantine to practice?
Yes.
Now, directing your attention to page 3, you had indicated to the jury that you had received text messages from Jennifer's phone in the morning. And I want to just direct you to the top, Friday, May 24th at 7:14 a.m. Can you just indicate to the jury what she wrote to you?
Yeah, she said I took Instagram off so he could use it for a car ride. Petros's iPad is in my bathroom. Petros is bringing Lexic. He has to bring home.
And so, first of all, just for the record, what is Instagram?
Well, social media app.
And who had Instagram?
Petros had it when he was not allowed to have it because he downloaded it.
Okay. And so when she's saying I took Instagram off, she's referring to some tablet or computer that
Yes.
Petros had?
Yes.
Okay. And she's indicating he's allowed to have it now?
Yes.
Okay. And what does this mean? Petros is bringing lax sticks he has to bring home.
Yeah, so Petros played lacrosse, so he was bringing the lacrosse stick to school because I think he was playing after school.
So you received these messages in the morning.
Mhm.
What time did you arrive at 69 Wells Lane that day?
I got there, I think it was close to 11.
When you say 11 in the morning,
11 in the morning, yeah.
how did you get there?
I drove my car.
Did you make any stops prior to getting to 69 Wells Lane?
Yes.
Where did you stop?
I stopped at the restaurant chain Subway to get sandwiches for everybody.
And when you got to 69 Wells Lane, how did you enter the home?
Like I always do. So I typed in the code to the middle garage and went through the middle bay.
And then through the mudroom door?
Yes, and through the mudroom door.
Did you notice anything unusual when you went to the garage?
When I went into the garage, yes, the Range Rover was still there and the Suburban was gone when she told me she would be taking the Range Rover.
Did you see any blood-like substances in the garage or on the floor?
No.
After you walked in the garage, where did you go?
So I enter through the mudroom and I usually put my stuff. She had these cubbies and I put my stuff in the cubby and then I go to the kitchen. So I went in the kitchen.
When you got to the kitchen, did you notice anything unusual?
A couple things, yes.
Tell the jury what you noticed.
So first, her purse was on the floor. It was between the mudroom and the kitchen, like the doorway. It was a big, like, structured purse. And I thought it was just a little odd because it was a really nice handbag and it was on the floor. But I didn't look in the bag, so I just kind of figured she took her phone and her wallet with her to New York. And then when I entered the kitchen, she always had a tea, like in a certain cup with her, and a granola bar. She ate it every morning. It was just part of her routine, and it was there. The tea was still full, and the granola bar was still there. So I thought it was a little strange, but I just figured she was in a rush because I knew she had to get to the city. So I just cleaned the cup of tea and I put the granola bar away.
As you were cleaning the cup of tea, did you notice the paper towel roll on the countertop near the sink?
Yeah, so the paper towel roll was empty, so I went in the pantry to go grab another one.
Cup of tea.
And noticed that there were only 2 rolls of paper towels left, which was odd to me because the night before I just put 12 rolls in there. But again, I thought maybe the kids spilled something and they used a lot of paper towels.
They use 10 rolls in a day.
Yeah, so
Yeah,
usually I would go
that's
in
a
and
lot
I'd
of
go in the
paper
kitchen and, like,
towels.
fix up their beds or put away some clothes.
A lot of
and then after
brawny.
I left to pick the kids up from school.
Well, it's also a lot of kids.
I think it was around 12:30.
It's a lot of snacks.
12:30.
And where did you pick them up?
A New Canaan Country Day.
That's $3,000 worth of towels, guys.
I picked up Petros, Theodore, Constantine, and Noel because Krishan was going to go home on the bus with a friend.
One
and
of
spend
them might have had
afternoon
the
there, and
runs.
she didn't need to go to the orthodontist.
Where did
It's
you
a
take
lot
the
of reddish
children?
brown stains.
So we went out to 69 Wells and had lunch.
Did you notice any blood-like substances inside the home while you were having lunch or prior to picking up the children?
No.
Approximately how long did it take to eat lunch?
Like 20-ish minutes. We were pretty fast.
After you were finished eating lunch, what did you do?
The kids went and got their iPads for the car ride, and I just cleaned up quickly, put everything away, and then I texted Jennifer because Noelle couldn't find hers, and so I asked. We had a family iPad, and so I asked if she could take that instead. And then we got in the car and headed to New York.
Did Jennifer respond to your text message?
No.
So what did you decide to do without her having responded?
I just took the iPad. It was a long car ride.
During the car ride, did you try to communicate with Jennifer?
So right before we left the driveway, I texted her our ETA and that we would be at Gloria's, and then I just started driving, and then I texted her when we got to Gloria's.
Did you ever try to call Jennifer?
Yes, after we got to Gloria's around 2:30, and she wasn't there. And I was supposed to meet Jennifer at Gloria's. I wasn't supposed to go to the orthodontist. I was going to be heading back home, but she wasn't there. And so I called her around 4 o'clock.
And when you say Gloria, just to refresh everyone's memory, Gloria is Jennifer's mom, is that correct?
Yes.
And she resides in Manhattan?
Yes.
And she has an apartment in Manhattan?
Yes.
And that's where you were supposed to meet Jennifer?
Yep.
Had Jennifer replied to either of your text messages
No.
prior to trying to call her?
No, none of them.
If I can just pull those up. So beginning Friday, May 24th at 12:43 p.m. Hello, we're home and eating. Noelle can't find her iPad. Is it okay to take the iPod? Is it okay to take the iPad? And she does not respond, correct?
Yeah.
And then you texted her again, leaving now. ETA is 2:30. And she does not respond, correct?
Yes.
And at 2:30 exactly, you just got to Gloria's. Approximately how long after sending that text message, did you try to call Jennifer?
I don't remember. I think it was close to that other text message, but we meet you at the dentist.
And why did you send that message?
Because I hadn't heard from her. So I didn't know if I was going to, I've been to their orthodontist. It says dentist, but it was orthodontist. I've been to the orthodontist before, so I knew where it was and I brought them. So maybe I was going to meet there because maybe her appointments ran longer. I didn't know.
Did you go to the orthodontist with the children?
Yes, I did.
How did you get there?
We took a taxi.
Did Jennifer meet you at the orthodontist?
No, she didn't.
How were you feeling at this time?
Really bad. The second I called Jennifer, it's like my stomach just sank because she never not answered her phone. So I was really hopeful that she just got caught up with meetings and she was going to be there. And so when she wasn't there, I just came in, I was shocked, but also like, okay, I have the 4 kids in front of me. I don't know what to do. So I just put them into their appointments and I I just walked outside and I started to call people that could have heard from Jennifer.
Who did you call?
Well, I called my mom, who was trying to calm me down and tell me all these things that I needed to call the hospitals because maybe she was in a car accident. And then I called her friends.
And based on those conversations, what did you do next?
Based on those conversations, I got the kids, they finished their appointment. I got them in the cab and I had Noelle bring Jennifer's iPad, her family iPad, but it was connected to her Google and her Apple ID. And so I decided to bring the kids back to their grandmother's. I went in the cab and I went to her appointment because I was able to pull up her Google Calendar and what appointment she had that day. So I went to one of her appointments.
And were you able to make contact with someone at the appointment or at the location of the appointment, I should say?
Yeah, they were able to tell me, I just needed to know if she made it and they were able to tell me that she didn't.
What did you do next?
I called her friends again, letting them know what was happening. And then I decided to take a cab back to Gloria's. And it was from there that myself and Jennifer's friend Laurel called the police.
Which police department did you call?
New Canaan.
Excuse me. And what information did you give to the police?
What information did this witness give to the police? Overrule. Overrule.
Excuse me, Your Honor, I apologize. You can answer the question.
We told the police that a mother of 5 was missing and that she was in a very contentious divorce. And I knew that he had purchased a gun, and so I was afraid. And they were on it right away.
I don't claim that part.
Ladies and gentlemen of the jury, the portion of the testimony that this witness knew Fotis Dulos purchased a gun is stricken. You may not consider it for any reason.
Yes, don't consider it for any reason, but we're telling you about it.
Did you ever receive any communications from Mr. Dulos that night?
Yes.
What type of
I
communication?
hate that when they get
He
that
called
crap
me in the
in.
evening.
And did you answer the phone?
No.
Why not?
I was afraid.
Did you eventually speak with him?
Yes.
And can you describe that conversation for the jury?
Yeah. So he called me and I called the police because I wasn't sure what to do. And they told me that he's not a suspect, so you should talk to him because I have his kids. And so I decided just to call him back because I didn't want to anticipate waiting for the phone call. And so I spoke to him and it was a very weird conversation. He asked how the kids were doing, but didn't talk about Jennifer or really what was going on, just saying, oh, this is really weird. And immediately went into that he had a supervised visitation that Saturday. I think because it was Memorial Day weekend, so he had a day, it was a special thing, and that I needed to make sure that I left New York early enough that I got the kids to him to New Canaan for his supervised visit.
Whoops,
And he
I
was
didn't know
very
I got.
adamant, Lauren, you have to make sure that they're
myself.
there. They need me. You need to bring them to me. Be early. And then the conversation ended.
I just did a Sean and started talking when I was muted.
And did you also exchange text messages? with Mr.
Welcome
Dulos
to
that
the
night?
club.
Yeah.
If I could just pull them up, that's folder 2.
I really did take over your stream then. I was like,
And once again, were these screenshots from your phone that you shared with the police department?
Yes.
And you indicated to Mr. Dulos at 9:49 p.m. on May 24th, hello, no updates so far. Laurel's at the police station right now, keeping me updated, but they don't have anything yet. They looked around the house, but it all seemed fine. I'm trying to get the kids to get some sleep. You sent that message, correct?
Yes.
All right. And his phone responded, okay, thank you. Please call me first thing in the morning. And then you responded, yes, I will. If I hear anything tonight, I'll let you know. Is that correct?
Yes.
And he responds, okay. other than the phone conversation that you had with him on May 24th that you've already described to the jury, was your additional communication with Mr. Dulos done strictly through text message?
I didn't have any at that time other than that evening. I didn't talk to Fotis at all.
Well, I'm referring to these messages here that
Yeah.
we're seeing. This was after your telephone conversation, with him, correct?
Yeah, it was only through text messaging.
And if we just continue on to Friday, May 24th at 11:38 p.m., he asked you still up any news, and you responded, no news. They're still searching though. Got kids to sleep. Is that correct?
Yep.
Continuing on. And then, I'm sorry, can you scroll just there? Okay. Looks like there's part of the message that's cut off. It says, thank you. Are they okay? Are they worried? And you responded, they're doing okay. They're worried, but I'm trying to just keep them updated as much as I can, keep them D's. I'm happy they got to bed. So presumably the children had fallen asleep at this point.
I think I was referring to the night before that they got to sleep.
Okay. And then he responds, okay, I will see you guys tomorrow. And you respond, okay, good night. Is that right?
Yeah.
Okay. So when he says see you tomorrow, he's referring to Saturday, May 25th, correct?
Yes.
And that was for his visitation?
Yes.
Were you intending on bringing the children for visitation?
No.
Why not?
I was afraid and I wanted to keep the kids with myself and Gloria.
Now, on Saturday, May 25th at 5:39 a.m., he texts you GM, which I assume stands for good morning.
Yeah.
Lauren, any news? And you replied, called them at 2:30 and 5:30. No news. They just told me that they're still searching. And he replies, I spoke to an officer at 1 a.m. as well. Is that correct?
Yep.
And then at 10 a.m., he texts you GM Lauren, again, driving down to NC, which I assume stands for New Canaan.
Yeah.
And then he continues, spoke to Officer Patton. He had no update. How are the children? And you respond, children are doing well, just ate breakfast. And then he asks, are you guys?
Makes the answer is yes, but we'll get to this. I'm going to save this
Yes.
question for a break.
Did you indicate one way or the other whether or not you were driving to New Canaan?
No.
Directing your attention now to the next page. The title is Fotis New Phone. At some point, had he reached out to you from a different phone number
Yes.
and you programmed it in as Fotis New Phone?
Yes.
And so this is him with, I guess, the initial reach out saying, Lauren, it's Fotis. How are the children doing?
Yep.
And you said kids are doing okay, getting ready to sleep. He responds, okay, any updates? You said no, not yet. Is that right?
Yeah.
Directing your attention now to Sunday, May 26th at 10:59 a.m. Fotis Dulos' new phone texts you, GM Lauren, how are the children? You respond, they're doing fine. And he asks, is Christiane with you or is she still with friends? And you replied, she's with us. Christiane was the child that you had mentioned you had a sleepover. Is that correct?
Yeah.
And how did Christiane come to be with you if she was in New Canaan
Jennifer's friends picked her up.
and brought her to Gloria's?
Yeah.
And then he asked, okay, good. Somebody brought her to you. And you replied, yes. He asked, is she okay? You respond, all are fine. He says, okay, thanks. Any update on Jennifer? You didn't respond to that message. Why not?
I just didn't want to.
Now, on Sunday, May 26th, did you see Mr. Dulos in New York?
Yes.
Where did you see him in New York?
He came to Gloria's apartment in Manhattan
How did you see him?
through the window. We saw his car pull up.
And were the police called?
Yes, they were.
Which department responded?
I think it was some precinct, but I don't remember.
The New York Police Department?
Yeah, it was a New York Police Department.
And did you speak with the police?
No, I didn't. Well, in the original phone call to the police.
No, I'm referring to the NYPD.
Oh, when they came to the house, I spoke to them.
Okay, in Gloria's apartment?
Yes.
And did Mr. Dulos ever see the children in your presence that day?
No.
Did there come a point in time when you were asked to review photographs of the garage at 69 Wells Lane?
Yes.
Can you tell the jury when that was?
It was, I believe it was that weekend in Gloria's apartment. The New Canaan police, they came to New York to meet with me and show me pictures.
And I'm just going to show, these were pictures that were taken by the police department. Is that right, Ms. Almeida?
Yes.
So this is, for the record, this is within State's Exhibit 16. Specifically, this is item number 3. What are we looking at here?
So this would be like where the open bay was, where all their sports stuff was. This shelf in particular was where I kept like their camping stuff and their guns and stuff like that.
Okay. And you had indicated that on Tuesday, May 21st, you had cleaned the garage.
Yes.
Is there anything not visible in this photo that was visible to you on the 21st in this location?
Yeah.
Can you tell the jury what that is?
Those were the camping pillows that they had for their trips.
And where would they have been in this photograph?
They would have been next to the sleeping bags on that second shelf.
Okay. So, and just for the record, there is a shelf and there's 2 sleeping bags underneath on the second level, and they would have been next to those.
Yes.
And if we could pull up item number 4. What color were the camping pillows?
They were white.
I'm sorry, I interrupted you.
They were white.
So what are we looking at here in item number 4 on that disc?
So these are just more shelves in that third bay where we kept like their sports equipment and stuff.
And is there anything not visible in this exhibit that you had seen on the 21st?
Yeah, there was a cleaning bucket that I put on that third shelf, so on the bottom.
And was this the cleaning bucket that you described earlier, the red or white bucket?
Yes.
And directing your attention to the sponge in the photograph, was that on the floor when you cleaned the garage on May 21st, 2019?
No, it was in the cleaning bucket.
Now, did there come a point in time where you and the children were asked to provide DNA samples to the state police as well as fingerprints?
Yes.
Do you recall approximately when that was?
I would say it was like a week or so after we all went to New Canaan. They had an event at their school that day because they didn't go back to school. We stayed in New York this whole time. But we went to New Canaan so they could be a part of this event and then went to the police station to give our fingerprints and DNA.
And have you continued to be the nanny for the Dulos children since May 24, 2019 to the present day?
Yes.
And I think you indicated yesterday that you still live with them?
Yep.
Are you their primary caregiver?
Gloria is their primary caregiver, their grandmother.
Have you seen Jennifer Dulos since May 23rd, 2019?
Yes, she has.
Have
Oh,
you heard from Jennifer Dulos since those text messages that we saw earlier on May 24th, 2019?
No.
Accept the moment, Ron. I have nothing additional.
isn't it interesting that you're one of the last people to see her live? How do you know How do you know you didn't do it?
Oh, I'm booming. It usually is. What is it with this channel?
What's
Good morning, Ms.
wrong?
Almeida.
Morning.
It's actually afternoon. Good afternoon.
Good afternoon.
I don't
So you
usually
started working
boom
for
up.
the Dulos family in 2012?
Yep.
And then you started working for 4 Group in 2013?
Yes.
And that was Fotis's company?
Yes.
Fotis hired you?
Yes.
And the company consisted of home construction?
Yes.
And you worked there in the mornings, either 8:30, 9 o'clock?
Yep.
Until about 2 o'clock?
Yeah. Depending on when the kids came out of school.
And during the weekday?
During the weekday. Yeah.
And after that, you went to work caring for the Dulos children?
Yes.
The work that you did for Fotis, for 4 Group, at first was administrative work?
Yeah.
You'd go to the bank?
Yep.
Sometimes run errands?
Yep.
And at some point, I think you said it came to you doing some punch lists?
Yep.
And that involved you going to people's houses?
Mhm.
Where you would look at some things that were left undone
Yes.
or needed to be fixed?
Yes.
And sometimes you would be responsible for fixing them?
No, not myself.
Okay.
I would be responsible for getting the right person to fix.
And was Pavel Gumieni one of those people who would help you fix those things?
Yeah, but it was mostly like the subcontractors. Like if it was something with the painter would need to come back in. If it was something with the roofer would need to come back.
Did Pavel ever go with you?
Yeah.
Pavel worked for 4 Group?
Yeah.
Pavel was an employee of 4 Group before you had gotten there in 2013?
Yeah.
And you left in 2017?
Yep.
Pavel still worked for 4 Group after you left?
Yeah.
Hmm.
And when you weren't going to houses to look at what needed to be done or running.
Remember, guys, we're doing this at like 1.5
Yes.
times
The
because
office
it's
was at
slow.
Fort Jefferson.
Yes.
And that's also the Dulos home.
Yeah.
So the office was in the home.
But she must be fast talker already though, because
Can you call up what?
Yeah,
the
she is a little bit,
attendance
but-
C, I believe there's no objection, Your Honor.
You guys are thinking it's too fast?
Yep.
We'll tone it down a hair.
all right, I'm gonna have to jump, Sean. Unfortunately.
Guys, hella excited utterances, and thank you for stopping in.
Thank you very much. I'll see you guys
Just a
later.
moment, please, Your Honor.
Have a great
Yes.
day.
Bye.
See you.
Hold on just 1 second. What the heck happened here?
I have no objection to what she's.
Sorry, guys.
Defense exhibit C, D, and E. and F and G. So with that,
So is the offer for all of those at this time?
Yes,
C,
Your-
D, E, F, and G?
yes, Your Honor.
So defense C, D, E, F, G admitted as full.
Can you call it, what's number one on yours? And Ms. Almeida, if you could turn around, is this for Jefferson?
Yes.
And the office, can you show, do you mind getting up? Can you show the jury where the
That's a
the
nice
office
house.
is at Fort Jefferson?
Yeah, so the office would be this whole space up here.
Okay. All right, thank you. And can the record reflect that the witness is pointing to the right side of the image of Fort Jefferson above the garage? So it's all the way at one side, the office is all the way at one side of the house?
Yeah.
And it has its own separate entrance?
Yeah, it does. Would be underneath, like where you pull the car in.
Okay, so you can basically go in through the garage.
Yes.
And Bob, can you pull up what's number 2? This is Defense Exhibit D. Can you tell the jury what that is?
Yeah, so that's the other side of the garage.
Okay.
So once you drive through, that's what you would be facing.
Okay, and did people who worked at Ford Group employees, did they in fact park in that back area that you're looking at?
Yes.
And did you also park in that back area that we're looking at?
Yeah, I did.
Bob, can you pull up number 3, which is Defense Exhibit E? And this view, can you tell the jury, is this in fact looking from the vantage point at where the Ford Group employees would park in the back of Fort Jefferson?
Yeah, that was right behind the house. There was a little stone area where you would pull up to park.
And Bob, can you pull up 4, which is Defense Exhibit F? And do you recognize this picture?
Yeah.
Is it one of the rooms of Ford Group, one of the office rooms?
Yeah.
All right, and that's above the garage?
Yep.
With its own separate entrance. And did you work in this office?
Yes, I did.
Did you actually work at this table or something similar to it at the time back in 2013?
Yeah, I usually sat at that table, and there was a table on this side that I would sometimes sit as well.
And other employees worked there as well?
Yeah.
About 4 or 5, you said?
Yeah.
Was Mr. Dulos, Fotis Dulos, was sometimes there at the office with you?
Oh, yeah.
All right, and he sat at that desk with you?
Yep.
And you worked with him side by side?
Yep.
And you saw him almost daily?
Yeah.
And you had an opportunity to observe him with other employees?
Yes.
Bob, can you call up number 5? Showing you
This is pretty
Defense
nice.
Exhibit
I like it.
G. Is this another room upstairs in Ford Group's office?
Yeah, so this is past the room that you just showed.
And would you also work in this room?
Not usually, because usually that's the room where, like, if he had clients come in, he would use the table there to sit with people and go over things.
So clients would meet at the Ford Group office?
Yeah.
And people would come in and out of the office?
Yeah.
Pretty regularly?
Yeah.
And they would enter through the garage?
So it wasn't like inside the garage. You could get to the office that way, but there was an outside door that you could get. There
An
was a
outside door
stairwell.
that's separate from the
That's separate from the house, yes.
Right? People would just go to the office, but wouldn't necessarily walk through the house?
Yeah.
So people could be there in and out all during the day, but wouldn't at all interact with the people who are inside the home?
Yeah.
You can take that down. Thank you. You talked about some other people who had worked at Ford, and you said that Pavel was one of them,
Mhm.
and he helped you sometimes?
Yeah.
And there were other people who worked there when you were there from between 2013 to 2017?
Mhm.
May I have one moment, please, Your Honor? Your Honor, I'd ask that Defense Exhibit H be moved in as an exhibit. I don't believe there's any objection.
that's correct, Judge.
The defense H will be admitted as full.
Bob, can you call up number 6? Ms. Almeida, do you recognize some of the people in this photo?
Yeah.
All right. And on the bottom left, is that a photo of Pavel Gamianian?
Yes.
And he was the worker we just talked about who worked at Ford Group from before you started in
Yeah.
2013, who remained at Ford Group working with Fotis.
Yes.
He worked for Fotis.
Yeah, I think at first he was a subcontractor, and then eventually I moved as to employee.
Okay, did he become a project manager?
Yeah.
All right. And he worked closely with Fotis from what you could observe.
Yeah.
And he interacted with him daily?
Yeah.
All right. How about next, obviously the top left, is that a picture of Fotis Dulos?
Yes.
All right, and you recognize him?
Yeah.
All right, and that's how he appeared to you at times between 2013 and 2017?
Yeah.
All right. And next to Fotis Dulos is Guillaume, is it Vitale?
I think.
I'm not sure. Either. Are you familiar with him?
Yeah.
Did he work at Ford Group at the time that you worked there?
Yeah.
And between 2013 to 2017, was he there during that entire period of time?
Yes.
How about Stefan Reich?
Right. Yeah.
Reich. He worked at Ford Group.
Yes.
What did Mr. Reich do at Ford Group? when
He was
working?
real estate, so he was an agent. So
Did
showing
he
places.
work with Ford Group from 2013 through 2017, to your knowledge?
No, I think he left the company when I was there, but I don't recall when.
Okay.
But I think that they still maybe consulted with each other.
You think they kept in touch
I think so. Yeah.
from a business point of view?
Yeah.
Okay. And how about Matt Byrne?
Yeah.
When to when did Matt Byrne work for Ford Group?
So Matt came in after me, but I don't remember the times.
Was he there when you left in 2017? Was he still working for Ford Group?
I think so.
How about on the bottom right, that Ben Corbett? Did he work for Ford Group?
He did.
And did he work for Ford Group in 2013 when you were working there?
Yeah, but he was younger. He was still in college. So he's finishing college and he would come back for like summers and breaks and he was helping not so much like project managing, but like tasks around the company or things like that.
Okay.
And then I think when he graduated, Fotis offered him a position.
And do you know whether he took it?
He did. Yeah.
Okay. And did he also help around with the kids?
Ben. Yeah.
All right. Did he also go on vacations?
Yes.
All right. How about Mr. Vitale? Did he also go on vacations with the family ever?
Yeah.
All right. So you can take that down. Thank you. Mr. Dulos had a good relationship with most of his employees, it sounds like.
Yeah.
And he was close with them
Some of them. Yeah.
and spoke to them pretty regularly.
Yeah.
And socialized with them.
Yeah.
For a time, you had a good relationship with him.
I did.
You considered him a mentor.
I did.
All right, so when you left working for Ford Group at the end of your workday, you went and cared for the Dulos children.
Yes.
And while doing that, in that capacity, you had an opportunity to observe Fotis Dulos' and Jennifer Dulos' relationship.
Yes.
And you were able to observe it from when you started in 2012?
Yep.
And you always thought that the dynamic between Fotis and Jennifer was odd?
Yeah.
Early on in your employment?
Yeah.
From 2012?
Yeah.
And it wasn't a typical relationship?
I mean, I'm going based on what I grew up with. So to me, no, it wasn't.
Not like anything you've seen before?
Not like my home.
In your experience?
In my experience. Yeah.
And early on, we're talking 2012, 2013, he took a lot of vacations,
Early on and throughout.
early on and throughout.
Yeah.
He took vacations with a family.
Yep.
And he took vacations with you as well as the family.
Yep.
And then he took vacations with just you and the kids.
Yep.
Did he ever take vacations with just the kids?
The two older boys.
And he also went away quite a bit on his own
Yes.
from early on.
Yes.
And you didn't know where he was going.
No, early on, no, I had no idea.
You didn't know if it was for business.
Nope.
You didn't know if it was a
Pleasure.
vacation.
Nope.
You didn't know if it was a ski competition.
No, I didn't know.
And you didn't know if he went with anybody.
Early on, no.
And you didn't know if he met anybody when he was on vacation.
No.
All right. And you don't know where he went.
No.
And as part of your observation of their relationship, Jennifer seemed to be totally fine with that.
Yeah, it didn't seem to like bother her so much. And again, I was coming from what I believed. He was away a lot. If that was me, I would probably be like, why are you away a lot? But at that time, again, I was just starting and I was there just once a week and I wasn't as close with them as I became to be.
Understood. And you said you went on vacations with the Dulos family.
Yep.
And sometimes you traveled with Fotis alone.
Yep.
Did you go with Fotis, not alone, but alone
But with the
and
kids. Yeah, with the kids.
Did you go with Fotis alone and with the kids to Greece?
I did.
All right. And did Fotis introduce you to some women friends of his in Greece?
Yes.
And did you ever go alone with Fotis to Miami?
Yes.
And was that prior to or after March of 2017?
Well, so it was March 2017 was the first time that I was like alone with him and the kids. He would take trips with the 2 older boys to Miami just by himself.
But March 2017 was the first time you went with Fotis and the kids to the Miami Ski Club?
Yeah.
And you went several times that week that you were there to the Miami Ski Club?
Yeah.
That's a private club?
Yeah.
Members only?
Yeah.
Do you know if Fotis was a member?
He was.
You said he had a boat?
Yeah.
And all the times that you went with Fotis, the kids also went?
Yeah, it was always with the kids.
But Jennifer never went?
Jennifer never went.
It's about 1 o'clock, Jenny Felsen. You can pick up the cross-examination after the lunch and recess. Take the lunch and recess, ladies and gentlemen, until 2 o'clock. Please do not discuss the case.
Thank you, Your Honor.
So yes, I understand you guys want to simp for this woman, but
All rise. This honorable Superior Court now stands in recess until 2.
I know you guys want to simp for her, but there's, you know, they are trying to work in evidence about what she knew or did not know. And now we're going to start part 2 of day 4.
Myself and Attorney Moran, who is sitting with us
Well, that was
in
quick.
our office assisting in this case. We're en route upstairs. We were on the elevator banks as one of the marshals was bringing 2 of the alternate jurors back upstairs. When the elevator doors opened, Attorney Moran and myself, when we realized who was inside the elevator, we turned around and immediately walked away. We did not say anything. And the marshal escorting the jurors leaned out and said, "Thanks, Liz, we love you." And the elevator doors closed.
Oh,
So at that point, I immediately came upstairs and informed
jeez.
Attorney Felsen and Attorney Schohorn, as well as the Marshals Service. And I'm bringing that on the record now that that exchange happened. No one from the state said anything back. In fact, we walked away quickly when we realized who was in the elevator bank.
Okay, that's funny. So they're on the elevator, they're getting the elevators and they realize there's a juror there. Once you get into the trial mode, like, you know, like you walk into the courthouse and you're set for trial that day, even before you do voir dire, you don't say hi to people. Like, I'll say hi to the guards or people I know who aren't on jury duty, like people who work at the courthouse. But if you see random people walking around, you're not just like, you don't even say good morning. You don't smile. You just, you know, if you have to say, excuse me, fine. You know, but even then, if you bring that, it's like, yeah, did me have interaction? Did I, you know, just, did I excuse myself as I tried to go around you or something like that? It's funny though, while the marshal's standing there with the juror, and in Connecticut, a marshal's like an actual like police position. He says to the prosecutors, "We love you guys," while he's standing there with jurors. What a mope. What a mope. Holy cow.
Jenny Felsen.
We had some
Attorney Schoenhorn.
discussion about that. I don't think we need to put a lot on the record. I think it was inadvertent. I understand that the marshals are just going to switch. And I think that the only thing that maybe the court should do is at least advise the jury that any comments they hear in the hallway or the elevators about anybody connected to the case should be disregarded. I think that that probably would take care of it. I'm not seeking anything more important than that. I'm certain it was inadvertent.
Thank you.
Well,
First, the court will address the supervising marshal in the courtroom. No marshal is to comment at any time on the case or any individuals involved in the case, or comment on the court. And no marshal is to have any conversation with individuals, specifically counsel and the staff of the State's Attorney's Office, or the staff or counsel for the defense in the presence of any juror.
You think that would have to be
Now, what has happened
said.
today?
You think that would go without saying. That's the funny part, because these guys work there. It's not like they're just the first day at the courthouse ever. So it's mind blowing.
Is the court agrees with Attorney Schoenhorn, inadvertent. Attorney Moran is not conducting any cross-examination or direct examination. She is assisting counsel in the presentation.
Oh, you guys saying it
Of
wasn't
the
the marshal.
exhibit.
Sorry. Well, even the jurors.
Court
Yeah,
is
you guys
not
should shut up when you
convinced
see
that-
people.
The comment from the marshal will lead the jury to, or those
Well,
jurors
hold on,
who
this-
heard it, to
Wait. Time
opine
out.
about the
The judge just said the comment from the marshal. The judge just said the comment from the marshal.
Okay.
the
No,
comment
I'm
from the
telling
marshal
Chad.
will lead the jury to, the comment from the marshal
Yeah, see?
will
This is a comment
lead
from the
jury
marshal.
to, or those jurors who heard it, to opine about the nature of the state's case or the nature of the defense.
Yeah, the strength of it, yeah.
If the comments had concerned perhaps Attorney McGinnis or Attorney Manning and had been of the tenor, "We love you, you're doing a great job, keep it up," that's a different story. But as of right now, the court thinks any opinion formed by alternate jurors based on the comment to Attorney Moran is of little effect. But the court will address the jury when they come in.
There is one other matter, Judge, that I need to raise at this time, and I'm doing it at the earliest moment before the jury comes in. One of the reasons we file our motions in limine is so that issues that are potentially prejudicial and require some deliberation on the court are heard in advance outside the jury's presence. So when the current witness, Ms. Almeida, was on the stand, we were aware of, we had listened to the 911 calls. We were aware of the highly prejudicial nature of some of her comments that were clearly hearsay. And I note specifically that we were aware, and the state was aware of our concern about the issue of a mention that at some point Mr. Dulos had purchased a firearm that he then disposed of years ago as part of a divorce case. So when that was said, Your Honor, we tried, Attorney Felsen tried to get this decided so that the witness would be admonished outside the presence of the jury. There are cases such as State versus Onofrio in 179 Connecticut, State versus Girolamo, Girolamo in 197.
Delete what? What are we
State
doing
versus
here?
Williams in 182 Connecticut, where those cases say that evidence about guns, where that is where firearms is not a part of the case, is particularly inflammatory and can have an effect on the jury's judgment. It awakens sympathy, passions.
Yes, 100%.
the Judgment of the jury, and cannot be considered harmless. Based on that, Your Honor, and I'm reluctant to do this, but I'm making a motion for mistrial.
Motion's denied. The court received a motion in limine.
I'm reluctant. Okay, guys. Yes. Okay. Apparently, the judge has it wrong. All right. The judge has it wrong. It was one of the jurors. It wasn't the marshal. Oopsie poopsie. Hold on 1 second. Now, I love how the attorney's like, reluctantly, I'm asking for a mistrial. It's like, reluctantly, come on, dude. You know you want to ask for it. Just say it. I want a mistrial, Your Honor. It's okay. You can say it, man. Charles put the nanny on house arrest at my house. Yeah. Real quick, I'll answer these two questions. Actually, we got to get through some of these real quick. I like to dissect women for $2. Says Sean isn't even here. Nice redirect. Unhung Hero for $2 says, oh, I'm gonna come. I like to dissect women for $2 says Hard Smash. Brandon Alt, by the way. Well, that's kind of figured it was. And then Youngly Minx is saying, couldn't the attorney have told the nanny not to talk about a gun before she went on the stand? Yes. And that's part of when you have a witness, especially as a prosecutor, I would argue you have a duty to tell them what they can and can't say. Here are the nice topics. Here are the no-no things. Don't say this. Don't say that. I generally think that's on the state because they're the ones who should be prepping their witnesses. And then Claude says, can a jury be held in contempt? Yeah, we see it all the time in the Young Thug trial. jurors that were getting sent to jail for screwing around and ignoring the court. So that's not impossible. It's a very, very realistic possibility of that happening. So, definitely very realistically possible. So, definitely possible. Definitely possible. So those are not bad questions. Those are all very good questions, guys. We got to get this going back again. But yes, you don't reluctantly ask for a mistrial. It's not a big deal. Oh, that's why it's not starting. So I'm clicking the wrong screen.
This morning, if the defense had indicated in the motion in limine exactly what this witness may say that was prejudicial concerning guns or the purchase of guns, it should have appeared in the motion. That would have alerted the court to the nature of the hearsay. But a general motion in limine to preclude hearsay is not enough for this court to grant a blanket motion without having some roadmap as to what the highly prejudicial nature of the testimony would be.
Your Honor, it had to do with the motion yesterday regarding marital discord. That was where the court would not entertain a proffer about what issues would or would not be allowed in and would hear them as they arose. And that's what I'm referring to more so than the fact that this witness was allowed to testify about her conversations to the police, which is also, I note, testimonial in nature.
Well, a general motion in limine about marital discord does not lead to this court considering testimony about a gun. And so motion for marital discord generally may involve contention, arguments, physical assaults, but not the purchase of a gun. So the court is not on notice from a motion to preclude testimony about marital discord that there may be evidence of a gun. And again, the motion in limine filed today mentions nothing about a firearm or a purchase of a firearm. So the court has no idea as to what the prejudicial, unfairly prejudicial nature of the testimony would be. Can bring the jury in.
Sure.
So we'll see what happens here. We'll see what happens, guys. Discord is the cause of this all. Yes.
Would counsel stipulate to the presence of all of the jurors, please?
Yes, Judge. Yes.
Ladies and gentlemen, it was brought to the court's attention that there may have been a number of you, perhaps the court should say a few of the alternate jurors, who may have overheard a comment from one of the marshals who have been assigned to this case. And that comment was directed towards Attorney Moran, who is sitting behind counsel table, sitting behind attorneys Manning and McGinnis. And that comment was directed towards her, but it was probably overheard by one or more of the alternate jurors. And that comment was essentially a complimentary comment to Attorney Moran. It was brought to the court's attention that that comment may in some way be perceived as an opinion by one of the marshals as to the strength of the state's case. The court is not convinced that that comment was an endorsement of the strength of the state's case. Nevertheless, what the court will do is indicate to you that if you hear any comment from any of the court staff concerning any other participant in the trial, or the nature of the state's case or the nature of the defense case, first, if you overhear it and you think it needs to be brought to the attention of the court, it should be brought to the attention of the court. Secondly, if you think it probably means very little or has little effect, just ignore it. However, any comment that would suggest that the strength of the state's case or the strength of the defense case is being articulated in your hearing, that should be brought to the attention of the court.
Well, he's given a curative instruction. He's telling him, like, look, one of you or a couple of you may have heard these things. If you have heard these things, it's your duty to disrupt them, ignore them, disregard them. What somebody may say about the strength or weakness of a case is not relevant for you because ultimately you have to judge it yourself. I mean, I think he's just trying to cover the basis of what could have happened in the neighborhood. So I think he's doing an okay job. I mean, he really talks, but yeah.
Thank you. We can bring the witness back in. You may proceed, Counsel.
Thank you, Your Honor. Good afternoon again. Hi. We were talking about the Miami Ski Club, I think, when we were last here. The Miami Ski Club is a water ski club.
Yeah.
And it's members only,
Yes.
private,
Yes.
and Fotis had a membership there.
Yes.
Do you know for how long Fotis had that membership?
I'm not exactly sure.
But Fotis had been traveling down to Miami for some time,
Yes.
alone
Yes.
and with the kids,
Yes.
for years.
Yeah.
And Fotis water skied
Yes.
competitively.
Yes.
You describe him as very competitive,
Yes.
and not just in water skiing,
With everything.
everything. Had he been water skiing since when you first met him?
Yeah.
And he taught the kids to water ski?
Yeah.
And they all water skied?
They all water ski. Yeah.
Some of them competitively?
Yes.
They had won medals?
Yes.
Did he teach you to water ski too?
He did.
All right. And I think he also taught you how to drive the boat?
Yep.
When you went to the
Drive it Tommy
Miami
Lee style.
Ski Club
Yeah.
in March of 2017, and you met Michelle
Yes.
for the first time,
Yes.
and you met her daughter as well. Her daughter was there.
Yes.
Your Honor, I'd move into evidence defendants. I changed the numbers a little bit. It's I1 through I4, I believe, without the state's objection.
That's correct, Judge.
The defendants I1 through 4 admitted as full exhibits.
And can you pull up I4, please? Thank you. Ms. Almeida, do you recognize some of the people in this picture?
Yes,
Is Fotis in this picture?
yes,
Is Michelle in this picture?
yes.
And the Dulos children?
Not all of them.
Okay, but some of the Dulos children are in the picture?
It looks like 2 of them.
Okay. And do you recognize Michelle's daughter in that picture?
Yes,
Okay. And is that at the Miami Ski Club?
I think so. It's kind of hard to tell.
Do you remember if you took the picture or not?
No, I don't remember.
Okay, but you had been at the Miami Ski Club before?
Yes.
All right. And you recognize Fotis and Michelle in this picture?
Yes,
All right. And at least 2 of the Dulos children and Michelle's daughter?
Yes.
All right. Thank you. Thank you. Was Michelle at the ski club every time that you were there when you went there in March of 2017?
No, I don't think so.
All right. How many times did you go there that week?
To be honest, I don't really remember.
But you went frequently?
Yeah, the reason for that trip was so that they could water ski.
Okay, so I'm assuming you went every day.
Yeah, we probably went mostly every day.
All right. And you were there for lengthy periods of time?
Yeah.
And Michelle was there several of the times at least?
Yeah.
All right. And she was interacting with Fotis?
Yep.
And the kids?
Yeah.
And they seemed familiar with her?
Some of the kids.
All right. And you observed that? It was in front of you?
Yes.
It wasn't being done in private or in secret?
No.
And I think you mentioned you spoke to Michelle?
Yep.
And she told you that she intended to move to Vail, Colorado with her daughter?
Yes.
Do you know, in fact, whether she did that at any point in time?
I don't know.
Did Fotis water ski a lot?
Yes.
All right. Did you go with him sometimes down to the pond?
With the kids, yes.
There was a pond in Avon, Connecticut.
Yeah, in Avon.
All right, and he would go down there.
Yep.
All right, and would you ever go with him when he competed?
Yes.
All right, and would the kids go with him and with you when he competed?
Anytime I went with Fotis, it was always with the kids to watch him compete or the kids compete.
Bob, can you pull up I-1? Do you recognize the people in this picture?
Yes.
All right, and is that Fotis?
Yes.
And is he with one of his children?
Yes.
Was this picture, you did not take this picture, did you?
No, but I know where that picture was taken.
All right, do you know, can you tell the jury when this picture was taken?
Yeah, so we were coming back from a trip, a ski trip. It was around Christmas time. And
A
some
ski
of us
trip.
got on a plane. There was a lot of cancellations and stuff like that. And I wanted to be home for Christmas. So Jennifer, myself, and 4 of the kids were able to get on a different flight because ours got canceled to be back home. And there was only enough seats for all the amount of that was there. And so there were Fotis and Theodore stayed back. And I think it was like maybe a day.
Was it Christmas time of 2015, 16, 17, 18? What year was it?
To be honest, I don't remember, to be honest.
All right, but it was prior to 2019.
Prior to 2019.
Okay. And in this picture, Fotis has very short hair, correct?
Yeah.
All right. Had you ever shaved Fotis's hair?
No.
All right. But you do recognize him in this picture.
Yes.
All right. Bob, can you pull up I-2? This is also a picture of Fotis
Yes.
with one of his children.
Yes.
And even though the date's on there, can you tell or give a sense to the jury if in fact that seems like a picture taken of Fotis and one of his children in 2016?
Yeah, it was probably at the pond, it looks like, maybe, and the one in Avon. I don't know.
But about that year? Does that
Yeah.
year seem right?
The way Petros looks. Yeah.
And Bob, can you please pull up I-3? Do you recognize Fotis in this picture
Yes.
and with his children?
Yes.
Was this also at the pond?
I can't really tell.
Mhm.
But was this prior to 2019?
Yes.
Bob, you can take that down.
Hmm.
Thank you. You told the jury that you stayed behind in Miami in March of 2017 for a little
In
while?
Miami.
When Jennifer went
Miami.
back home?
Yes.
Yes.
And then you returned at some point
Yes.
without Fotis.
Without Fotis.
And Jennifer told you that she confirmed that Fotis was having an affair,
Yes.
and she didn't seem surprised.
No.
And she said she wasn't in love with him and hadn't been for a long time.
Yeah.
Jennifer also told you when you were in Florida that she suspected Fotis was having an affair,
Yes, she did.
and you didn't believe her at first.
No.
And you had worked with him for several years before,
Yes.
side by side.
Yep.
And you thought you knew him.
I thought I knew him.
Did you know that Fotis had been married before
Let's
Jennifer?
go.
At that time in 2017, yes, but it took me some time to find that out.
All right, but you eventually learned that
Yes.
he in fact was married before,
Yes.
and he was
Yes.
dating Jennifer while he was still married.
I didn't know the details.
Yeah,
Did
there's
you
like a
learn that at
pattern
some
here.
point?
No, I didn't.
So before you proceed, counsel, the court has to take a brief recess, not based on anything other than something has been brought to the court's attention. So this is not the afternoon recess, ladies and gentlemen. This is just something the court has to address immediately. So we ask that you return to the deliberation room and please do not discuss the case.
I've got to be judicial with someone, ladies and gentlemen, is what he's saying.
And we'll take, everyone needs to leave the courtroom.
All rise. This honorable Superior Court now
Just that
stands in
issue you
recess.
guys brought
Recess to
up.
the courtroom.
The judge doing the nanny. I think maybe he has to go to potty. Let's see here. Let's go from here and go whoop, 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 whoop. Okay.
court indicated before it took that brief recess that it had to address a matter. And the court has to address that matter at this time, which has nothing to do with the merits of the case. The court was informed previously that one of the marshals had, in the presence of two of the jurors,
The Jurors.
rendered a complimentary remark to Attorney Liz Moran outside of one of the elevator banks. And that complimentary remark was that, according to what was reported to this court, we love you. But the attribution to the marshal was an incorrect attribution. The court has now learned that it was not the marshal who said, we love you to Attorney Moran, but it was one of the jurors. That is cause for the court to have to bring in that juror
Yes, it is.
to determine whether those remarks.
And that's the thing, guys. If you get on a jury,
Those remarks. were
don't
made,
screw around.
Then that juror. may
Tell
have
people
to
we
be
love you
dismissed.
and stuff like that. Don't be that person.
But first, we will ask Mr. Christian Alvarado to just take the stand so that we can understand what the nature of those comments were as he heard them. The court should also indicate that when the juror is brought in.
So, when he refers to himself as the court, Jared, that's natural. He's got to refer to himself in the third person because it's not him making personal decisions. I think that. No, he's speaking as the court. He's speaking as the referee. He's speaking from that position there. So that is what they're. That's why he says that. It's because it's, if that makes any sense. I hope that explains it, because if I'm the judge, I don't say, well, I think it should be this way. Some judges will. The proper way is the court to speak in the third person, because the court is merely just the referee. So.
And there will be no video coverage of that, no still photo coverage of that. And we would ask both the videographer and the photographer to wait outside of the courtroom when that juror is brought in. Madam Clerk.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm the case may be?
The marshal's like, Jesus. He's like, I just want to get paid and get my retirement.
I do.
Just state your name.
Christian Alvarado.
Thank you. Marshal Alvarado, you may be seated. Marshal Alvarado, the court will just draw your attention to the time before we took our lunch and recess. And you were in the presence of at least two jurors after the court had recessed. Can you tell the court what happened and what you heard?
I was on the elevator coming back from lunch with the two jurors, and it made a stop on the second floor. Attorneys Moran and Manning tried to get on the elevator. They turned back around, and in the midst of that, I said, thanks, Liz, and the juror ultimately kind of stuck his head out and said, we love you. The door closed, and then we went on our way.
Now, was that juror's comment directed towards Attorney Moran?
I believe so, yes.
And how many other jurors were present when that comment was made?
Other than him, just one more.
And was there any other marshal with you when those comments were made?
Just me.
Was there anyone who was not a marshal or a juror close enough to hear those comments?
Not that I could see from my point of view.
Okay. Thank you. You may step down. Yes. Now, what the court is going to do at this point is call that juror in. The cameras need to go off. And we ask the videographer and the photographer to step out of the courtroom.
And this judge is not screwing around. He's like, you're walking out of the courtroom. I'm not even going to chance an accident here. Turn the camera away and just let it ride. So, let's see if we can even hear the sound. Ashley says, how often does this happen? It happens a lot, but never to that level of like, oh, we love you. You might say, like, I might come into court and say, Your Honor, I tried to get on the elevator and I ran into him, and the person's like, oh, you can come in here, and I said, sorry, I can't, because that juror spoke to me. And I'll say, Your Honor, I don't believe there was any effect by that. It wasn't my intention to gain anything out of that. But the juror did speak to me. I immediately said, I'm sorry, I can't. Now that's how that works. If that makes any sense to you. I mean, there are all kinds of screw ups and things like that happening. Normally when you start a trial, the judge will point out, like, the parties will avoid you. Like they say, ladies and gentlemen, the attorneys are going to avoid you like the plague. They're gonna treat you like you're a spooky ghost. If you're on the elevator, they're going the other way. If you're walking in the hallway, they're gonna go around, or they might wait, or they won't acknowledge you, and they'll pretend you're not there, because that's because of this kind of stuff. I mean, it's kind of biased. It's very heavily biased. That is a heavily biased comment. We love you. It's like, bro, like, what kind of wine mom crap is this? So, Otto says, I bet the jurors say I love you to Sean all the time. Yeah, yeah. So let's catch up here.
Good afternoon, Your
Make the record as to what has transpired. It was brought to the court's attention when we began our afternoon session that there were some comments made by what was believed to be a marshal that was heard by some jurors who were sitting on the case. It was later discovered that it was not the marshal that made those comments. It was one of the jurors who made the comment. Now, the comment was directed towards, as the court understands it, at least one person, Attorney Elizabeth Moran, who is one of the assistant state's attorneys who is assisting the state in the presentation of exhibits. The comment made by one of the elevator banks in the presence of another juror and one of the marshals, or the marshal that was involved, was that we love you, directed at least to Attorney Moran. Upon learning that the comment was made and that it was made by one of the jurors, the court conducted an inquiry calling that juror to the courtroom and having that juror sit in the jury box. And the court asked the juror if he made such comments, and the tenor of the response was yes. The comment was directed at both Attorney Moran and Attorney Manning. The court indicated to the juror that it can easily be perceived that the comment made to at least Attorney Moran can be an endorsement, an opinion about the strength of the state's case, and that he at this time was favoring the state's case. The court explained to the juror that the appearance that there was a favorable opinion of the state's case indicates to this court at this time that it would be difficult to proceed with him seated as a juror because the impartiality and fairness of that juror can reasonably be questioned. That was juror number 420. The court dismissed the juror. The court then asked that the juror who was in the presence of that juror, who also heard the comments, to be seated in the jury box. The court asked that juror if those comments were discussed with anyone else that is anyone on the jury. And the response was no, and the court asked if those comments were heard by anyone other than himself, juror 399, and of course, juror 420, and the response was no. Because the inquiry involved an inquiry of jurors, the court maintained its supervisory authority not to have that portion of the proceeding recorded, either by video or by audio, other than the court reporters taking of the audio of the proceeding. Are we ready to proceed?
Yes, Judge.
We can bring, well, let's bring the jury back in. Well, we can bring the witness in first, and then we'll bring the jury in.
That's the right decision. If that's what he said, he's got to go. There's no. I don't even think it got to the defense or the prosecutor. The judge made his own decision. That guy's got to go. Yeah. Don't be screwing around with that stuff. It's George 420. Yeah. I was gonna pass a verdict, but then I got high. Ooh.
You may inquire if any folks.
Robert Lawrence, yes. 420 blaze it.
Your Honor, I have to wait for
Oh,
the
I'm
jury.
sorry. Please bring the jury in.
Sleeping psychopath, he became a member of thank you very much. I appreciate it. And then I just wanted to address this one real quick. That's a shame you brought this up earlier. But the other jurors didn't know the marshal had that positive opinion. He could have stopped at something you may have heard a comment. Yeah, but I think he needs to make it clear and I would argue if I'm even the defense, I want to make it clear like that, if somebody's messed up and they're making comments about one side or another, that can't be tolerated, disregard it. I think because you don't know what comments other people have heard, you're not sure. So you never know, because other people may have heard things that were not necessarily reported. So I actually think for the sake of the record, it should be acknowledged on the record as the curative. Disregard the specific comments. Because otherwise that would be a massive issue on an appeal, like what was actually said. So here we go.
Counsel stipulate.
Yes, Judge.
Yes, Your Honor.
Thank you, may inquire.
Thank you, Your Honor. Good afternoon again. We keep getting interrupted.
Yes,
Apologize.
all good.
I want to just close something out, and if I had asked you already, and I'm repeating it, I apologize, but maybe I missed it. I think you said at some point in time, you did not know that Fotis had been married previously. Did at some point you learn that?
I learned it at some point.
Okay. Do you remember when you learned that?
It was a few years after working for Jennifer and Fotis.
It was before 2017?
Yes.
All right. And did you learn that he was still married when he was with Jennifer?
I'm just going to object, Your Honor. Asked and answered, calls for hearsay.
Well, the question was, what does the word believe, that he was still married? So the court did not catch the phrasing, Attorney Felsen. Would you phrase the question again as you stated it?
At some point, did you learn that Fotis was still married while he was dating Jennifer?
Same objection, Judge.
Well, did you learn that Fotis was still married while he was dating Jennifer? And the objection is?
Well, it's twofold. One is that she's already answered this question, so it's asked and answered. And then my second objection is that it calls for hearsay information.
Well, the objection's overruled.
Yeah, I don't know.
No.
There's no real way to ask that question otherwise.
After you came back up from Miami and Jennifer had told you that she was going to leave, she asked you to go with her?
It wasn't right That wasn't that night when I got back. No,
Okay, but it was shortly after that.
a few weeks after.
And you said yes?
Yes,
And you gave notice to Fotis that you were quitting for group.
yes, I did.
But you didn't tell Fotis that why you were quitting, right?
No.
And the plan was for Jennifer to move out of Fort Jefferson,
The plan with myself or the plan with like that? her
just with
Fotis?
Jennifer to move out.
Yeah, her plan was to no longer live at Fort Jefferson.
Okay, and to leave without Fotis knowing that she was going to leave.
She was gonna let him know after she left. So
So she was going to leave without him knowing that she left. And she was going to take the children without him knowing that she was going to take the children.
yes,
And she told you not to tell, obviously, Fotis, right?
Yep.
You had testified to some, there was tension in the house, right?
Yeah.
Between, I would say, when you got back from Miami and then when Jennifer moved out.
yeah. So like the months prior to her leaving.
And there was also some tension between you and Fotis, where Fotis had yelled at you
Yes.
in 2017.
Well, the tension with Fotis and myself didn't really start until after, well, the day I left with Jennifer.
So from about June of 2017, for at least that month, there was some tension.
Probably a few months after that.
And you would testify that you saw him here in court.
I did.
It was in this courthouse,
Yes.
and he approached you,
He did.
and he was angry.
Yes.
And then his personality shifted, and he appeared to be reasonable.
Yes.
And he also had approached you once at the pond, I think, and had been yelling at you,
Yes.
and then suddenly switched and became very reasonable.
See, there were several times in which he yelled at me, different occasions of drop-offs.
And then his personality just shifted.
Yeah.
And those were in 2017.
Yes.
And because of that, you had indicated to Jennifer that you no longer wanted to have contact with Fotis.
Yes.
So between 2017 to 2019, you had very little contact with Fotis.
Yes.
All right, you didn't go to Fort Jefferson.
No.
You didn't know who was living at Fort Jefferson.
No.
You didn't talk to Fotis on the phone.
There might have been a few occasions they were going to a family systems therapy where I would do some drop-offs, but that was more controlled. So occasionally I would do that, but there was never really any like calls or texts between Fotis.
Okay, so for 2 years, other than those few times, you really had no interaction with him.
No.
So I'm going to fast forward now to 2019, to May of 2019. You were still working for Jennifer.
Yeah.
And Jennifer was living in New Canaan.
Yes.
At some point, she moved to 69 Wells.
Yeah, she originally moved to 153 Chichester, which was in New Canaan. I think it was a year she moved to 69 Wells Lane.
And when she was at 69 Wells, you were working, doing childcare,
Yes.
and you were helping organize the house.
Yes.
In May of 2019, were the Dulos kids and Jennifer living at 69 Wells?
Yes.
And in May of 2019, did Fotis have supervised visitation with the children?
Supervised. Yes.
And that was on Wednesdays?
Wednesdays. And if it was agreed upon other days, for like that Memorial Day weekend, he was supposed to have a visit on Saturday, but that's because it was agreed on before. So there was some flexibility if the supervisor and Jennifer, they all agreed.
All right. And you're talking about the Saturday of Memorial Day weekend?
Yes.
All right. So the Wednesday before it, let's go to the Wednesday before it. That was May 22nd?
Yep.
And did Fotis have scheduled visitation with the kids on that Wednesday?
Yes.
And it was through a court-ordered supervisor?
Yes.
And that court-ordered supervisor would be present when Fotis met with the children
Yes.
and spent time with them. And that had been happening for many weeks prior.
Yes.
That Wednesday, May 22nd, Fotis had a supervised visitation with the kids,
Yes.
and it ended up being at 69 Wells.
Not the whole visit,
But part of it was at 69 Wells.
part of it.
And Jennifer had agreed to your understanding to allow him to be outside in the backyard at 69 Wells.
Yes.
You didn't want to be there?
No.
And you weren't there while Fotis was there?
No.
So you didn't see Fotis interact with the kids that night?
No.
And you didn't see Fotis interact with the supervisor that night?
No.
And you didn't see Fotis interact with Jennifer that night?
No.
So that's Wednesday, May 22nd. Thursday, May 23rd, you worked a regular schedule?
Yes,
You were in the house,
yes,
and I think you had mentioned that that Thursday you had emptied out paper towels into the pantry,
yeah. The evening before I left that Thursday,
and there were several of them.
12.
There's a package of 12.
Yeah, it was the big packs.
Is there more than one pantry in the kitchen, or is there just one main pantry?
One main pantry.
And is that the pantry where food is also stored
Yes.
and the kids' water bottles?
Yep.
And there's no other pantry, just that one?
There's like cabinets and stuff, but the food pantry was just that pantry. Yeah.
Okay, and the paper towels went in that pantry?
Yep.
All right. Now, May 24th is that Friday before Memorial Day. You had indicated that Fotis had scheduled visitation with the kids for that weekend.
That Saturday.
Okay, did he also have it for Sunday?
I don't remember.
All right. And that would have been through the courts
Yes.
by agreement?
Yes.
That Friday, you got to 69 Wells at about, did you say 11 a.m.?
Yeah, around there. I don't know exact.
And you didn't expect Jennifer to be home?
No.
Because she had plans to be in New York?
Yep.
And you understood that she had doctor's appointments in New York?
Yes.
And you were going to meet her in New York later in the afternoon
Yes, I was gonna meet her at her mom's.
after you picked the kids up from school?
Yes,
That Friday, they had a half day
they had a half day.
because of the Memorial Day weekend?
I think so. I don't really know.
And you went to the house before you picked up the kids?
Yes.
I think you testified that you went in through the garage,
Yes.
through the middle bay of the garage?
Yes.
Do you remember when you got there that there are 3 garage bays?
Yep.
All 3 of them were closed?
Yes.
And you remember that?
Yes.
And you used the keypad to get in
Yes.
that morning? And that keypad is only for the middle bay?
Yes.
And when you opened it, you saw that the Range Rover was parked in the middle bay?
Yes.
And that was not what you were expecting?
Yes.
Because you had expected that Jennifer was going to take the Suburban?
No, she was gonna take the Range Rover and
Okay.
the Suburban was gonna be left.
Okay, so you saw the Range Rover there, and that wasn't what you expected, because you expected that that would have been gone by that time of the day.
Yes.
Normally, so there's 3 bays, and the Range Rover was in the middle bay.
Yes.
Does Jennifer park the Suburban in the left bay?
Yes, on the left side.
Okay, she always does that, that's just
Just
what she
always-
does,
Yeah.
even if she's running in for 5 minutes.
Yeah, it's always that one. It was impossible to park in the other one because of the other stuff that was in that bay. It wouldn't have fit through the third bay.
The kids' stuff?
The kids' stuff,
Got it. And you had indicated when you walked through the garage, that first time when you were walking through, you were going inside, were you going inside just to straighten up before you picked the kids up?
Yeah, I had the sandwiches with me, so I put them in the fridge. And then, yeah, I usually go before I pick up the kids to straighten up.
And you didn't notice anything unusual in the garage when you first went through?
Other than the Range Rover being there, no,
You weren't really looking for anything?
I wasn't looking. No.
Did you go, when you walked in, did you go to the right of the Range Rover or to the left, if you remember, to get up to the garage door leading into the kitchen or the mudroom?
Yeah, so I always go to the right because usually the Suburban's there. So it's kind of just habit to go on the side that's empty
Got it.
that leads through the door into the mudroom.
And that door was unlocked?
Yes.
And it's usually unlocked?
Yes.
So that wasn't unusual?
No, that was unusual.
So when you went inside, you had said that you saw Jennifer's purse in the house on the floor?
It was in the doorway between the mudroom and the kitchen.
And usually she has it on the counter where she takes it with her?
Yes.
So it was on the floor and that was an unusual thing,
Yes.
but you didn't go through it at the time?
No, I didn't go through it.
Did Jennifer usually bring her purse with her when she was traveling?
Traveling like to New York.
Traveling
in
anywhere?
general?
Yeah.
It depended. Like she would take her wallet and phone sometimes. So she would leave her bag somewhere else. It just wouldn't really be on the floor.
So that was unusual.
Having the bag on the floor was unusual. Yeah.
And you saw, when you walked in, there was an uneaten granola bar on the counter,
Yeah, it was like still in its packaging.
right? You put that away.
Yes.
And then there was a mug of tea
Yes.
and it was full.
Yep.
You washed that mug?
Yep.
The tea wasn't hot. It was semi-warm.
It was semi-warm.
And about what time was that?
Like close to 11.
After you washed the mug, you noticed that there were no more paper towel rolls.
Yes.
So you went and replaced that roll of paper towels.
I just went to go get a new one in the pantry.
Do you recall there being a paper towel holder on the island in the kitchen?
Yes, it was right next to the sink.
And is that what you did? You replaced the roll that was on there, the used up roll, and replaced it with a new roll?
Yes.
And then you left to pick up the kids?
Yes.
You went back through the garage?
Yeah, I went through the mudroom, out the middle bay, closed the door, and got in my car to get the other kids.
And then you pick up 4 of the kids?
Yep.
And brought them back?
I brought the 4 back to the house.
The 4 kids, you went back through the garage?
Yes, we always went through the garage.
When you left to pick the kids up, did you shut the garage door?
Yes.
And then you entered the keypad
Yes.
and you went back in?
Yes.
Do you recall if the 4 children went to the right of the Range Rover and walked into the house that way with you?
I don't recall. I don't
But
remember.
all 5 of you from school went back into the house?
Yes.
And there was nothing unusual at that point in the garage?
No, we just went right into the mudroom.
And again, you weren't looking for anything at that point?
Yeah, that's correct.
At some point, did you notice that there's another mudroom door leading to the outside?
Yes.
Did you notice that that door was unlocked?
Yes.
That's unusual, right?
That was unusual. Yes.
It's usually locked,
It's usually locked.
especially that time of day?
Yes. The
Okay.
only time it was unlocked was when the kids were playing outside because it was right directly towards the backyard. But other than that, that door was always locked.
So you eat lunch there?
Yes.
And then you brought the kids to New York?
Yes.
Everybody went back through the garage?
Yep.
So it was the 5 of you went? back
And
through the
myself and
garage.
4 of the kids.
And then did you shut the garage door when you left?
Yes.
At some point during the evening, you became very concerned and you called the police.
I did.
And you were giving them information, not just then, but over the next couple of days, you were talking to them and cooperating with them.
Yes.
During that time, when you were talking to the police, Fotis was reaching out to you. He was texting you.
Yes.
Can you pull up states 12,
16.
16? That's it. Is that the first page of it? Can you go to the next page?
I believe we're on redirect.
That's not what it is. I think it's, may I have one moment, please? So it will be 2 within that disk. These are your communications with Fotis, right?
Yes.
He was reaching out to you while you were talking to the police?
Yes.
And is this the first time he communicated with you? I can't see on top what time it says.
The first, no. I had
The
a phone call
Fosidin of the
before.
United
Okay.
States.
Bob, can you scroll down? Keep scrolling. Keep scrolling. Read the next page. Okay. Can you see where it says, "Good morning, GM, Lauren, any news?"
Yep.
All right. And you had said to him, call them at 2:30 and 5:30. No news. They just told me they're still searching.
Yes.
And then Fotis texted to you, I spoke to an officer at 1 a.m. as well. What did you take that text to mean from Fotis?
I spoke to an officer at 1 a.m. as well. I read it as he called them, as I did, to speak to them.
And you spoke to the police and told them that you were talking to Fotis or communicating with Fotis, right?
Yes.
And did you learn that Fotis, in fact, was not cooperating with the police afterwards?
No.
You did not learn that?
Can you repeat that?
It was poorly worded.
Sorry.
Did you learn that Fotis, in fact, was not cooperating with the police
At that moment?
after?
After that moment?
Yes.
In days, yeah, we learned that he was not cooperating.
Okay, even though Fotis told you he spoke with an officer.
Yes.
Thank you. He was also texting you on Sunday because it sounds like he was asking you how things were doing.
Yes,
And he actually showed up in New York.
he did.
He drove down in his car.
Yeah, he drove, I believe, in his Suburban.
And that was where the children were staying.
Yes,
You were there
I was there.
and it was an apartment.
Yes,
There's a bellman downstairs.
Yep.
Did he demand to see the children,
yes,
saying they were abducted?
yes.
You said that Fotis water skied a lot,
He did.
very competitively.
Yeah.
But that he was competitive with everything.
Yeah.
He was also a runner. You've seen him run before.
Yeah.
One moment, please.
He's run a lot. Okay. What's that got to do with what we're dealing with here? Just curious.
I don't have any other questions. Thank you.
So,
Is there a redirect?
Yes, Your Honor. Good afternoon.
Good afternoon.
Ms. Almeida, you were asked some questions on cross-examination regarding Mr. Dulos' travels. Do you recall those?
Yes.
And I believe you were asked whether or not you understood what he was away for, whether it was vacation or business. Do you recall that question?
Yes.
Now, in the time that you worked for Group, you indicated that you had an opportunity to work on different projects for the company. Is that correct?
Yes.
What states did Group develop houses in?
Connecticut, and I knew that they built.
yeah,
a
I'm
house in
sorry. It
Rhode
was
Island.
cross. My bad. My
Singular
bad.
house in Rhode Island.
Yes.
I keep forgetting there's a female attorney on the team.
You were asked some questions about the Miami Ski Club on cross-examination. Do you recall that?
Yes.
When did you first meet the defendant, Michelle Troconis?
It was at the ski club. Shortly after we got to Miami. I don't remember the exact.
See, that's an asked and answered.
March of 2017.
Yes, March of 2017.
May I ask the defense call up defense I-4? Apologize, I should have given you the heads up. Ms. Almeida, do you recall being asked on cross-examination whether or not you took that photograph?
Yes.
I just direct your attention to the date, October 17th, 2016. Assuming that that date and time is attributed to that photograph, could you have taken that photograph?
No.
Thank you, sir. You were asked on cross-examination whether or not the defendant had moved to Vail, Colorado. Do you recall that question?
Yes.
Where did the defendant move?
Farmington, Connecticut.
Where in Farmington, Connecticut did the defendant move?
4 Jefferson Crossing.
How long after Jennifer moved out of the house did the defendant move into 4 Jefferson Crossing?
From what I was aware, a few months
Objection, Your
after.
Honor.
Oh, ground,
Basis of knowledge.
so foundation. Well, counsel,
Well, I think it's fair follow-up to the cross-examination, Judge.
well, the response, as the court understood the response, is from what she understands. And so court does not know the fount of that understanding. And so the court is going to sustain the objection.
How did you become aware that the defendant had moved into 4 Jefferson Crossing?
Jennifer hired a private investigator and had pictures.
And when was that?
I don't know the exact time.
Approximately.
It was like a few months, maybe up to 6 months after the divorce started.
I just wanted to clarify, you were asked on cross-examination whether or not you'd ever been on vacation alone with Mr. Dulos. Do you recall that question?
Yes.
Have you ever been on vacation alone with Mr. Dulos?
With the kids, never myself and Fotis.
Right, and that's what I'm getting at. There were never just the two of you,
No.
correct? And you were asked some questions on cross-examination regarding Mr. Dulos' arrival in New York on Sunday, May 26th. Do you recall that?
Yes.
Could you just indicate to the jury what he was claiming?
He was claiming that we kidnapped his kids and that he was demanding the bellman to let him up to get his kids, which we already instructed the bellman not to let him up because at that point in time, he didn't have custody of the kids.
If I could just have a moment, Judge.
Sorry, I just have one moment.
Yes.
Here we go.
Did the Dulos children ever reside with their father after May 24th, 2019?
No.
Was there a scheduled visit for Sunday, May 26th, 2019?
I'm not sure.
Thank you.
I have one moment, please, Your Honor.
Come on, let's go. Let's go, state.
I have no further questions. Thank you.
Thank you.
Okay, you may step down.
So she's to redirect and recross.
Does the state intend to call another witness?
Yes, Judge. Just before we do, may we approach with a brief sidebar?
Yes.
So they got a sidebar. I don't know what this is about. We'll find out in a second. Don't tell YouTube what I'm working on here, because YouTube will get mad. So let's see what you guys have comments-wise here. I didn't like her. I hope the children did. Jeez. Oh my gosh. Oh, yeah. Well. Trying to get that so I could see a little better what I'm doing here. She walked by the defendant with stress. I'm sure it's very stressful. So, yeah, it'll be interesting to see how they address this problem or whatever it is they're doing. So, we'll find out pretty quick, though. Well, are we gonna like not hear who this is? What happened? The long
Yeah, they patrol, where I worked various shifts. From there, I was a member of the special response team for about 10 years. And then in about 2016, I was assigned to the investigation section.
And when you say special response team, what's that?
Special weapons and tactics. It's a team that's comprised for various events that could occur, barricade subjects. You receive special training in tactics and weapons use.
And the investigations division, what type of cases do you work on?
Investigations handles any involved investigation, burglaries, bank robberies, death investigations, any investigation that will be of like a prolonged time that patrol typically wouldn't have the time to handle. It will get assigned to the investigation section.
And how long had you been working in investigations prior to May 24th, 2019?
I was assigned in October of 2016.
Were you working on May 24th, 2019?
I was.
And specifically the evening hours, I'll just call your attention to approximately 7 or 8 o'clock in the evening. Were you working a normal shift at that time?
I was not working my normal shift.
Okay, so I guess I'll ask the question, how did you end up becoming involved?
He does look like
so,
Billy Mays.
So I had worked
yes.
my normal shift, which was 8 a.m. to 4 p.m. during the Friday. And I was the on-call investigator. So I was contacted by Lieutenant Ogrins at about 8 p.m. that evening in regards to a missing persons report.
And were you initially, on behalf of the New Canaan Police Department, I guess, the lead investigator?
Initially, yes.
So when you received the call from the lieutenant, what was the next step that you took?
Lieutenant Ogrins contacted me initially to request if I could do a search of our license plate readers. I had access to that at the time to search for the license plate of the missing person's vehicle. So I started to do that and then was contacted a short time later to report that they had located the vehicle on Lapham Road, and then they requested my assistance.
And who was the missing person?
Jennifer Dulos.
After learning that the vehicle had been located on Lapham Road, what did you do next?
I then responded to police headquarters, obtained my gear, and then went to where the vehicle was located on Lapham Road.
Prior to responding to Lapham Road from police headquarters, did you request any assistance from any other detectives?
Yes, I requested assistance from Detective Sergeant Romano, who was newly assigned to the Detective Bureau. And part of the training process was he would get called out along with any of the on-call investigators. So I had called Detective Sergeant Romano to come in to assist.
And did he respond to Lapham Road separately from you, or together?
Yes, he did.
When you arrived at Lapham Road, what did you see?
I met with Officer Blank, and there was Jennifer's black Chevy Suburban that was parked on the side of the road.
And at the time of your arrival on Lapham Road, was there an active search of Waveney Park going on?
Yes, at that point, a canine from Wilton had been there to do an initial search of the area.
And Waveney Park, what type of park is that?
Waveney Park is a approximately 300-acre park in New Canaan that's comprised of various open spaces, sporting fields. There's what we call Waveney Castle, which is utilized for various events. It's a large open area for the townspeople to utilize.
And approximately how long were you at Lapham Road for?
Approximately 10 minutes.
Did there come a point in time where you responded to 69 Wells Lane?
Yes, I did.
Approximately what time did you respond to 69 Wells Lane?
That was about 10:10 in the evening, 10:10 p.m.
And when you arrived at 69 Wells Lane, how did you approach the home?
So I was informed by Lieutenant Ladderette of some suspected blood that they had observed on a vehicle in the garage. So I met with Lieutenant Ladderette at 69 Wells in the driveway.
And you're referring to him as Lieutenant Ladderette. In fact, he was a sergeant at the time, correct?
That is correct, yes. Apologize.
Other than Lieutenant Ladderette and Sergeant Ladderette, was anyone else present at 69 Wells?
At that time, no.
What did you do once you arrived?
Sergeant Ladderette at the time, he had directed me into the garage. There's a 3-bay garage with a vehicle in the center bay, and he pointed out the what he had observed to be possible blood evidence on the vehicle.
And did you observe it as well?
I did.
Could you describe it for the jury?
So I had brought with me a large lantern spotlight, and when I utilized that to light up, to illuminate the side of the vehicle, you could see signs of wiping of a car that had been dirty but then had been wiped. As we walked around, noticed droplets of a red color on the side and on the front.
Attorney McGinnis, just for clarity, could you inquire as to which vehicle?
This was, sorry.
Yes, sir. Which vehicle are we referring to?
There was a Land Rover that was parked in the center bay of the 69 Wells garage.
After observing the blood-like objects and the car, the vehicle, what did you do next?
So we continued to walk around the interior of the garage where we located some more blood, suspected blood evidence. And it was at that point then that we stepped out of the garage and made the decision to secure the home.
Where did you see the additional blood evidence?
As we walked around
To the word blood, I think it's suspected.
Yeah, suspected blood. It's not, we don't know what it is.
Where did you see the additional blood-like evidence?
There was a what appeared to be a partial shoe impression on the concrete floor. There were 2 garbage cans inside the garage that upon further inspection, the left-hand portion of the lid had suspected blood. on that. Those blood droplets had a texture to them that was consistent to a texture that you would see on a kitchen rubber glove. There was a suspected blood droplet on the driver's side rear of the Land Rover. And then some areas on the concrete floor that appeared to have been blood evidence, suspected blood evidence that had been wiped up, cleaned up.
You mentioned the garbage can, I believe.
Yes.
Did you ever open either of those?
I did. I opened up both garbage cans and did a cursory look on the inside, and there were white, typical household garbage garbage bags that were in either one.
Now, after your observations, was a decision made to apply for a search warrant?
Yes. At that point, we stepped out, we secured, we consulted with our supervisors at the time, and I had made the decision that the Connecticut State Police Major Crime should be contacted for us to assist in processing the scene.
And the state police, they will routinely assist police departments like New Canaan with processing crime scenes if requested, correct?
That is correct. They have the resources, the manpower, and the knowledge and experience to do that.
And in New Canaan, you all work with the Western District, is that correct?
That's correct.
Now, as you were awaiting state police arrival, where were you?
We were in the driveway.
Was anyone allowed in the home?
No.
Approximately what time did the state police arrive?
Approximately between, I would say, the hours of 1 a.m. to 2:30 a.m.
And did someone from the state police named Sergeant Al Bisson arrive?
That's correct, yes.
And what was Sergeant Bisson's role with the state police?
Sergeant
Your Honor,
Bisson,
I'm going to object. It's cumulative, and this witness would only know from hearsay what another person's role from a different department was.
Well, the question is, what was Sergeant Bisson's role with the state police? Well, that's not the same as what did Sergeant Bisson do.
Take care, Charlie. I understand.
Did you speak with Sergeant Bisson?
yes, I did.
And did Sergeant Bisson, on behalf of the state police, make any offers to you?
He did. Sergeant Bisson was the supervisor of the Western District Major Crime Band at the time, and he had offered his services and also offered if I needed any other investigators or detectives for assistance.
And when he's offering any other investigators and detectives, he's offering state police personnel, correct?
That's correct. Yes.
Sergeant Bussin.
After he offered you this additional assistance, did you ultimately
He is on
accept it?
top of it.
Yes, I did.
And so as the night continued, the state police are arriving.
Yes.
Did you begin to receive information about a potential person of interest in the disappearance of Jennifer Dulos?
Yes, we had.
And who was that potential person of interest?
That was Fotis Dulos, her husband.
And who informed you of this information?
That was from the initial initial officers that had taken the missing persons complaint, Officer Kelly Coughlin.
And was Officer Coughlin working dispatch that night?
That's correct, yes.
Meaning that she's actually receiving 911 calls and things of that nature?
Yes.
And did you end up speaking with Mr. Dulos that night?
Not that evening. I spoke with Mr. Dulos the following morning. Sergeant Ferenga had spoken with Fotis Dulos that evening.
Now, I want to direct your attention to the following morning. Was there a command post set up at the New Canaan Police Department?
Yes, there was.
And what floor of the New Canaan Police Department was that located on?
The second floor in the investigations office.
And who was present at the command post in the early morning hours of May 25th?
Myself, New Canaan Sergeant Condos, New Canaan Sergeant Romano, New Canaan Sergeant Ferenga, Sergeant Al Bisson, Connecticut State Police. There was also Detective Chris Allegro, as well as several other Connecticut State Police detectives.
And Detective Allegro, what unit of the state police was he with?
Western District.
Was he with the van or major crime?
Major crime detective.
Now, at some point on the morning of Saturday, May 25th, did you make contact with Mr. Dulos?
Yes, I did.
How did you make contact with Mr. Dulos?
I had made a call to his cell phone.
Do you recall how you got his phone number?
That was delivered to me from previous coworkers that had already spoken with him.
And Did you make any requests of Mr. Dulos during that call?
I had asked if he'd be willing to come down to the New Canaan Police Department to speak.
And did he agree to do so?
Yes, he did.
Did the two of you agree on a time?
Not a specific time. Fotis had stated that he was in a meeting and that it would take him approximately an hour and a half to travel from Farmington to New Canaan.
And from the moment that you were speaking to him, what would have been an hour and a half?
So that was at approximately 9:30 a.m. in the morning.
So
11.
he would have arrived at approximately 11 had he left.
Had he left at that time, yes.
Did, was it your intention to interview Mr. Dulos with any other detectives?
Yes. Detective Chris Allegro from Connecticut State Police Mission.
And did Mr. Dulos arrive at 11 a.m.?
No, he did not.
Direct your attention now to approximately 12:30. Were you contacted by anyone on Mr. Dulos's behalf?
Yes, so at approximately 12:30, I had noticed that I had a missed call on my work telephone. And then I had also received an email from an attorney associated with Fotis.
And what was the attorney's name?
Jacob Prytanker.
Prytranker. And were arrangements made with Mr. Prytranker for Mr. Dulos and he to come to the police department?
Yes.
And did he indicate that he'd be accompanying Mr. Dulos?
Yes, he did.
Was there an agreed upon time that they would arrive?
Just that they would be down possibly around 2:30 p.m.
Now, I want to direct your attention now to approximately 2:40 in the afternoon. Did you receive any notifications from the New Canaan Police Department front desk?
Yes, so the dispatcher at the time had they called my desk to inform me that there were two persons in the lobby that were looking for me.
And did you go to the lobby?
Yes, I did.
Who, if anyone, did you go to the lobby with?
With Detective Allegro.
And when you entered the lobby, who did you see?
Fotis Dulos.
Could you describe Mr. Dulos' physical appearance for the jury?
Yes, he was dressed dark colored pants, shirt, and a sport blazer he was wearing.
And did you, Detective Allegro, and Mr. Dulos exchange pleasantries?
Yes, yep, we introduced ourselves.
Was Mr. Prytranker in the lobby at the time that you exchanged
No, he was
pleasantries?
not.
Where was Mr. Prytranker?
We had asked Mr. Dulos if his attorney was with him, and he had motioned to outside of the police department, and there was an individual outside pacing back and forth on a cell phone, and he had motioned that was his attorney.
When you say he's outside, did the lobby of the New Canaan Police Department have windows or?
Yes, there's windows, and there's the door is glass, so you can see outside to the parking lot.
And how was Mr. Prytranker dressed?
Professional suit.
Now, did Mr. Dulos offer to go get Mr. Prytranker?
So he stepped outside to go get him, and he returns back into the lobby again without the attorney.
And was there any conversation at that point about the police department being a secure area?
So I had informed Mr. Dulos that he would be going to sit down to talk. He's in a secured area, and that I would just need to ensure that he didn't have any weapons or anything on him. To which at that point he removed his wallet and keys and started to search for his phone.
And as he was searching for his phone, did he say anything?
Just he was initially looking for his phone, didn't know where it was.
Now, after Mr. Dulos was looking for his phone, did Mr. Prytranker enter the lobby?
Yes, he did.
And what happened next?
As he entered the lobby, Mr. Dulos had seen that he was holding his phone, and he goes, "Oh, there's my phone." And Attorney Prytranker had handed it over to Mr. Dulos.
And this occurred in your presence?
Yes, it did.
What happened next?
At that point, Attorney Prytranker had informed us that Mr. Dulos would not be meeting with us at that point.
And so after Mr. Prytranker indicated that Mr. Dulos would not be meeting with you, what happened next?
As Mr. Dulos was going to put his phone into his blazer, Detective Allegro asked Mr. Dulos if he could see his phone.
And did Mr. Dulos give Detective Allegro his phone?
Yes, he did.
What happened next?
At that point, Detective Allegro observed that the phone was secured, was locked with a numerical code, and he asked Mr. Dulos for his passcode.
And did Mr. Dulos provide the passcode?
Yes, he did.
Did Detective Allegro use the passcode to get into the phone?
Yes, he did.
And after he used the passcode to get into the phone, what did he do next?
He then placed it into airplane mode and informed that the phone was being seized.
Now, in your experience as a detective, are cell phones sometimes seized in criminal cases?
Yes.
Objection.
Well, in your experience as a detective, are cell phones sometimes seized? Well, that question, to use a colloquial phrase, is loaded.
Yes. It's a very loaded phrase.
What types of evidence from an investigative perspective can be found on cell phones?
Location data, phone calls, text messages, emails, pictures.
And when you say location data, what do you mean by that?
Anytime that a cell phone is used, it will record through metadata where the location at that incident taking place. There's various apps also that do the same. They will track your location. So either, for map guidance or whatnot.
Did you have a search warrant for the cellular phone at that time?
At that time, no.
Was one being drafted for the cellular phone?
Yes, there was.
Why was the phone seized without a search warrant?
I'm going to object to his subjective reason. We can get into the constitutional issues, but I don't think that's appropriate here. So I'm objecting on relevance ground.
Well,
I think that's a fair argument to
the
make.
short answer is going to be so that we could try to find what we want to try to find. That's the answer.
Yeah, but
The court's going to allow the question.
You can answer.
I
Can
know,
you
but
just repeat the
I get what he's trying to
Try.
do there.
Why was the cell phone seized without a search warrant?
To prevent the loss of any possible evidence that was on
Because
it.
we think he killed her.
After Detective Allegro indicated that the cell phone was seized, did Attorney Kreitschranker say anything?
Yes.
What did he say?
He had stated, why are you taking the phone, on what grounds, and asked if we had a search warrant.
And did Detective Allegro explain to him why the phone was being seized?
Yes.
At that point, did Mr. Kreitschranker and Mr. Dulos exit the police department?
Yes, they did.
And when they exited the police department, where did they go?
Outside, right in front of the main lobby doors.
Okay.
Were the two of them still visible to you?
Yes.
And at some point,
Like, seriously, if that happened the way it happened, where the attorney for this guy, Fotis' attorney, is just standing there, and the cop walks up to Fotis and says, "Hey, bro, can I see your phone real quick?" And the attorney wasn't like, "No, what are you insane? No, don't do that." Holy cow. Like, what the hell is going on? Why? That is bad attorney. That's bad lawyering right there. Why would you do that? That is just inexcusable. Well, no, give the police your stuff. Like, what the hell? My God. So dumb.
Mr. Kreitschranker come back inside the police department?
Yes, he did.
And did he demand the phone back?
Yes, he did.
And did Detective Allegro indicate that he was not going to be getting the phone back?
Correct.
Did Detective Allegro subsequently turn the phone over to you?
Yes, he did.
And what did you do with the phone?
At that point, ensured that it was in airplane mode, and then obtained the serial number and the IMEI number for records.
And did you also
For your
log the
warrant
phone to
also.
evidence?
Yes.
May I have this marked for?
That's just absolute
Believe it to be a full
garbage
show.
by the defense
What's
attorney.
the number, please?
Not these ones. Fotis Dulos'
Page
attorney.
17, admitted,
Absolutely
no
awful.
objection, full exhibit.
May I just have a moment, Mr. McGinnis?
Ugh.
Detective Patton, I've handed you what's been entered into evidence as State's Exhibit 17. Do you recognize State's Exhibit 17?
Yes, I do.
What is State's Exhibit 17?
This is the cell phone that was seized from Mr. Dulos in the lobby of the New Police Department.
And I'm just going to ask if you could just please take the cell phone out and hold it up for the jury. And what type of cellular phone is that?
This is an Apple iPhone
Do you know the model?
X.
You can put it back. And is this the cellular phone that was taken off of Mr. Dulos or taken from Mr. Dulos? Was a search warrant subsequently sought for Mr. Dulos' cellular phone?
That is correct, yes.
And how does law enforcement get information off of a cell phone? In other words, do you guys do a visual inspection of the phone? Do you guys do a download of the phone? What's that look like?
No, it's done through a forensic digital examiner that would conduct a download of the cell phone.
You're so bright.
And do you know a forensic examiner by the name of Michael Clark?
Yes, I do.
Is
Michael
Michael
Duncan
Clark
Clark?
affiliated with any police departments here in Connecticut?
He's a detective with the Fairfield Police Department.
Did you take this cellular phone that's been entered into evidence as State's Exhibit 17 to Michael Clark?
I did.
Why did you take it to Detective Clark?
Detective Clark had forensic software and hardware that was available, and he was also available to process on Sunday, 26th.
So you took it to him on Sunday, the next day?
Correct, the next day.
And were you present for Detective Clark's download or extraction of the cellular phone?
I was.
And as the phone was being downloaded, were you able to see some of the information that was being downloaded?
So yes, after the extraction was complete and was uploaded into the software that then parses the data so that you can see the data, you were then able to begin to look at some of the data that was being parsed.
And I want to direct your attention now specifically to location data. Was there location data that was parsed that you were able to do?
That's correct, yes.
And can you just
Yes, it was a very
explain to the jury,
crinkly bag.
The location data that you observed that was of interest to you?
So I'm going to object. There's going to be, I assume, information concerning that. This is not only hearsay, but it's a violation of the best evidence rule to have him testify as to what he saw on an extraction from a phone.
Well, the testimony so far is that the cell phone was taken to Detective Clark, who forensically downloaded it. And this detective observed location data. And the question now is what essentially else was observed that was of interest?
Now, what of the location data was of interest? Like, in other words, parsing from what was actually the download, not something else.
Well, there has to be a foundation that Detective Patton can read extracted data from a cell phone.
Well,
It's not written out in narrative paragraph form, so there has to be a foundation for that.
that does make sense. He has
So
to be able to
the judgment,
testify.
As it is sustained.
Yes, Judge. Detective Patton, when you are, when a phone is being downloaded, can you just explain to the members of the jury what the data looks like?
So when it's parsed into the software, it's grouped into categories so that you can easily search, such as pictures will be grouped into the picture category, location data will be grouped into location data, text messages will be grouped into text messages. So you can easily navigate through the information that was retrieved from the phone.
And what software allows that to be done?
This was Celebrate.
And Celebrite is a software company that has created a mechanism to download cellular phones.
Correct.
And so when you were reviewing the location data, what type of data were you looking at?
We were focused on the date of interest is when Jennifer Dulos was reported missing.
How does the location data come up on the cellular phone? What does it appear as?
It's sorted by date and time.
But I guess what I'm getting at is the location data itself. Is it latitude, longitude?
Latitude and longitude, and then the software will also give you a map.
When you say the software gives you a map, you mean it actually pinpoints where the cellular phone is at a particular time?
Correct, and it's displayed on a map similar to what you would see on like Google Maps on a phone. It shows you an actual it's not a satellite image, but a default image of a map of the location.
So was there any location data of interest to you that you observed on the phone?
Your Honor, if this is just a yes or no, I don't object. It's the next question that I would object.
So the witness may answer that.
Was there any
Well-
location data of interest that you observed on the phone?
Yes.
What was that location data?
Objection.
Ground.
Hearsay, foundation, this is not the witness who can testify to that.
Well, it's not
and
hearsay.
It's not the best evidence. It's my understanding if they have this data, they can produce it. But this witness simply can't say any more than you or I can say, oh, well, the computer produced this and now I see certain things. So I object on that basis.
Well,
It's not
court's
hearsay.
view is this: if the witness has testified that what is seen is a date and a map, then the witness can testify what he saw on the map. That is the witness's personal knowledge as to what he saw on the map. So
Because that would not be hearsay if you said I looked at a map and it
So
said this.
we observed that there was a route that was taken to Albany Avenue in Hartford on the evening of May 24th,
And do you recall approximately what time that route was taken?
approximately 7 p.m.
Where had the phone been in the morning, according to what you observed?
Could I just have a running objection to all of this?
yes, well, again, the court thinks the objection is well taken. If there's a map, then that map is either a point in time or it's a map where you're looking at the course of a route over an extended period of time. So the question, what else suggests to this court that what this officer observed is not simply a point
map.
in time on the map?
Yeah.
So there has to be a foundation as to how he would determine where the device had been hours earlier.
How did you determine where the device had been hours earlier?
through the location data of the phone.
And so can you just explain to the members of the jury how you're able to do that?
Well, again, I'm going to object. He testified he didn't do it, and it's not even his program. So I think this is the wrong witness for that aspect of it. I certainly didn't object to the general explanation of what he brought and saw someone do, but now for asking him to interpret the data is where I object.
Real quick, Joe Loy for £5 sterling, the King sterling, saying night to you and your beautiful soon-to-be ex. Well, thank you. Thank you, Joe. I understand what the defense attorney is saying there, but I still think they're going to go back to the issue of I can read a map. That's not hearsay. Or what are the clock, what time was on the clock? When you looked up what time was on the clock, that's not hearsay. I think the court's going to allow him to say the map because he's just reading it, and they can bring it in. But I think he's going to let us say what he saw. I don't know.
I couldn't cross-examine this witness about specifics without actually having those documents through the witness who produced it. I may not require that person. I'm just saying I don't think he's the right person.
Right. Well, it would appear that the question the court would have is, how does this mapping of a device work such that you can follow it over the course of a number of hours?
Try to ask the judge this question. How does the mapping work so that you can follow it over a number of hours?
I'm not an expert witness in the behind the scenes of how the software was developed and how they gather the information.
Oh, wow.
But my understanding is
Well,
that
then I'm going to object to his then.
Yeah, he can't comment. I'm not an
Then the
expert.
question is, how do you
Done.
come to the conclusion as to Albany Avenue, other than, well, the court does not even know what the answer is to other than.
Yeah,
How?
because
you come to
he
the
doesn't know what the
conclusion
other than
The
is.
device was on Albany Avenue.
Okay,
based on
I
the
got it.
forensic
I buy that.
You can answer that question.
because the phone captures location data when it's being utilized, and then the software will parse that and easily show the location data in a chronological order, and you can follow that through and tab through each location, and it will then update you and show you the location that the phone was in on that particular date and time.
So the court understands the testimony to be that the forensic download will show a date and then perhaps longitude, latitude at a certain time. But it won't say the phone was on Albany Avenue.
Is that correct, sir?
That's correct.
So how do you determine where the phone is?
Well,
By either inputting the Latin long into a mapping software, but Cellebrite also gives you the option that you can also see that they pre-map it for you. So you can actually see on another screen the location.
And based on your observations of the latitude and longitude showing the phone near Albany Avenue, did you alert any other law enforcement personnel to that information?
Yes, I had reached out to the detectives that were back at New Canaan Police Department and elsewhere of the finding.
May I just have a moment, Your Honor?
Yes.
I have nothing additional.
So I take it, I'm not going to ask you a lot about that. I take it you are not an expert then in either the Cellebrite input or reading the data in its raw form, correct?
So I do have training and certifications in Cellebrite certified operator and Cellebrite physical analyzer.
Did you have that in
I
2019?
did this.
All right, but you didn't want to do this yourself?
At that time, I did not have the experience.
Oh, that's what I'm talking about. In 2019, you did not have the
Correct. I
experience.
started with the Technical Investigations Unit in 2018.
You started in 2018, but this happened in 2019. Are you saying, though, you did not yet have sufficient experience to be able to interpret it, right?
Correct.
So it's more like if somebody prints something out, I could look at some data and then try and follow the instructions and punch it in and come up with some locations, basically, right?
You're not coming up with the locations. The software does
The
that.
software does it. Okay, fair enough. So let me move away from that for a moment. I'm going to ask you about your earlier testimony. You said you went to Waveney Park. Is that right?
Lapham Road near Waveney Park.
On Lapham Road, adjacent to Waveney Park, correct? And you said something about seeing Officer Blank there, right?
Yes.
And you also said you observed a canine police dog in the area of that.
I did not observe the dog.
You did not. Then you just heard about it?
I was informed that there had been a dog there, yes.
Oh, so were you also informed that there were other canine dogs that had been dispatched from state police or from other police departments to also search?
Correct.
So you were, and so as at that time, the chief investigator on this investigation, you're aware that Officer Blank then went into the woods with one of those canine units, correct?
Correct.
You know that they followed a scent to the Talmadge Hill Metro North Station, correct?
Correct.
And that's where they
Wow.
lost the
Okay.
scent, right?
Correct.
run with it.
You
Holmes.
testified that either late on the night of May 24th or early in the morning of the May 25th that Mr. Dulos had a telephone conversation with Sergeant Ferenga. Is that correct?
That's correct, yes.
Now, he's no longer, he's higher up now than a sergeant,
Correct.
right? But at the time, he was a
At the
sergeant,
time, he was
right?
sergeant,
A
correct.
uniformed officer?
He was in the Detective Bureau.
He was in the Detective Bureau at the time.
Correct.
And he received a call from Fotis Dulos. Is that right?
He had made the phone call to Fotis.
He made the call.
Correct.
And he spoke to Mr. Dulos for some time that night, didn't he?
I don't know how long, but he did speak with Mr. Dulos, yes.
And earlier than that, Mr. Dulos had actually called the New Canaan Police Department and spoke to dispatcher, that was Officer Coughlin, correct?
That's correct.
And that was shortly after, as I understand it, a Farmington police officer had notified him that his wife was missing, right?
Correct.
And that conversation went on for a little bit of time, didn't it?
I wasn't there. I don't know how long it was.
Again, you were informed of that by, who was it, Officer Coughlin?
Yes.
And you were also informed about the longer conversation that Mr. Dulos had with Sergeant Ferenga, right?
Yes. I don't know how long the conversation was, but yes.
But you were made aware of it that night, is that
Correct.
correct?
Mhm.
Thank you. Is that a yes?
Yes.
No further questions. Thank you.
Okay, that was
Yeah,
short and
we do that.
effective.
No, Judge.
Thank you. Detective, you may step down.
Thank you.
Well, it makes sense to conclude today's proceeding. Attorney Manning, Attorney McGinnis, do you have the court is not asking who, but do you have your lineup ready for tomorrow?
Yes, Judge.
Could we have a quick sidebar about scheduling?
Right. Well, the court remembers what we discussed. So,
Yeah. I want to make sure that the jury was aware.
we'll inform the jury tomorrow. Thank you. Ladies and gentlemen, that concludes today's proceeding. We thank you for your attention. We ask that you be ready tomorrow at 10 o'clock. Please do not discuss the case.
Okay, so you guys wanted how Michelle.
This honorable Supreme Court now stands adjourned.
you guys wanted to know, how does Michelle Troconis fit into this? Well, here we go. Claude saying, should they give judges training in the software? No, because it's not their job to know. It's a state's job to explain what their witness knows and what he doesn't know. So no, they don't want to be known. They don't want to know that software. So, it's very interesting in that regard. We're going to find out who Michelle Troconis is. We found out who she is, how she came into this, that she's the other woman. And now we're finding out what happened after. And now we're getting into that part of Michelle's disappeared. The phone's there. They now have locations where the phone went. Come on, focus. Focus. Let's go. Focus. There we go. So now we have that done. And we've got that part. Do you guys want to watch part of day 5 tonight? That last attorney seemed really raring to go. Yeah, he's the head of her team. He's the head of Michelle's team. So yeah, they're ready to rock and roll. We can. I mean, there's some. It's apparently gets even better because now we're getting to the nitty gritty. And also there's some issues, I guess, that happened tomorrow or today too. But that was quick. I mean, we fly through it. We can do it at speed. All right, guys. So we're gonna get this started. This is we'll roll right into day 5. I guess keep going. All right. Carrie says keep going. Yes, we'll do it. All right. This is who we are says no one will be streaming tonight. Maybe, but I was thinking about after we get this done, I might do like a normal stream tonight too. But we'll see what we get done in time. All right. So share screen. All right.
Please be seated. Thank you. Have you concluded your discussions, Attorney McGinnis?
Good morning, Judge. Yes, we have. I believe the defense is signing the stipulation right now. There's 2 stipulations, Your Honor, relating essentially to chain of custody issues with respect to evidence that Detective Riley seized and was subsequently submitted to the state laboratory. I'll just indicate that the defense has asked that the state ask a few clarifying questions on direct examination of this witness, essentially indicating that most of these swabs taken by Detective Riley were not tested for confirmatory human blood testing at the laboratory, that they were simply sent for DNA analysis. And I indicated to counsel that I didn't have an objection to asking those questions. The witness who ordinarily would testify to that is expected to testify sometime next week or so, depending on how the schedule goes. But just to short circuit it, I'm just going to ask those questions.
So what the court will probably do is ask that the stipulation be presented to the court after the state's questions.
So, Judge, if I may,
unless there's cross-examination.
Well, there's another reason maybe not to do that. It's, and if I may interject, I think this is why we're agreeing to this. What this is basically a flow chart. We're skipping some of the chain of custody material. So to facilitate that flow, it may be necessary at least to put it up or to mention it beforehand, only because this witness is going to be testifying to testing things that came from, it makes it sound like it was picked up at the garage and whisked to her office, when instead there are a couple of intermediate steps that would need to be clarified. We don't need to do it in cross-examination. If it goes in this way, at least it explains that skipped step, if you will.
So you have the flow chart, correct?
It's not in a chart form, but it's essentially that. Yeah.
My intention, Your Honor, was essentially to publish the stipulation with each exhibit so that this was identified as State Police 12. It was submitted to the state laboratory and re-designated as laboratory submission 2, for example. And then can you please tell us the results of 2? If I can sort of go through it that way. And so I'm going to publish the stipulation as we go along. If the court would like to review it in advance, I'm happy to tender that now.
Well, what the court has to do is explain to the jury what a stipulation is.
Of course.
And so what the court will do is wait for counsel to
Still
indicate
may watch Attorney
that
Tom.
it may be an appropriate time for the court to explain what a stipulation is.
I don't
Yes.
know if we've signed the stipulation.
It's appropriate time for me to explain what a stipulation is as well. A stipulation is both parties agreeing to a fact. At that point, they are agreeing to something. In this case, they're agreeing that the chain of custody, so the process of how these things were picked up, which, like, you know, Sergeant Bob bagged it, and then Trooper Sally picked up the bag, and she took it to the station. Both sides are agreeing to skip that because the chain of custody is not a concern in this case. There's not an issue of, well, you guys let Bob take it, and we know Bob's a drunk idiot. There's no questions about that. And they're trying to skip some steps here because this is literally just going to drag on. And this is attorneys working together, and the courts appreciate this. These guys are working together to try to make the trial move because the judge does not want this just to drag on. If there's stuff that has to be proven and there's stuff you guys can't agree on, fine. You fight over it and you do it. But every judge is going to say, what can you guys agree to? And can we do that? Now, the thing is, Michelle Troconis has to agree to these stipulations. If she doesn't agree to them, you know, that's a big deal because that's, you know, agreeing to facts in the record there. I mean, that's something that, you know, she has to generally approve of as well. She can't just be like, wait, I didn't agree to any of that. So that is where the stipulation comes in. And, you know, the way it works is that stipulation becomes an exhibit and it gets submitted. And the jurors are told, this is a fact. You cannot question it. This is literally something you have to accept. It is a fact we are agreeing to. So therefore it is established. And they'll get it in written form. But it does sound like they have to do some clarifying before they introduce the thing.
And there's two stipulations. There was one other, I think it's just that there was one additional remark that it's not just that several of these things were not tested, but that some were tested and were negative for blood. And the reason this is important is the stipulation uses the same name that the police used, and it often mentions Castlemeyer and luminol. And of course, this goes back to whether, you know, my concern about it being in it all, but since it is, for most of these, there was never a confirmatory test, and then some that were tested came back negative. It would give the false impression, perhaps, to the jury that when there was DNA, that it was blood DNA, when in fact it was skin cell DNA, even though it was taken from something called a blood-like stain that tested positive for KM. But it's to get that clarified because of the reference to those reagent presumptive tests.
Well, are we ready to proceed?
There's just one other thing I want to put on the record, and the state did share this with us, and I just want to raise it now so it doesn't happen in the future. The witness who was here yesterday had been instructed specifically by the state not to mention a firearm. So this is a witness who then apparently deliberately violated an instruction, and that's why I wanted to let the court know that if we have concerns about any other witness, we would need to have either a sidebar or a discussion outside the presence of the jury. Perhaps if the court had admonished the witness, she wouldn't have disobeyed the instructions by the state.
Well, the court would not have known that the state instructed the witness not to mention firearms.
Your Honor, if I can just be heard on that, I don't think that Ms. Almeida deliberately violated any sort of instruction. The question was phrased by me, I think, a little inartfully. I had not appreciated the fact that she had mentioned the gun when asked whether or not, you know, what she had relayed to the police. I was expecting to just hear that there was a missing mother, you know, she apparently misunderstood, and so it was completely inadvertent. You know, as the court knows, what we're doing here is a tightrope act, and these things are going to happen from time to time. But yes, the witness was instructed not to mention the gun, and you know, unfortunately, you know, what happened. But I don't.
It does happen.
Deliberate, you know, attempt to circumvent the instruction by the state. And I'll also just add, Judge, that I had actually offered for Ms. Almeida to be present in the room during the offer of proof and the argument on the uncharged misconduct, and the defense did not want her present. And I specifically indicated that I would hope that she would be present because in case there was an issue. So perhaps that is another way to handle things in the future, that the witness could actually be present for some of the arguments so the witnesses understand exactly what the scope is. And I indicated at that hearing that I would not be eliciting evidence of the firearm. So I just want to say that I think it was completely inadvertent. And
if you tell your witness what the scope is, they don't need to be in here for the argument.
For the jury.
Yes,
because that may reveal defense strategy. No, tell your client, tell your witness what the thing is. So this will be we're gonna go, guys. Here we go. Here we go. Yahoo!
Counsel stipulate to the presence of all of the jurors.
Yes,
Yes,
sir.
Judge.
Thank you.
That is
Your
not
Honor, state call,
something
Mr.
I've
Nadeau.
seen judges do in my area. Do you agree all the jurors are here?
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm as the case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Can you please state your name and spell it for the record?
Kristen Madel, Kristen Madel.
And your affiliation?
I work at the forensic lab.
Ma'am, you may be seated. Thank you.
Good morning.
Good morning.
Ms. Maydell, who employs you?
The State of Connecticut Forensic Science Laboratory.
Where's the Forensic Science Laboratory located?
It's located at 278 Colony Street in Meriden, Connecticut.
How long have you worked for the State Police Forensic Laboratory?
Next week will be 20 years.
What is your position in the lab?
I'm currently a forensic science examiner 2 in the DNA unit.
What are your duties at the laboratory?
My main duties are to extract DNA from items of evidence that may contain biological stains or material. I perform analyses. I develop a DNA profile when possible, write reports, and testify in court when necessary. I also am a supervisor in the DNA unit, so I supervise 2 FSC 1s or forensic science examiner 1s within the unit on their daily duties. I am
Oh wow,
the
she
quality
talks
control
fast. Oh
coordinator
my
for the
god.
DNA
Oh my
unit
god.
and-
Oh my god, she's way too fast.
Concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon
Sorry guys, she's like a machine gun. We gotta slow her down.
Spell it for the record.
Kristen Madel, Kristen Madel.
And your affiliation?
I work at the forensic lab.
Ma'am, you may be seated. Thank you.
Good morning.
Good morning.
Ms. Maydell, who employs you?
The State of Connecticut Forensic Science Laboratory.
Where's the Forensic Science Laboratory located?
It's located at 278 Colony Street in Meriden, Connecticut.
How long have you worked for the State Police Forensic Laboratory?
Next week will be 20 years.
What is your position in the lab?
I'm currently a forensic science examiner 2 in the DNA unit.
What are your duties at the laboratory?
My main duties are to extract DNA from items of evidence that may contain biological stains or material. I perform analyses. I develop a DNA profile when possible, write reports, and testify in court when necessary. I also am a supervisor in the DNA unit, so I supervise 2 FSC 1s or forensic science examiner 1s within the unit on their daily duties. I am the quality control coordinator for the DNA unit also, which means
She
that
gets a good
I
Adderall.
make sure that all the reagents and consumables that we use in our DNA testing process are checked before they're put into use for casework. And I'm also the contact person for missing persons cases that require DNA testing.
Is that it? I mean, like, you. Are you sure there's nothing else you
I'm gonna
do?
send you
Jeez.
several exhibits that have been marked for identification in states 18 through 28. I'm just going to show you States Exhibit 18 first. What is States Exhibit 18?
This is my CV.
And I have provided a copy of that to make sure I'm moving into evidence.
Can I just see which one it is, please? It's referenced by number, so if I could just look at the. No objection.
That states 18.
It is, Judge.
States 18 will be admitted as a full exhibit.
I'm also going to hand you States 19 through 26 for identification purposes only, and just ask that you hang on to those for now. And if I could just have a brief moment with Attorney Schoenhorn. That's fine. Now, you mentioned that you work in the DNA portion of the laboratory. Can you tell the jury what is DNA?
DNA stands for deoxyribonucleic acid, and it's the hereditary material found in a cell that makes you who you are as an individual in an organism. DNA is passed from parent to child, where you get half your DNA from your mom and half your DNA from your dad. And nuclear DNA is unique to an individual, except for identical twins.
Before you proceed, ma'am, there's an interpreter. So we would ask that you would just slow down your delivery so that the interpreter can interpret accurately.
Okay. No
Thank
problem.
you.
What are some sources of DNA?
You can get DNA from cells in your body. So cheek cells within.
Okay, oof, guys. Like, she adds buffers and grinds things and tries to make statistics look better in her favor. Jeez, the scientists are being rough right now. I'm surprised you guys aren't making jokes about a chromosome, but okay. I'm just waiting. I'm disappointed.
Your mouth, blood, saliva, body fluids such as semen. There's DNA in the roots of your hair, nuclear DNA, bones, and teeth.
What is the purpose of DNA testing?
DNA testing is a forensic tool of comparison. So we want to try to include or exclude a possible person as being a contributor to that evidentiary profile. So we develop a DNA profile from a known profile and the evidence, and we compare those to see if they match.
How do you obtain a DNA profile?
We use standard protocols and procedures that are accepted throughout the United States and the world. First, you want to get the DNA out of the cell. So you open up those cells and extract the DNA. Then we want to see how much DNA we have. So we want to quantify that DNA. After we know how much DNA we have, we want to go make many more copies of that DNA. So we amplify it, think of a photocopier. And then after that, we want to separate those DNA types so we can develop a DNA profile, which is represented by a series of numbers.
Approximately how many DNA profiles do you typically compare to evidence in a given year as either a primary analyst or a technical reviewer?
Oh, thousands.
Does your equipment also have the ability to tell you whether or not one or more of the contributors to a DNA profile are male or female?
Yes.
What is a mixture?
A mixture is when you have a DNA profile that is more than two or more people contributing to that profile. So to give an example, like I said before, you get half your DNA from your mom and half your DNA from your dad. So if your mom gives you one type and your dad gives you that same type, you might only have that one type represented at any specific test site. If your mom gives you one type and your dad gives you a different type, you would have two different types at that test site. So if there's ever evidence of 3 or more types at a particular site, that's evidence that it's more than coming from more than one person.
Are you familiar with the term trace DNA?
Yes.
What is trace DNA?
Trace DNA is DNA that is left behind when it comes in contact with a person or an object.
Is it possible to touch something or come in contact with something and your DNA not be detected during testing?
Yes, that is possible. It depends on how long you touch something, how hard you touch something, what the substrate is, and how much DNA can get left behind.
What is primary transfer?
Primary transfer of DNA is when you transfer DNA from a person to an object or a person to person.
What is secondary transfer?
Secondary DNA transfer is when DNA can be transferred from a person to an object, from a person to an object to a person, from a person to an object to an object. Oh, I said that one already. But yeah, those are some examples.
And in doing your analysis, you reach certain conclusions. Is that correct?
Yes, but after we make a comparison between the evidence and a known profile, we would have a conclusion, correct?
I'd like to talk to you about different conclusions and what those mean so that the jury is clear. When you reach the conclusion included, what does that mean?
An included conclusion would mean that the types in the known profile are present in the evidentiary profile where there are results.
What does the conclusion cannot be eliminated mean?
Cannot be eliminated is a conclusion where you have a partial match between the known types and the evidence where results are detected.
What does the conclusion eliminated mean?
Eliminated is when the known types are not present. Some of them or all of them are not present in the evidentiary profile.
What does your conclusion consistent with source mean?
Consistent with source is when the known types are present in a single source profile where results are obtained.
And what does the conclusion consistent with contributor mean?
Consistent with a contributor is also a conclusion where a person's types are present in a mixture profile where there's results.
Are you familiar with the acronym STR?
Yes.
What does STR stand for?
STR is the actual type of nuclear DNA testing that we do. It stands for short tandem repeats. And this is type of DNA testing that is used throughout Connecticut and the world. And you are basically looking at length variant repeats. So at any particular site, like I was talking about before with the different types, those types are represented by a number, and that number is because of the number of repeats at that site. So you think of it as a train, and every train has a engine car and a caboose, but the number of train cars in between those are the repeats and the different lengths. So I may have 15 train cars in between, but you may have 16. So those are what we're looking at.
Are you familiar with something known as STR mix?
Yes.
What is that?
That is a software that is used to help the DNA analyst interpreting the DNA profiles.
Are you familiar with the term likelihood ratio?
Yes.
What is that?
A likelihood ratio is the evaluation of the weight of the evidence under alternate hypothesis. So that's the statistical weight that we give to a conclusion that is at a positive association. So you have some kind of weight to what that conclusion means.
At the laboratory itself, what types of steps do you take to ensure there is no contamination from sample to sample?
Sure. We always wear lab coats, masks, gloves, hair nets when we're processing samples in the laboratory. We use bleach and UV light to clean our surfaces, and we have separate testing spaces for our known profiles versus our question samples.
When a case gets assigned to the laboratory, does it get a particular case number?
Yes.
I want to direct your attention now to a laboratory case number entitled BSS-19-002984. Did you conduct DNA analysis under this laboratory case number?
Yes, I did.
And was this laboratory case number associated with the New Canaan State Police investigation into the disappearance of Jennifer Dulos?
Yes, it was.
And in terms of doing DNA analysis, what do you need as a forensic scientist to do a comparison between a particular person and a DNA profile found on a piece of evidence?
I'm sorry, can you repeat the question?
Sure. So how do you do a comparison between a particular person and an item and a DNA profile that you find on an item of evidence?
Well, you have to develop a DNA profile for both of those. You need a known sample from that individual or person that you want to compare the evidence to.
You mentioned a known sample. What is a known sample?
A known DNA sample is a sample taken directly from a person that you know it's coming from, that source. Typically swabbing up the inside of your cheek swab.
Are you familiar with the term pseudoknown?
Yes.
What is a pseudoknown sample?
A pseudoknown sample is a sample that's typically a piece of evidence that you gather from a person that you think their profile would be on, and it would be a single source because you can't collect a buccal swab from that person. So a good example of this would be a toothbrush. You should be the only person on your toothbrush. And then we could develop a DNA profile from that to use for comparison.
In connection with this particular case, did you receive known DNA samples from several individuals?
I did.
And perhaps I'll just read them. Did you receive known DNA samples from Fotis Dulos, Michelle Troconis, Lauren Almeida, Joel Gumieni, Petros Dulos, Theodore Dulos, Christiane Dulos, Constantine Dulos, and Noel Dulos?
I did.
Now, when a known DNA sample is processed at the laboratory, who typically processes that sample?
Typically, the knowns are done in a separate section of the lab to keep them separate from the evidence. And we have a separate section of people who process those knowns. I actually processed the two from Fotis Dulos and Michelle Troconis myself because I believe it was a sample that needed to be processed quickly. So I did them by myself and didn't wait for someone in the known section to do them.
So essentially, the ordinary process is a known DNA sample is extracted by someone else in the laboratory, and then you ordinarily review that data and compare it to the samples found on the evidence. Is that correct?
Correct. Yes, it's done in a different part of the lab. It goes through the same process. It's analyzed, it's reviewed, and then that final profile is given to me so I can use it in comparison to the evidentiary profiles that I have.
You mentioned in this case that you personally did the extraction for the known DNA samples of Fotis Dulos and Michelle Troconis. Is that correct?
I did, yes.
Did you do any other extractions of what would be considered a pseudoknown sample?
I did. I processed the toothbrush.
Were you able to generate a DNA profile from the toothbrush?
I did.
Your Honor, perhaps this would be an appropriate time to present the stipulation.
Yes.
This has been marked as State's Exhibit 27 and 28. 27 is entitled a stipulation regarding evidence seized from 69 Wells Lane, a 2014 Range Rover. And State's Exhibit 28 is entitled stipulation regarding evidence seized from Jennifer Dulos' Chevy Suburban.
Thank you. Ladies and gentlemen, what the state and the defense have agreed upon is contained in what is called a stipulation. It is signed by both parties. A stipulation is an agreement as to certain facts. So you will have an opportunity at the appropriate time to review those stipulations. Again, those stipulations concern an agreement between the state and the defense as to certain facts. Do you wish to publish it now or no?
I'll publish it as we proceed with the direct, Your Honor.
Thank you.
Are you familiar with something known as a parentage analysis?
Yeah, parentage comparison is when we compare to see if a parent can be the possible donor to that child's DNA. So we do a comparison and then a statistic to show the frequency of people who could be a parent to that child.
And did you do a parentage analysis in this particular case?
I did. I compared the toothbrush to one of the Dulos children.
If I can just approach.
I'm not eating anything. I'm cleaning this out.
This is stage 29 for identification, Your Honor.
Thank you.
Can I just look at it, please? Thank you.
By agreement, Your Honor, I think State's Exhibit 29 can become a full exhibit.
Stage 29 admitted as a full exhibit.
Handing you State's Exhibit 29. You indicated that you had done an analysis of the profile that you obtained from the toothbrush to Fotis Dulos. Is that correct?
Yes, this is the report I generated with that comparison.
And can you tell the jury what your conclusion was?
My conclusion was the source of the DNA profile from a swabbing of the electric toothbrush is consistent with being a parent of Fotis Dulos. The expected frequency of individuals who could be a parent of Fotis Dulos is less than 1 in 8.1 billion in the general population.
Now, when evidence comes to the state laboratory, is it given a submission number?
Yes, when a submitting agency brings any evidence to the lab, it's given a unique case number, which we discussed is this DSS 19-002984, and then each piece of evidence is then given a number underneath that case number.
And what was the submission number for the toothbrush in this case?
Submission number 7.
Now, ordinarily, if there is swabs taken by a police department and submitted to the state laboratory for further forensic analysis, where's the first stop for those swabs?
If there's just a DNA request, those swabs would go to the forensic biology unit, where they would prep those swabs for the DNA unit. So the person would just basically cut the cotton swabs off the tip and put them in a tube for DNA.
And are you familiar with someone named Christine Roy?
I am. She's a forensic scientist in the forensic biology unit.
And she has since retired, is that correct?
That is correct.
But she did most of the cutting in this particular case, is that correct?
From what I recall, yes.
And when a swab is cut off by forensic biology and submitted for DNA analysis, does that get an additional submission number?
Yes, it gets what we call itemized. So if the parent item is number 1, then when they cut that swab off, they'll designate it as either a 1-1 or a 1S1. Since it's been 5 years, the evidence nomenclature has changed a little bit, but it gets a sub item of that parent item.
And many of these swabs that were submitted were described by the state police as being KM positive. Are you familiar with that term?
Yes.
What does that stand for?
KM is Kasselmeyer is a chemical screening test for the presence of blood in a sample.
Many of these swabs, though, were not tested at the laboratory for confirmatory blood. Is that correct?
That is correct.
And some actually were tested additionally by the laboratory and came back negative. Is that correct?
For confirmatory testing or KM?
I believe for KM.
There might be some results in here that we did do KM testing on some samples. I can't recall exactly, but.
Okay. And if I just have a moment to reach on. And just to be clear, most of these swabs were not confirmatory tested for blood either. Is that correct?
Correct. Confirmatory test would be a separate test than KM. KM is a screening test.
Now, you've indicated that you did analysis in this case. Is that right?
Yes.
Okay. I'd like to talk to you about some of the results, if I could. We could just pull up the first one, please. Your Honor, I'm publishing on the screen a photograph which is found in State's Exhibit 9, Folder 3, specifically Photograph 2. And I'm just going to publish the stipulation at this point. State Police Exhibit 9 was seized from 69 Wells Lane by Detective Riley on May 25th, 2019, and identified as 2 swabs from the scene, exterior handles of the mudroom back door, and was subsequently submitted to the Division of Scientific Services and designated as submission number 2. And Ms. Maydell, just for your benefit, this is referred to in DNA Sup 1, Sup 9, and Sup 18. Could you tell the jury what your conclusions were with respect to submission number 2?
Sure. So for the first report that it was reported in is supplemental DNA report, and it is item 2S1 was the swabs from, quote, exterior handles of a mudroom back door. The results are consistent with the DNA profile from item 2S1 being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 2S1.
May the interpreter request that you speak a little bit slower.
Sorry. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Fotis Dulos could be a contributor to the DNA profile from item 2S1.
And what about the defendant?
Michelle Troconis is eliminated as a contributor to the DNA profile from item 2S1.
And
Could we have a sidebar for a moment, Your Honor?
Yes.
Sure what the sidebar, it's not going to be critical if they're sidebarring it. Although this is still all on the record. So, bye, Franz, you're taking off. All right, well, have a good one. No, I am cleaning out a 3D printed magazine. So that's what I'm doing right now. So let's see here. Let's, there we go. Okay, this is the only problem. Whoever's in charge of the audio is
from that calculation is above what our elimination range is, but below what our positive association is. So therefore, we cannot reach a conclusion for that particular comparison.
And eliminated?
Eliminated is when the likelihood ratio is below our positive association, so we eliminate them, a negative likelihood ratio.
And just staying with lab submission 2S1 specifically.
Make sure that testimony is clear to the jury. Just using a narrative form, Ms. Maydell, inconclusive means you can't tell, correct?
Correct. I can't eliminate and I can't do a positive association. There's no conclusion can be made for that particular comparison.
Thank you. Are there any questions based on the court's question?
No, Judge.
Thank you.
Staying with item 2S1, directing your attention to DNA supplemental report number 9. Did you do additional analysis with known profiles?
Yes, I made big one, sorry.
That's okay. I know it's a lot.
So the conclusion I made in this report was 2 different knowns. So the conclusion is the same as the results are consistent with the DNA profile from item 2S1 being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 2S1. The results do not support the hypothesis that Lauren Almeida is a contributor to this profile. Assuming 2 contributors, Lauren Almeida is eliminated as a contributor to the DNA profile from item 2S1. And also Pavel Gumeni is eliminated as a contributor to the profile from 2S1.
And they're going to say Fotis is not. I guarantee that's how they're going to go with this. The Fotis was not ruled out.
This is paragraph 2 of State's Exhibit 27. State Police Exhibit 10, which was seized by Detective Matthew Riley from 69 Wells Lane on May 25th, 2019, and identified as 2 swabs from the scene, the interior handles of the mudroom back door, was subsequently submitted to the Division of Scientific Services and designated as submission number 3. And this is in DNA supplemental report number 1. Can you tell the jury what the results of your analysis were for that particular item?
Do I have, it's supposed to be State's Exhibit number 27, you said?
Ms. Maydell, it'll be DNA supplemental report number 1, which is in front of you. State's Exhibit 27 is the stipulation that I made.
Oh, okay, sorry. Was lab item number 1?
Lab submission number 3.
3, sorry. Yes, sorry, found it. That was bag with 2 swabs, and the sub item was called swabs from, quote, interior handles of mudroom back door.
And what were the results?
For item 3S1, there was no DNA profile detected.
What does that mean when no DNA profile is detected?
There just was not enough DNA there to detect a profile, so I have no results.
Remember, guys, that touch DNA, we talked about that before. You don't always leave DNA.
To the jury, Your Honor, photograph contained in State's Exhibit 9, folder 3. This is photograph number 18, and it displays the garage door opener at 69 Wells Lane. This was identified as State Police Exhibit 11, 2 swabs of the exterior garage door opener open keypad from the center bay, and was subsequently designated as lab submission number 63. And I'm just reading from paragraph 3 of our stipulation.
If you could read a little slower, please, Attorney McGinnis.
I'm sorry. I apologize, Your Honor. It was designated submission number 63. And for your benefit, Ms. Maydell, it's found in DNA supplemental reports number 2, 9, and 18. Was this given a sub-item as well?
Yes, so 63S1 was a designated swabs from, quote, garage door opener keypad.
And what were the results of the swabs from the garage door opener keypad?
The results are consistent with the DNA profile from item 63S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA from the swabbing of the electric toothbrush, Fotis Dulos, or Michelle Troconis are contributors to this profile. Assuming 2 contributors, the source of the DNA profile from the swabbing of the toothbrush, Fotis Dulos, and Michelle Troconis are eliminated as contributors to the DNA profile from item 63S1.
And you did additional analysis in DNA supplemental number 9 with known profiles, is that correct?
Correct.
And what were the results after you had a chance to look at the other known profiles?
It was nobody.
The results are consistent with the DNA profile from 63S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 63S1 is at least 45,000 times more likely to occur if it originated from Lauren Almeida and 1 unknown individual than if it originated from 2 unknown individuals. The results do not support the hypothesis that C. Noel Dulos is a contributor to this profile. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to the DNA profile from 63S1. Petros Dulos, Konstantin Dulos, Christiane Dulos, Theodore Dulos, and Pavel Gumini are eliminated as contributors to the DNA profile from item 63S1.
And just to sort of short circuit this, going forward, with the court's permission, if the other children are eliminated, you could just say the other Dulos children are,
Okay.
Just to sort of streamline it.
Sure.
I'm displaying for the court now State's Exhibit 9, folder number 2, picture 7, which shows the mud door handles, Your Honor. And with respect to the stipulation, it's agreed that this is State Police Exhibit 12. It was seized by Detective Riley and submitted to the state.
So we're gonna get the. She's gonna be the one who says there's no.
Talk to you about this.
There's nothing on the concrete swabs.
Were swabbings taken of this particular object?
Yes.
And unlike some of the other objects where the swabs came in from the police department, Ms. Roy actually did these swabs. Is that correct?
Yes, that is correct.
And how many swabs did she take in total?
On my supplemental DNA report, I have 2, 4-1S1 and 4-1S2.
All right. And I'd also direct you to DNA sub 2. I believe there's also 4-1S3. And
Correct, yes.
4-1S4. So there were 4 swabs total taken of these?
Yes.
Okay. Just beginning with the first swab, 4-1S1, what were the results for that swab? And this will be in DNA sub 1 and sub 9.
The results are consistent. The 4-1S1 was designated a reddish-brown ridge-like detail from front of knob. The results are consistent with the DNA profile from item 4-1S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 4-1S1. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 2 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 4-1S1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S1.
And when you did the additional analysis of the names in DNA sub 9, what were the results?
The results are consistent with the DNA profile from item, oh, sorry, I'm on the wrong one. 4-1S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Konstantin Dulos could be a contributor to the DNA profile from item 4-1S1. The results do not support the hypothesis that Christine Dulos is a contributor. So assuming 2 contributors, Christine Dulos is eliminated. Results do not support the hypothesis that C. Noel Dulos is a contributor. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to 4-1S1. And then Petros Dulos, Theodore Dulos, Lauren Almeida, and Pavel Gumini are eliminated as contributors to the DNA profile from 4-1S1.
And just with respect to 4-1S2, which was found in DNA sub 1, no profile was obtained. Is that correct?
That is correct.
And with respect to 4-1S3, was that a swabbing of a doorknob and plate assembly with screws?
Yes, that's what it was designated.
And directing your attention now to DNA sub 2, what were the results?
The results are consistent with the DNA profile from item 4-1S3 being a mixture of 3 contributors with at least one of them being male. Assuming 3 contributors, the DNA profile from item 4-1S3 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile of the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. Assuming 3 contributors, the DNA profile from item 4-1S3 is at least 330,000 times more likely to occur if it originated from Fotis Dulos and 2 unknown individuals than if it originated from 3 unknown individuals. And Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S3.
Well, Attorney McGinnis, what the court is going to do is just ask a few questions so that it is clear what those numbers mean, but in a more narrative form. So, Ms. Maydell, when you indicated that certain court is going to refer to it as likelihoods occur, when you use the numbers, would you explain in a narrative form what those numbers mean? So if someone is 45,000 times more likely to be X, what does that mean?
Well, it's a likelihood ratio that, given the evidence is more likely to occur if hypothesis 1 is true compared to hypothesis 2.
So would you rephrase it using those numbers?
So for any given evidence, it would be 100 times more likely, 100 billion times more likely, as an example, for hypothesis 1 to be true compared to what hypothesis 2 is.
So it's a comparison of the hypotheses.
Yes, only one of them can be true. So if that evidence is more likely to occur if the first hypothesis
Only
is
one
true
might be
compared to the second
true.
hypothesis.
That's
Thank
not
I
true.
believe you indicated for 1S3, it was 330,000 times more likely that Fotis Dulos was a contributor to the profile than if it were 3 unknown people. Is that correct?
330,000 times, yes.
And I'll just note, I think that's a misstatement of what the odds are. I think this is what they call the fallacy. It is odds of one thing occurring versus another, not that it's that person.
Well, what the court understood from Ms. Maydell's explanation is that we're comparing hypotheses. We're not talking about identification.
And just directing your attention on DNA supplemental report number 9.
Still, this is starting to fall apart.
And those additional knowns against the DNA profile for 41S3. And if you're ready, what were the results?
Sure. The results are consistent with the DNA profile from 41S3 being a mixture of 3 contributors, with at least one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 4.1S3. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 900,000 times more likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the electric toothbrush, and one unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 160,000 more times likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the toothbrush, and 1 unknown individual than if it originated from the source of the toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 4.1S3 is at least 30,000 times more likely to occur if it originated from C. Noel Dulos, the source of the DNA profile from the electric toothbrush, and 1 unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Konstantin Dulos, Christian Dulos, Theodore Dulos, and Pavel Gumeni could be contributors to the DNA profile from item 4.1S3. Lauren Almeida is eliminated as a contributor to the DNA profile from item 4.1S3.
I want to talk to you about 41S3 for a second. In DNA supplemental 9, you assume that the profile from the toothbrush was a contributor. Can you just explain to the jury when you assume that a particular profile is a contributor to another profile? What does that mean?
So it's called conditioning. And when there's a scientific, reasonable expectation scientifically that a person's DNA could be on that item, it is sometimes better to assume that person so you can get a more accurate likelihood ratio to the other contributors that are contributing to that DNA profile. So after I did the first report where I compared the toothbrush and Fotis to the swabbing of the doorknob and plate and saw that they were both contributors. Knowing that I'm going to now compare the children to that profile, because the children get half their DNA from their mother and half their DNA from their father, it's a given that those profiles are going to be there, because if they're contributing, then the children are going to have a likelihood ratio. So in order to give a more accurate likelihood ratio to if the children are contributing to that profile, we went and assumed the toothbrush because she's scientifically expected to be on that doorknob because that is her house.
The time is now 11:15. Ladies and gentlemen, we will take our morning recess. The court should indicate to you today that we will conclude today's session at 3 o'clock. So we ask that you retire to the.
What if half their DNA came from the neighbor? So, oh my gosh. Yeah, I get it, guys. This is boring, but this is where we get to the whole, like,
All right.
all the swabs they collected are showing bust for the DNA evidence. So, but I think the state would argue that just proves their theory that this crime scene was sanitized. Name of some sort says, yeah, I've got all these like loose filament in there, and I should just run it. You're saying I should just print it straight up. I'm like, I'll try that next time. You know what? I'm actually just try that now. We'll see what happens. And I'll just put a support on it. So, all the booger swabs. Yeah. I can't. I cannot. But let's skip ahead. I know she's got a little bit more. Let's see what we get out of her here.
Before the jury comes out, I would just note, we had a sidebar. There was a previous motion regarding motion to eliminate regarding the question about what did inconclusive mean. It was clarified by the state, but the state started getting into it knowing that there was a motion to eliminate. Again, the court did some clarification, and as far as I'm concerned, that was fine. But I would ask the state to realize that if I file a motion to eliminate, it's because there's an issue that should be resolved, so we don't have to do sidebar, and it doesn't require the court's intervention. Maybe he was inadvertent on Mr. McGinnis's part. I'm just raising it because we have a moment to do so.
Well, the record has to reflect that the court did act on the motion. The motion is denied, but that denial in this court's view is not to the prejudice of the defense, because the court has the opportunity to ask questions, which would allow the jury not to be confused. For example, this goes back to yesterday's discussion, the likelihood ratio.
So that is the neat thing. The court, he's saying, I'm shutting down your motion to eliminate, but I'm still in charge. I'm the gatekeeper. He said, I'm still in charge of gatekeeping the facts. And I'll give him credit. He's not afraid to do that.
The likelihood ratio is simply a ratio of compared hypotheses. And so if the jury did not understand that previously, hopefully the jury understands that now. Are we ready to proceed?
Yes, Judge.
Thank you. We can bring the jury back in, please. Okay, will counsel stipulate?
Yes, Judge.
Yeah.
Okay, thank you. Attorney McGinnis.
Good morning again. Ms. Madel, I just wanted to ask you, when we were talking about hypotheses earlier, hypothesis 1 versus hypothesis 2, could you just explain to the jury in a little more detail what that means from your perspective. Does it mean it's one or the other? What exactly does that mean?
When we're creating these hypotheses, it's to describe how likely the evidence is to occur. Is it more likely to occur when hypothesis 1 is true compared to hypothesis 2?
So it's not an either or scenario.
No, it's if number 1 is true compared to what number 2 is.
Were there a number of results in this case in which you
down five.
concluded that the contributor to the profile was a single female individual and that it was 100 billion more times more likely to be the profile on the toothbrush and everyone else was eliminated?
Yes, there is a bunch of those samples.
All right, I'd like to talk to you about those if I could. If we can call up Exhibit 15, or a photograph of State Police Exhibit 15,
Bubba?
which is found in State Trial Exhibit 9, folder number 3, photograph 13. And just for the record, Your Honor, State Police Exhibit 15 was identified as 2 swabs of a blood-like stain seized from the scene, the handle under the sink, cabinet door, kitchen island, and subsequently designated as submission 6. Were these results consistent with being a single female and the results being 100 billion times more likely to be the profile found on the toothbrush?
Yes.
If we can call up State Police Exhibit 35, which was identified as 2 swabs of a blood-like stain, G19, seized from the scene and submitted to the lab as submission 102. Were these the same results, being a single female 100 billion times more likely to result if it was the DNA profile obtained from the toothbrush as opposed to an unknown individual?
Yes, single female individual, yes.
We can call up State Police Exhibit number 36. This was identified as 2 swabs of a blood-like stain, G20, seized from the scene and subsequently submitted to the Division of Scientific Services as submission 103. Same results. And that's DNA sub 7 and sub 10.
Yep. Yes.
Staying with DNA sub 7 and 10 for your benefit, Ms. Maydell.
No, they're comparing it to Jennifer's toothbrush because it's got like the best sample on it. So the toothbrush is found in the bathroom. These are the ones out in the garage.
We can call up State Police Exhibit number 36, 37. And this was identified as 2 swabs of a blood-like stain, C2, KM positive, seized from the scene, subsequently submitted to the Division of Scientific Services and designated as submission 104.
Go on.
Was it the same result, Ms. Maydell?
Yes.
One. Fine. No.
We can call up State Police Exhibit 38, photograph of that. And this was identified as 2 swabs of a blood-like stain, B3, seized from the scene, North Bay, and submitted to the state lab as submission number 105. Were the results the same, a single female?
Yes.
And just to be clear, a single female 100 billion times more likely to be the profile obtained from the toothbrush. Is that correct?
Correct.
And everyone else was eliminated?
Correct.
If we can call up a photograph of State Police Exhibit number 39. This was identified as 2 swabs of a blood-like stain, B11, seized from the scene, KM positive, North Bay, subsequently submitted to the Division of Scientific Services as submission 106. What were the results of this?
The same as the previous result. Single female, assuming 1 individual, the DNA profile from item 106S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from a... Sorry. Assuming 1 individual, the DNA profile from item 101S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from a swabbing of the electric toothbrush than if it originated from an unknown individual.
We can call up State Police Exhibit number 41, photograph of that.
Well, Your Honor, I note that the witness skipped the last sentence of her report, of her finding on that particular item. I just asked that she read the remaining sentence.
Well, Attorney McGinnis, is there another sentence that was not read from the conclusion?
I'm unclear, Judge. I'm assuming he's referring to everyone being eliminated? Everyone else being
The court does
eliminated?
not know because the court does not have the
That's
exhibit.
So these results that we're going through now are consistent with the profile of the that you obtained from the toothbrush being 100 billion times more likely to be the source of these profiles. Is that correct?
versus an unknown profile.
Right. And everyone else has been eliminated. These results are all the same, correct?
Correct so far.
We can call up a photograph of State Police Exhibit 41. This was identified as 2 swabs of a blood-like stain, A18, KM positive, seized from the scene, subsequently submitted to the Division of Scientific Services and designated as item 108. Were these results the same as your previous answer?
Yes.
We could call up State Police Exhibit number 45. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 109. Is the results of this test the same?
Yes.
If we could call up State Police number 48. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 112. Were the results here the same?
Yes.
If we could call up State Police Exhibit 59. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left side of the hood, subsequently submitted to the Division of Scientific Services and designated as submission 118. Were the results of this the same?
Yes.
If we could call up Exhibit 60. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left front corner of bumper, subsequently submitted to the Division of Scientific Services as submission 119. Were the results here the same?
Yes.
If we could call up State Police photograph 61. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, exterior side of left front door, subsequently submitted to the Division of Scientific Services and designated as submission 8. Were the results of the analysis here the same? And that's in DNA Sup 1 and Sup 9.
Yes.
If we can call up State Police Exhibit 62. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the garage 2014 Land Rover, exterior side left rear door, subsequently submitted to the Division of Scientific Services and designated as submission 121. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 63. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, 2014 Land Rover, left rear fender, subsequently submitted to the Division of Scientific Services and designated as submission 120. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 64. Oh, I'm sorry, I don't think we have a photograph of 64. State Police Exhibit 64 was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, east wall of garage, north of door 2 mudroom. Were the results of that test the same?
So which item number for the lab?
Oh, I apologize. Submission 122.
Yes.
We can call up State Police Exhibit 65. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can western, subsequently submitted to the Division of Scientific Services and designated as submission 9. Were the results of this test the same? And that's in DNA Sup 1 and Sup 9.
Yes.
If we can call up State Police Exhibit 66. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can eastern, and subsequently submitted to the Division of Scientific Services and designated as submission 123. Were the results of this test the same?
Yes.
If If we can call up State Police Exhibit 78. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, kitchen island countertop edge north of sink, subsequently submitted to the Division of Scientific Services and designated as submission 10. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 320. This was identified as suspected biological matter E, seized from the scene, garage 2014 Land Rover, lower edge, left front door, subsequently submitted to the Division of Scientific Services and designated as submission 132. Were the results of this test the same?
Yes.
If we can return to State Police Exhibit number 13. I don't know if I talked about this one yet. This was identified as 1 used paper towel roll with blood-like stains, KM positive, seized from the scene, kitchen island countertop, east of sink, and subsequently submitted as submission 101. Were the results of this the same? This is from DNA sub 7 and 10.
You said number 110?
101.
101. Correct, yes.
If we could call up State Police Exhibit 14. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, kitchen sink, faucet spout, and subsequently submitted to the Division of Scientific Services and designated as submission 5. Can you let us know what the results were of this? This is from DNA sub 1 and 9.
The results are consistent with the DNA profile from item 5S1, being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, the DNA profile from item 5S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, the DNA profile from item 5S1 is at least 4.3 billion times more likely to occur if it originated from Fotis Dulos and 1 unknown individual than if it originated from 2 unknown individuals. Michelle Troconis is eliminated as a contributor to the DNA profile from item 5S1.
And directing your attention now to DNA supplemental report number 9, did you reanalyze this profile and assume that the profile from the toothbrush was a contributor?
Yes, again, knowing from this first report that it was a 2-person mixture and it looked like a mixture of the parents of the children, I went and created a new hypothesis to make that second contributor more discriminating. So I ran the children all against that first deconvolution of the 2-person mixture in order to determine who had the highest likelihood ratio between the toothbrush and the 5 children. So then I could then assume one of them and make a comparison to that second person. So after I did that, the toothbrush had the highest likelihood ratio as being a contributor. And when you assume somebody on a profile, it increases the likelihood ratios of true contributors, but it will decrease the likelihood ratio of non-contributors. So it is a scientifically sound conclusion to do. So after I did that, then I made my conclusions in supplemental 9.
And what were the conclusions?
The results are consistent with the DNA profile from item 5S1, being a mixture of 2 contributors with one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 5S1. Assuming 2 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from 5S1 is at least 100 billion times more likely to occur if it originated from Fotis Dulos and the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual. Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, Theodore Dulos, Laura Almeida, and Pavel Gumini are eliminated as contributors to the DNA profile from 5S1.
So all the other known profiles that you had, including the defendant, were eliminated. Is that correct?
Yes, after I assume the toothbrush as a contributor to the profile, the children are eliminated and cannot be the second contributor.
If we can call up State Police Exhibit 40. And this was identified as 2 swabs of a blood-like stain, A15 KM positive, seized from the scene, North Bay, subsequently submitted to the Division of Scientific Services as submission 107. And this is found in DNA Supplemental Reports 7 and 10 for your benefit, Ms. Maydell. What were the results of the analysis here?
S1, you said?
Yes.
The results are consistent with the DNA profile from item 107S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 107S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Due to the limited data detected from item 107S1, the comparison to Fotis Dulos and Michelle Troconis are inconclusive.
What does that mean when you say due to limited data?
So this is was designated a 2-person mixture. So the major profile being so I probably had a major profile with a minor profile. So looking at the toothbrushes being 100 billion times more likely, that was the major profile in the within that 2-person. And there was only one, probably, I don't want to speak without seeing the actual data, one peak that wasn't attributed from that DNA profile from the toothbrush. And Fotis Dulos and Michelle Troconis have that peak, so I can't say conclusively if they're a contributor or not, but I can't eliminate them either.
If we can call up State Police Exhibit 42. This was identified as a fragment of a paper towel with a blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item 65 or submission 65, I should say. And for your benefit, Ms. Maydell, this is found in DNA Sub Reports 3 and 9.
I'm sorry, can you repeat the number?
65.
65. The results are consistent with the DNA profile from item 65S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 65S1 is at least 2.5 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from item 65S1.
And in fact, all known other profiles were eliminated. Is that correct?
Let me just double check. What was the other report?
Sub 9.
And I'm going to object to this mischaracterization. If I may just have a moment.
Oh, I apologize.
Well, sustained.
I apologize, Your Honor. If you could just read the results when you compared it to the other knowns.
Sure. The results are consistent with the DNA profile from item 65S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Theodore Dulos could be a contributor to the DNA profile from 65S1. The other children, Lauren Almeida, Pavel Gumini, are all eliminated as contributors to 65S1.
If we can call up State Police Exhibit 43. And this was identified as a fragment of a paper towel with a blood-like stain and submitted to the Division of Scientific Services and designated as submission 66. And this can be found in DNA Reports 3 and 9.
The results are consistent with the DNA profile from item 66S1 being a mixture of 2 contributors.
Guys, this is just dragging right
Assuming
now.
2
There's
contributors,
nothing.
the DNA profile from item 66S1
They got to
is
get
at least
this in.
100
So
billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from 66S1.
And
Okay,
was
they're
there,
eliminated. Maybe
Additional
Michelle.
swabbing of the paper towel that was designated as 66S2.
Oh, this is good. Okay, I wanted to get the information on this. Yeah, this is going to be the paper towel that were found inside. One of the few remaining after so many were bought. So yes, this is the critical stuff here.
I'm sorry. S.
Yeah, there was a 66S2 and 66S3.
Okay. So can you just indicate to the results of 66S2, which was identified as swabbing of paper towel side A?
There was no DNA profile detected.
And similarly, the results for 66S3, the swabbing of the paper towel side B?
No DNA profile detected.
If we can call up State Police Exhibit 44.
I didn't do the results for 66S1 against the children.
Oh, I apologize. If I could just have a moment. Yes, if you could tell us the results of 66S1.
So the results are consistent with the DNA profile from 66S1 being a mixture of two contributors. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 66S1. Lauren Almeida and Pavel Gumini are eliminated as contributors to the profile from 66S1.
If we could bring up State Police Exhibit 44. This was identified as a fragment of a paper towel with a blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item submission number 67. And there were actually two separate analysis of this particular item. There was a fragment of the paper towel and then there was a swabbing of the paper towel. Is that correct?
Yes, 67S1 and 67S2.
Okay, so let's start with 67S1, which was actually a fragment of the paper towel. What were the results for that?
The results are consistent with the DNA profile from item 67S1 originating from a single female individual. Assuming one individual, the DNA profile from 67S1 is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from a swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Dulos and Michelle Troconis are eliminated as the source of 67S1.
And directing your attention now to supplemental report number 9, the Dulos children, as well as Lauren Almeida and Pavel Blooming were also.
You guys can hear the printer going.
And what were the results of 67S2, which was a swabbing of this paper towel fragment?
No DNA profile was detected.
If we can call up State Police. Actually, I don't believe we have a photograph of 46, but State Police 46 is identified as two swabs of a blood-like stain KM positive seized from the scene North Bay, subsequently submitted to the Division of Scientific Services and designated as submission 110. And for your benefit, Ms. Maydell, it's found in DNA supplemental reports number 7 and 10. Could you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from a swabbing of the electric toothbrush could be the source of the DNA profile from item 110S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the DNA profile from item 110S1.
And then when you had an opportunity to test that profile against additional knowns in DNA supplemental report 10, what was your conclusion?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be the source of the DNA profile from item 110S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 110S1.
Yeah.
Well, call up State Police 47. This was identified as two swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 111. And Ms. Maydell, for your benefit, these results are found in supplemental reports 7 and 10.
The The results are consistent with the DNA profile from item 111S1 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as the source of the DNA profile from item 111S1. Fotis Dulos and Michelle Troconis are also eliminated as the source of the DNA profile from item 111S1.
And then when you did additional comparison to the other knowns in DNA supplemental report number 10?
Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive to whether Fotis Dulos, Christiane Dulos, or Theodore Dulos could be a source of the DNA profile from item 111S1. Constantine Dulos, C. Noel Dulos, Lauren Almeida, and Pavel Gumini are eliminated as the source of the DNA profile from item 111S1.
She's got to say the
Please
same
call
thing
Stipulations
because
number
there's
49.
so many different exhibits and so many different samples taken. That's why she's saying it's all the people that it's not and everybody that they can rule out.
State Police number 49 was identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 113. What were the results of this?
No DNA profile was detected.
If I could just have one moment with counsel.
See, there you go. She had to talk about that. Remember, we had that issue they brought up. Well, we're going to bring up crap and it's going to come out negative for anything, but it's going to look like blood. And now they have to address that issue.
If we can call up State Police Exhibit 50. This is identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 114. And this is in DNA reports 7 and 10 for your benefit, Ms. Maydell. Could you just indicate to the jury what the results were here?
The results are consistent with the DNA profile from item 114S1 being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 114S1. Fotis Dulos is eliminated as a contributor to the DNA profile from item 114S1. The results do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 2 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from item 114S1.
And then when you did additional comparisons of the knowns in DNA supplemental report number 10, were all the other known profiles eliminated, the Dulos children, Lauren Almeida and Pavel Gumimi?
Correct, yes.
Yes, not dad, it's not
We could call up
Troconis.
State Police number 51. State Police 51 is identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, South Bay, subsequently submitted to the Division of Scientific Services and designated as submission number 115. And Ms. Maydell, this is also in report 7 and 10. Can you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 115S1 being a mixture of 3 contributors, with at least one of them being male. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 115S1. The results do not support the hypothesis that Fotis Dulos or Michelle Troconis are contributors to this profile. Assuming 3 contributors, Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from 115S1.
These aren't her notes.
And
These
DNA
are
supplemental report
literally,
number 10 when you
these are all the exhibits. They're literally lab results. So she has to be able to read those. And the defense is like, that's fine because they're lab results. They're not her notes. Because otherwise there's no way she could memorize everything she tested. That would literally, oh my God, that would be insane. So yeah, this is not that. I understand where you guys are coming from in that regard, but yeah, these aren't her notes. These are literally the lab results. They're already stipulated exhibits. So there's no issue there.
had the benefit of doing additional known comparison.
Yes. The results are consistent with the DNA profile from 115S1 being a mixture of 3 contributors, with at least one of them being male. Fotis Dulos, Constantine Dulos, Christiane Dulos, and Pavel Gumini are eliminated as contributors to the profile from item 115S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether C. Noel Dulos could be a contributor to the DNA profile from 115S1. And the results do not support the hypothesis that Theodore Dulos or Laura Almeida are contributors to this profile. Assuming 3 contributors, Theodore Dulos and Lauren Almeida, are eliminated as contributors to the DNA profile from 115S1.
If we can call up state police number 52. This was identified as 2 swabs of a blood-like stain KM negative seized from the scene South Bay, subsequently submitted to the Division of Scientific Services and designated as submission 116. What were the results of this? DNA sub 7.
No DNA profile was detected.
If we could call up state police number 53. This was identified as 2 swabs of a blood-like stain KM positive seized from the scene South Bay, subsequently submitted to the Division of Scientific Services and designated as submission 117. And again, these results can be found in 7 and 10, Ms. Maydell.
Yes.
Would you just indicate to the jury what the results were?
The results are consistent with the DNA profile from item 117S1 being a mixture of 2 contributors. Due to the limited data detected from 117S1, the comparison to the source of the DNA profile from the swabbing electric toothbrush and Michelle Troconis are inconclusive. Fotis Dulos is eliminated as a contributor to the DNA profile from item 117S1.
And then when you had the benefit of comparing additional knowns?
The results are consistent with the DNA profile from item 117S1 being a mixture of 2 contributors. Petros Dulos, Konstantin Dulos, Christiane Dulos, and Theodore Dulos are eliminated as a contributor to the DNA profile from item 117S1. Due to the limited data detected from 117S1, the comparisons to C. Noel Dulos, Laura Almeida, and Pavel Gumeni are inconclusive.
We could call up state police 67.
We're getting there,
And this was
guys.
identified as 2 swabs of a blood-like stain KM positive seized from the scene interior side of north garage door and subsequently submitted to Division of Scientific Services and designated as submission number 68. And this is for your benefit, Ms. Maydell, can be found in DNA reports 2 and 9. Beginning with report 2, what were your conclusions?
So what was the number again? The item number?
68.
68. The results are consistent with the DNA profile from item 68S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 68S1 is at least 810 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from item 68S1.
And now directing your attention to DNA supplemental
They're
report number 9.
eliminated.
When you did
Shocker.
additional comparisons to knowns.
So I'm sure this one's going to be the
Results are
same thing.
consistent with the DNA profile from item 68S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 68S1. Lauren Almeida and Pavel Gumeni are eliminated as contributors to the DNA profile from item 68S1.
If we can call up state police 79. This was identified as 2 swabs of a blood-like stain KM positive seized from the scene, the kitchen sink faucet handle, and subsequently submitted to the Division of Scientific Services and designated as submission 11. And this can be found in DNA supplemental report number 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 11S1 originating from a single individual. Assuming 1 individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 11S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the DNA profile from item 11S1.
It's very tedious, but
And then directing your attention on DNA
the state's
supplemental
not doing
report
this to
number 9.
bore everybody. They're trying to push a point.
You have the benefit of doing additional comparisons with knowns.
Yes. Results are consistent with the profile from 11S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive to whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, and Theodore Dulos could be the source of the DNA profile from 11S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 11S1.
If we can call up State Police Exhibit 319. State Police 319 was identified as suspected biological matter D, ceased from the scene, 2014 Land Rover, left front fender, and subsequently submitted to the Division of Scientific Services and designated as submission 131. Then directing your attention to DNA supplemental report 7 and 10. Could you indicate to the jury what the results were?
Sorry, what was the number again?
131.
31.
Did they test the DNA against police that touched everything? Yes, they would have done some of that as
Results are
well.
consistent with the DNA profile from item 131S1 originating from a single female individual. Assuming one individual, the DNA profile from item 131S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of electric toothbrush than if it originated from an unknown individual.
And were Fotis Dulos and the defendant eliminated?
Yes.
And in DNA supplemental report number 10, were the Dulos children, Lauren Almeida and Pavel Gumini, eliminated as well?
Yes, correct.
If we could call up just State Police Exhibit 12 for one moment. I think we've talked about the fact that there were 4 separate swabbings of this, and I think we got through 1S1 through 1S3. I wanted to just talk to you about the results of 1S4. And that's identified as the swabbing of a doorknob and plate assembly without screws.
1S4?
That's correct, ma'am.
Okay.
And this is found in DNA subs 2 and 9 for your benefit, Ms. Maydell.
Well,
Could you just indicate
The
to the jury what the
knobs.
results were?
The results are consistent with the DNA profile from item 4-1S4 being a mixture of 4 contributors, with at least one of them being male. Assuming 4 contributors, the DNA profile from item 4-1S4 is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 3 unknown individuals than if it originated from 4 unknown individuals. The results do not support a hypothesis that Fotis Dulos is a contributor to this profile. Assuming 4 contributors, Fotis Dulos is eliminated as a contributor to the profile from item 4-1S4. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1S4.
And when you did the additional comparisons?
Assuming 4 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 4-1S4. Assuming 4 contributors, the DNA profile from item 4-1S4 is at least 130,000 times more likely to occur if it originated from Christian Dulos and 3 unknown individuals than if it originated from 4 unknown individuals. Lauren Almeida and Pavel Gumini are eliminated as contributors to the DNA profile from item 4-1S4.
I'm surprised Lauren's not on everything. I mean, I get you don't leave touch DNA everywhere, but
I'm now
she
going to
should have
shift around and be
something
publishing
somewhere.
things from State's Exhibit 28, which is the stipulation regarding evidence seized from Jennifer Dulos' Chevy Suburban. Ms. Maydell, you recall approximately 45 minutes to an hour ago, we talked about results in which there was a single female contributor, and it was 100 billion times more likely to have occurred if it was the profile from that you obtained from the toothbrush as opposed to an unknown individual. Do you recall that testimony?
Yes,
All right. And in those instances, everyone else, all the other knowns were eliminated. Is that correct?
that is correct, yes.
I want to just direct your attention now, if we can call up State Police Exhibit 105. This is identified as 2 swabs of a blood-like stain KM positive taken from the rear bumper step of a 2017 Chevrolet Suburban. and subsequently submitted to the Division of Scientific Services and designated as item 124. Were those the same results that we were just discussing? This can be found in DNA Supplemental Report number 7 and 10.
Yes, that is correct.
And if we can call up 106.
I'm sure they're going to be inconclusive again. The people you
Same results. I'm sorry.
for all
Let
the
me publish,
kids.
This is State Police Exhibit 106, identified as 2 swabs of a blood-like stain taken from the exterior side of the right rear door and submitted to the Division of Scientific Services and designated as submission number 15. Were these the same results, Ms. Maydell?
Which report is that?
Oh, DNA Supplemental Report number 1 and 9.
So,
15S1, yes.
And if we can call up State Police 107. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the running board under the right front door and subsequently submitted to the Division of Scientific Services and designated as submission 100 and the steps. I can just have one moment, Your Honor.
I mean, it is. Well, I just don't see what this is going to get. I mean,
I just have a moment, Attorney Schoenhorn. I think I have a scrivener's error.
Oh,
If I could just have one moment, Attorney Schoenhorn.
this is yes, it's just it's just like I don't think they're prepared at this point to what to do. I mean, it's I don't like there's been no curveball, so where are they stuck?
I just had a scrivener's error.
Oh, okay. Like he didn't object, he wasn't screwing you, so you should be able to keep going.
State Police 107 is identified as 2 swabs of a blood-like stain, KN positive, taken from the running board under the right front door, subsequently submitted to the Division of Scientific Services and designated as submission 125. With respect to this, are these the same results, meaning 100 billion times more likely to originate from the profile obtained from the electric toothbrush than an unknown profile, and all other known individuals to you were eliminated?
Yes.
If we could call up State Police Exhibit 120. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the left side of the cargo area and subsequently submitted to the Division of Scientific Services and designated as submission number 70. Same results.
Is it a report?
DNA sub 3 and 9.
Correct.
If we could call up State Police number 316. This was identified as 2 swabs from Area A, subsequently submitted to the Division of Scientific Services and designated as submission 100. I'm sorry? Oh, we don't have 316? Okay.
Can I have a moment with counsel for a brief moment?
Why? Why? So, shows Corky. I'm not showing Corky. He lost his place. Yeah, this is the problem when you have such a voluminous.
Sorry, maybe just take a 5-minute recess so I can get the defense some paperwork.
Yes.
The problem, when it gets so big, this causes like a logistical problem like this. So let's get to it. Come on. Let's run this out. Let's run the clock out. Here we go.
We can bring the jury in.
Why is that popping up? I don't want that.
Ladies and gentlemen, the court understands that it is quite cold in the deliberation room, so we will address that at the lunch and recess. Will counsel stipulate to the presence of all of the jurors?
Yes, Judge.
Thank you. You
So
may
let's-
proceed, counsel.
Ms. Madell, where we left off, we were discussing State Police Exhibit 316, which was seized from the Chevy Suburban and identified as 2 swabs from Area A and subsequently submitted to the Division of Scientific Services and designated as submission 128. For your benefit, this is DNA reports 7 and 10. What were the results?
Number 128 is the same as what we were previously talking about. Single female individual, assuming one individual, the DNA profile from item 128S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And everyone else is eliminated.
And if we can bring up State Police Exhibit 317. No, okay, I apologize. Submission or State Police Exhibit 317 was identified as 2 swabs from Area B from the Chevy Suburban and subsequently submitted to the Division of Scientific Services and designated as submission number 129. Same results?
Yes.
State Police Exhibit 318, which was identified as 2 swabs from Area C of the Chevy Suburban and designated as submission 130. Same results?
Yes.
Oh. Ah. Mm. Mm. Ah. Mm.
State Police Exhibit 99 was identified as 2 swabs taken of the top half of the steering wheel. and
Yes.
Subsequently submitted to the Division of Scientific Services.
They swabbed 10 and
Submission
2.
number 12. And for your benefit, Ms. Madell, this is in reports 1 and 9.
Do you think they
What were the
swabbed it in
results?
circular motion on the wheel?
The results are consistent with the DNA profile from item 12S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 12S1 is at least 100 billion times more likely to occur if it originated from the
Doing a
source
bump.
of the
I'm
DNA
sorry, I didn't
profile
realize.
from the swabbing of the electric toothbrush in one unknown individual than if it originated from 2 unknown individuals.
Ah.
Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive to whether Fotis Dulos could be a contributor to the DNA profile from item 12S1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 12S1.
And directing your attention now to DNA
On this
supplemental
one,
report number
again.
9. It's my
like
understanding
brand
that with the exception of Theodore, the Dulos children, Lauren Almeida, and Pavel Guimi were eliminated.
That is correct. The low likelihood ratio is calculated. The results are inconclusive whether Theodore Dulos could be a contributor to the profile of 12S1.
State Police Exhibit 100.
Can I just have a moment, counsel?
Oh.
I apologize.
That's fine.
State Police Exhibit 100, which was identified as 2 swabs taken from the bottom half of the steering wheel and subsequently submitted to the Division of Scientific Services as submission number 13. And this is in DNA reports 1 and 9, Ms. Madell.
The results are consistent with the DNA profile from item 13S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 13S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from item 13S1.
And DNA supplemental report number 9. My understanding is that the Dulos children and Pavel Glumi were eliminated and the results were inconclusive as to Lauren Almeida. Is that correct?
That is correct.
State Police Exhibit 101, which was identified as 2 swabs taken from the gear shift and subsequently submitted to the Division of Scientific Services as submission number 14. And this is found in reports 1 and 9, Ms. Madel.
The results are consistent with the DNA profile from item 14S1 originating from a single female individual. Assuming one individual, the DNA profile from item 14S1 is at least 780,000 more times likely to occur if it originated from the source of the DNA profile from a swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Dulos and Michelle Troconis are eliminated as a source of the DNA profile from 14S1.
And in DNA supplemental report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Glumi, were eliminated. Is that correct?
That is correct.
We can call up State Police Exhibit 108.
Oh,
This was identified as 2 swabs of a blood-like smudge, KM positive, taken from the exterior side of the right front door and subsequently submitted to the Division of Scientific Services and designated as submission 126. And Ms. Madel, for your benefit, this can be found in DNA's reports 7 and 10. Could you just indicate what the results were?
Can you repeat the number again? 126?
6.
The results are consistent with the DNA profile from item 126 being S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 126S1 is at least 11 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from number 126S1.
And in DNA supplemental report number 10, I believe you concluded that given the low likelihood ratios, the results were inconclusive as to the Dulos children. However, Lauren Almeida and Pavel Glumi were eliminated. Is that correct?
Yes, that is correct.
State Police Exhibit number 113. This was identified as 2 swabs of a latent smudge from the exterior side of the tailgate and subsequently submitted to the Division of Scientific Services and designated as submission number 16. And this is in reports 1 and 9 for your benefit, Ms. Madel.
The results are consistent with the DNA profile from item 16S1 originating from a single female individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 16S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the profile from item 16S1.
And in DNA supplemental report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Glumi, were eliminated. Is that correct?
That is correct, yes.
State Police Exhibit number 119. This was identified as 2 swabs taken from the garage door opener on the driver's side visor and subsequently submitted to the Division of Scientific Services and designated as submission number 69. And it's found in reports 3 and 9, Ms. Madel.
The results are consistent with the DNA profile from item 69S1 being a mixture of 3 contributors with at least one of them being male. Assuming 3 contributors, the DNA profile from item 69S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 3 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 69S1. And the results also do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 3 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from 69S1.
And in DNA supplemental report number 9, you concluded that Lauren, Almeida, Pavel, Guimi were eliminated. You also concluded that all of the children, with the exception of Constantine Dulos, was eliminated. And with respect to Constantine Dulos, you concluded that assuming 3 contributors, it was 210,000 times more likely to occur if Constantine Dulos was a contributor with 2 unknowns as opposed to 3 unknowns. Is that correct?
Christiane Dulos.
Christiane Dulos, excuse me.
Yes. Constantine's eliminated. Christiane is the 210,000 more times likely.
If we can pull up states 121. This is identified as 2 swabs of a blood-like stain KM positive taken from the cargo area floor and subsequently designated as submission number 17. And this is in reports 1 and 9 for your benefit, Ms. Maydale. What were the results of this?
The results are consistent with the DNA profile from item 17S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 17S1 is at least 31,000 times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from 17S1.
Attorney McGinnis, we are going to take our lunch and recess at this time.
Judge, I'm sorry, may I just finish up with this one exhibit? Just one more question.
So
Yes,
remember, we are only going to be here an hour.
we're in conclusivity.
So you may finish.
Thank you. And just
We're in conclusivity. It's going to be great.
continuing on
guys.
to supplemental report
Ha
number 9.
ha ha.
What was your conclusion?
Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be a contributor to the DNA profile from 17S1.
This is day 5.
And Lauren Almeida and Pavel Gumini are eliminated as contributors to 17S1.
Thank you, Judge.
Ladies and gentlemen, we will attempt to address the frigid conditions in your deliberation room. And we'll resume at 2 o'clock. We will only have an hour this afternoon before we adjourn. So please do not discuss the case and have a good lunch.
They have an hour. Do you guys want to get this done? 1 more hour to get done. We'll get day 5 wrapped up. You just want to finish the hour. You know, it's just generate Civil War reenactment.
Rise. This court now stands in recess.
Yeah, all right, we'll do it. All right.
Dulos, Petros Dulos, Constantine Dulos, Christiane Dulos,
Oh,
C. Noel
jeez.
Dulos, and Theodore Dulos are contributors to this profile. Assuming 3 contributors, Fotis Dulos, Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, and Theodore Dulos are eliminated as contributors to the DNA profile from 134S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis or Lauren Almeida could be contributors to the DNA profile from item 134S1. Pavel Gumini is eliminated as a contributor to the DNA profile from item 134S1.
State Police Exhibit 371, which is identified as 4 swabs from the area with blood light staining on the steering wheel, subsequently submitted to the Division of Scientific Services and designated as submission 135. What were the results of that analysis?
The results are consistent with the DNA profile from item 135S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis or Lauren Almeida, are contributors to this profile. Assuming 2 contributors, the sources of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis and Lauren Almeida, are eliminated as contributors to the DNA profile from item 135S1. Fotis Dulos, Petros Dulos, Constantine Dulos, Christine Dulos, C. Noel Dulos, Theodore Dulos, and Pavel Gumini are eliminated as contributors to the DNA profile from item 135S1.
State Police Exhibit 372, which was identified as 4 swabs from the interior side of the left front door, was submitted to the Division of Scientific Services as submission 136. And just with respect to these results, the results were consistent with a single individual, but every known profile along with the profile obtained from the toothbrush were eliminated. Is that correct?
That is correct, yes.
State Police Exhibit 373, which was identified as 2 swabs from the left front seat adjustment controls, was subsequently submitted to the Division of Scientific Services and designated as submission 137. Can you please indicate to the jury what the results were there?
The results are consistent with the DNA profile from item 137S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 137S1 is at least 1.3 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 137S1. Fotis Dulos, Michelle Troconis, Lauren Almeida, and Pavel Gumini are eliminated as contributors to the DNA profile from item 137S1.
State Police Exhibit 374, which was identified as 2 swabs from their rear view mirror, was subsequently submitted to the Division of Scientific Services and designated as submission 138. What were the results of that submission?
The results are consistent with the DNA profile from item 138S1 originating from a single individual. Assuming 1 individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush. The results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 138S1.
And everyone else was eliminated, is that correct?
Yes.
And State Police Exhibit 375, which was identified as 2 swabs from the cargo area, rear seat controls, and subsequently submitted to the Division of Scientific Services and designated as submission 139. No profile was obtained, is that correct?
That is correct.
Now, I wanted to talk to you about circumstances that can influence the presence or lack thereof of DNA. Could clothing or gloves or other objects in between a person and a surface impact the amount of DNA that is ultimately left on the surface?
If you're talking about from your hands,
So for example, if somebody's wearing gloves, could that impact whether or not they leave DNA on a particular surface?
if they're touching something with gloves, correct. The gloves would interfere with leaving the touch cells from your hands.
And in terms of whether or not, let's just say hypothetically, blood or a blood-like substance is left on an object and that item is subsequently swiped with either a cloth or a paper towel, could that also influence the amount of DNA that's left behind?
Yes.
How so?
Well, if you use something to wipe up something and then throw it away, you're cleaning up some of that liquid or whatever it is, blood. So then you're losing some of that DNA that was there and just leaving behind remnants of it.
And does DNA degrade under certain conditions as well?
It does.
What does it mean when DNA degrades?
The DNA is breaking up and you're getting less of it. So if it's under the influence of ultraviolet light, bleach, moisture, heat, all different factors can degrade DNA over time.
If I just have a moment, Your Honor. I have nothing additional, Judge.
Thank you. Cross-examination.
How inconclusive is all of this? What about the kids?
Good afternoon, Ms. Maid.
Good afternoon.
So I'm looking at your resume, which has been put into evidence. You have a degree in biology, right?
Yes.
So I'm going to ask some questions about, for those of us who didn't major in biology, okay? So when we're talking about DNA, we're talking about something that is transmitted. Everybody has DNA. Correct? We all have. Every living thing has DNA.
Yes.
Whether it's a plant, a bug, an animal, or a human.
That's
right?
inconclusive.
At least when it comes to human beings, there are 2 sets of DNA that we inherit from our parents, correct?
Correct. Half from your mom and half from your dad.
So if we go back to basic biology, you have a mom and you have a dad, they have a child, and they inherit the DNA half from the father and half from the mother, right?
Correct.
And unless there's artificial insemination, you need 2 separate parents for that process to take place, right?
Correct.
And that within the DNA, there's something called alleles, correct?
Those are, yes, the specific types of the DNA profile.
And they're, for those of us who remember this from maybe high school biology, the DNA is kind of a double helix. It's sort of a twisty thing. That's how it's described. I think that's, if you use an electron microscope, that's how it'll appear, right?
It's like a twisted ladder or spiral staircase, yes.
And within that twisted ladder or spiral staircase, the alleles repeat at certain intervals, correct?
Correct.
And in any event, you're going to inherit half of your alleles from the male side, the dad, and half the alleles from the mom side, right?
Correct.
So one of the ways that these ancestry organizations work is they can trace your ancestry based on maybe a cheek swab or something, looking at other people in the database to see whether you're related to somebody else, right?
Correct, yes.
Because there'll be a lot of similarities between you and your parents and your children, right?
There could be, yes.
And in any event, if there are twins, whether they're identical or they're fraternal twins, they're at least close in, there'll be a lot of similar DNA, right?
And there's 2 sets of twins. So
when you're running this program, the STR Mix program, right? This is a proprietary program, right?
We do not know the source code. We know how it works, but we do not know the source code.
Right. In other words, it's a private company that has patented this calculation simulation, right?
It's a private company, yes.
So you're programming in information, right?
I put in the DNA profile.
And other information too, right?
Yes, I tell it how many number of contributors I believe it is.
Right. And I want to ask you about that. You put in a number of contributors that you believe or assume are in a mixture of DNA, right?
Based on my knowledge, training, experience looking at profiles, yes, I give my best estimate of how many contributors I believe that DNA profile is from the data.
And of course, that makes it more difficult when there's multiple contributors, right?
Sometimes it can, yes.
And in addition to that, if you have a very tiny sample that's only partial DNA, it's even more complicated, isn't it?
It can be, yes.
And some of the things when you talked about is, you said that it was inconclusive. Part of the reason was the sample wasn't even big enough to get enough alleles and repetition within a sample. Isn't that true?
Well, I'd have to know exactly what sample we're talking about.
Well, I'm using just in general. We went through a lot. Some of them, it was inconclusive because it was too small a sample for you to be able to derive a profile from it,
I
right?
think, yeah, I call those insufficient, I believe, when it's too small of amount to make a comparison.
Okay. Well, you're using the word insufficient, whether it's little or insufficient. It's just not enough sample for you to develop a profile of a person, right?
You're talking about two different conclusions, yes.
All right, well,
Yeah.
fine, all right. Now, when it comes to what the lab does, you're not actually comparing the whole DNA to another person, are you?
I don't understand your question.
You're only choosing alleles from certain pinpointed locations along the double helix, right?
Well, 99% of everybody's DNA is the same, and we focus on this 1% that is most variable between individuals. And we use a kit that has a certain amount of sites that we do test. Yeah, so it's not every single site, but it's a representation of some of the
Right.
alleles that vary.
And currently, the system you use has, I believe, what, 21?
Autosomals for statistics, global filer. Yes. but
Right,
it also
global
has-
filer, you take 21 points along the DNA strand to make a comparison, right?
21 autosomal sites, yeah, locus.
No, it's not a genome of that person or anybody, right?
It's not their whole genome, no.
Okay, and just for clarification, how many loci are there in a human DNA?
Oh, I don't know the answer to that.
Is it in the hundreds?
Well, the question really is, what is the range or an estimate generally? So overruled.
Give us an estimate.
I honestly really don't know if it's hundreds or thousands.
What was that number?
I honestly don't know if it's hundreds or thousands for how many loci.
It may be hundreds of thousands, right?
It could be. I honestly really do not know.
But we're only focusing on either 21 or maybe 23 locations along the strand, right?
Very discriminating locations, yes.
And when you're looking at alleles, right, you're not just looking at what the specific allele is called, because they'll have numbers and letters, right?
Numbers.
But how often it repeats along a DNA strand, right?
Right, that number is how many times it's repeated.
And that's how you determine whether it's unique to a particular person or you can compare it to another person, right?
That's how I just determine the DNA profile, is by the number of repeats at each testing site.
And some of the alleles occur in a large percentage of the,
yes,
of the I'm using the word loci because loci basically means places, right? Or pinpoints, right?
Those are the different sites that we're testing,
Right.
yes.
But I'm using the word loci so that the jury
in
understands
trouble.
that word is a Latin term for location, basically.
Mhm.
It's another way of saying that, right?
Mhm.
Yes?
Yes, sorry.
Okay. So certain of the loci, for example, are only found in male DNA, right?
Yes, there are sites that we test that are only found on the Y chromosome.
And are there some that are only found in the X chromosome?
That would be mitochondrial DNA.
And you, according to your resume, had some experience in doing mitochondrial DNA testing, right?
I do, yes.
But we're not talking about that here, are we?
No.
some of the DNA repeats. They're given actual numbers, either whole numbers or decibel partial numbers, right?
Correct.
And that's how you determine how often it's going to repeat on the DNA, correct?
In that specific location, that's how many times that length variation repeats. Yes.
And if you look at one of your reports, there's a chart that's contained in many of them, right?
Correct. We used to produce an allele table with everybody's types on it.
And if it shows the numbers, those are any numbers you put on there showing how often something repeats in your sample, right?
At this, yes.
We're also looking at an unknown sample, the one came swab or on a piece of material or whatever else that you are taking to determine whether or not that DNA shows similar repetitions as one of the people you're testing against, right?
I am comparing the DNA types from a known profile to the DNA types of an evidentiary profile. Yes.
And when you use the word during your direct examination a lot, assuming X or Y, or assuming this or that, you made certain assumptions as to many of these samples before you then compared it to something else, right?
Correct. I determine the number of contributors in the evidentiary profiles before I compare them.
But you also, for some of them, assumed, let's say, that the person whose DNA was on the toothbrush, right, was one of the contributors to the sample, right?
In certain non-probative pieces of evidence, yes, we do that.
Well, you're using words like non-probative. You made the determination to use that regardless of whether you think it's probative or not, right?
No, we only can use we only can condition a known profile on an item if it's a non-probative comparison, typically a victim, that you would expect scientific expectation that the profile should be there. So like if my car gets stolen and it's recovered and they swab the steering wheel, you would expect my DNA profile to be on the steering wheel with anybody else who may have drove it. So if we would condition my DNA profile if it was truly there. If I looked at the results and saw my types there, I would condition my known in order to get the second contributor better explained.
So you're assuming, I assume by that answer, you're assuming that your DNA would be on your steering wheel. is what you're
If
saying.
looking at the data, it was there, yes. But looking at the data, I have to see my types there. I wouldn't just say I'm there. I would look at the data and see that my types are there.
But if you assumed that the contributor was someone else, whether it was a close family relative or not, it would change the likelihood ratios, wouldn't it?
Well, it would have to have a
That's a
scientific
yes or no,
expectation.
wouldn't it?
Well, to indicate to an expert what the expert's answer is, when an expert is qualified by education, knowledge, training, experience, and skill, is
I had to go retrieve Clyde. He was making noise outside.
inappropriate. Secondly, the witness took an oath to tell the truth, whole truth, nothing but the truth. To tell the witness what the answer should be,
Ooh, what'd I miss?
you can move it to have it stricken as non-responsive. But this court does not permit counsel to tell a witness what their testimony should be.
Yes, Your Honor. Let me
You can ask
rephrase-
the question again.
Right. Let me rephrase the question. Regardless of whether I use the example of your steering wheel or not use any example whatsoever, the assumptions that you made about a contributor would, if you changed that assumption to a different known contributor, it would alter the likelihood ratio that would come out of the STR mix computer program, correct?
I
Again,
think
it's hard
so.
to answer as a yes or no.
So it wouldn't change it? It would come out the same?
No, it could, but it all depends on the data and if that person is scientifically expected to, be on that profile and their profile is there.
But once you run the program and you come up with a deconvolution report on using STR mix, when you then test it against someone else, you don't go back and pretend you don't know who the source is. You start with what you've already, we'll call it deconvoluted, right?
You have one original deconvolution, yes.
Right. So when you add someone, you're starting with the likelihood ratios that the computer has spit out for you previously, right?
You don't get the likelihood ratios until you make a comparison to an individual.
But you don't do a full deconvolution analysis again over the same sample if you're running it against other people. Is that a fair statement?
I'm sorry, can you say it again?
Yeah. If you decide to check the sample, an unknown, against other people, you start with the report that was already developed from the STR mix computer printout previously, correct?
Correct, yes.
Okay. Let me just ask you some questions about some of the other things that came up on direct examination. A lot of the descriptions, both in the stipulation that we've entered into, the lawyers have entered into, and in your report, make reference to descriptions such as swabs from a blood stain, luminol plus whatever, KM plus. These are things that you mentioned. Those were how it came to you with a title, right?
Yes, that was how the submitting agency named that piece of evidence.
So you didn't label that this had was a blood-like stain, did you?
I did not, no.
The police called it that, right?
Yeah, whoever the submitting agency was, yes.
Same thing with if they said Castlemeyer KM plus, that's just the police writing that down on the sample that they put on the bag that they then submit to the lab, right?
Correct, yes.
Same thing with if they use luminol, that is just something they wrote on the bag,
I'm
right?
just going to object, Your Honor, at this point.
Right.
Can we have a brief sidebar?
Well, first, the nature of the questions are simply as the court understands them. This witness did not write the descriptions on the bags. And this witness has stated she did not write the descriptions on the bags. So the court does not really see, unless there's a relevance objection, the necessity for a sidebar.
Well, may I have heard, Your Honor?
Yes.
I'm objecting because I think it mischaracterizes what happened. I think the question sort of assumes that the police are just writing these things as though no test was done. And I don't think that that's what the evidence is.
Well, that's essentially, in the court's view, an extraction from the questions. The questions appear to be very simple. There was information on the bag when you first saw them. That's
Yeah.
how the court hears the question. So
Yeah, he's gonna have to show where he's going with
flowing
this.
from that, the court cannot contemplate, other than the fact that there was information on the bag, and she did not write it. Overruled.
Oh, wow.
Am I correct? There's just something that was written on the description that you then note. You didn't change the description that the police put on it, correct?
No, we use what the police describe it as, so it continues through.
Right. You just give it your own letters and numbers to distinguish what you do from the exhibit and description that the police put on the bag, right?
Yes, we have unique item numbers for our pieces of evidence under our case number.
Right. And I just want to be clear, you indicated that you're familiar with a little bit with Castlemeyer KM, is that right?
I am, yes.
But you're not a biologist, right?
I'm a forensic scientist who I've had training on KM. I have a proficiency test twice a year in order to perform KM, so I can perform KM testing and I've been trained.
I didn't want to interrupt. Did you finish your answer?
Yeah.
And KM is not used, it's one of these presumptive tests, right?
We call it a screening test.
The screening test. It does not mean that a substance is blood, does it?
No, it just is testing to see if there could be the presence of blood.
There could be, but you're familiar with the fact that many other things test positive if you use KM on it, right?
Yes, other things can make a positive result.
And we're not just talking about animal blood, are we?
No, there's other plants and horseradish. There's a couple things that will make the test turn positive, but we're trained to swab things that are reddish brown in color and not just any swab.
But you made no determination as to whether or not any of these items yourself, you didn't determine whether they contain blood or not, did you?
I do believe that there are some items in here that we did do KM testing on at the lab. That would have been Christine Roy, but I have some of those results in my lab, in my reports.
No, I'm saying you personally did not.
No, me personally, no. All these evidence items went to forensic biology first, and they did all the testing.
And you know that you would not rely on a KM test to make a determination as to whether something actually was blood or not, would you?
No, KM testing cannot tell you that it's 100% blood.
Well, it can't even tell you if it's 99% blood, can it?
No.
Potatoes are one of those things that test positive, right?
I don't know definitely that. I know horseradish and we were trained to know that horseradish and some plant peroxidases do, but I mean.
And rust can too, right?
Rust is kind of tricky. Sometimes so when you do KM testing, you add that first colorless liquid and rust makes it change pink then versus you're not supposed to change pink until after you add the second solution. So rust is kind of like a false positive.
But anyway, rust, from your own personal knowledge, is kind of a reddish brown color too, isn't it?
It is, yes.
And you wouldn't say that it's scientifically reliable. That is, any reagent presumptive test is not reliable for finding blood, is it?
I would say the screening test is reliable for saying that it's KM positive and there's a chance that blood would be there, but we can't say that it was blood, no.
You're saying there's a chance that there is. My question is, you wouldn't testify that as a result of a KM test, that something was in fact human blood, would you?
I would not know.
you're also aware that most of the items that you went through that you tested for were not even screened for whether there was actually blood or not through the biology portion of your labs. Is that correct?
Yeah, the ones that come in that are already labeled KM positive or luminal positive or even negative, we don't repeat that test because we do the same tests and we trust that the PD did their correct testing and we wouldn't waste samples from the swabs to do that test again and take some of that sample that would then maybe not lead to a full DNA profile.
Ms. Madel, you're not in the biology department that does the testing for blood, are you?
I do know the protocols though.
All right, but you're not in that department, right?
Forensic biology and DNA kind of are intertwined and I'm trained on some evidence exam and I'm competent on KM. So, I'm not, but I'm majorly a part of the DNA unit.
And I just want to be clear, you would not testify under oath that something was in fact blood based solely on the fact that it was a positive KM test, would you?
No, I would not.
And when I asked you, most of the samples that we went through earlier through the state, you went through 100 maybe samples. I asked you whether or not most of them were not tested at the lab, and I don't think you answered that question. Am I correct that most of them were not tested with a confirmatory test for what it was, correct?
None of them were tested in these samples as confirmatory.
Earlier, when you were asked what are the sources of DNA, you made reference to blood. Let me just look at my notes here. You said blood, semen, I think you said hair, and you said bones, right? Didn't you leave out like the major source of DNA in that answer?
Blood, semen, saliva, bones, teeth, hair?
How about skin?
Cells, skin cells.
Skin cells, okay. Let's talk about skin cells. All of us have skin cells, right?
Yes.
And all of us have the same DNA in our skin cells that we do in our hair, in our blood, in our, shall we just say, our bodily fluids, right?
Correct, yes.
So you could take a cheek sample swab, right? And you would run a DNA profile on that cheek swab. You follow me so far, right?
Yes. Mm-hmm.
And it would be the same result for the DNA profile as if I took a sample of blood, right?
From the same person, yes.
Well, that's what I meant,
Yeah.
from the same person. Okay. And when it comes to skin cells, for most people, they're shedding skin cells all the time, aren't they?
Yes.
And in fact, if you cough or sneeze, you're also through what they call aerosoliation, right? You're expelling DNA that way too, aren't you?
Yes, that's possible, yes.
When it comes to DNA, there's also something called primary transfer and secondary transfer. Is that correct?
Yes.
And I'm not sure you explained the distinction between those, but if we're talking about touch DNA, right, when you get a sample, does the biology forensic portion of your lab note on the file jacket whether something is touch DNA or some kind of fluid DNA?
They do.
And when you gave your testimony today, you did not distinguish between whether any of the samples that you tested and re-identified with the letters and numbers that we went through, whether they were touch DNA or something else, right?
Correct, I do not. I just test the evidence that they submit forward to me.
However it comes to you, you do a DNA profile and then you run the test on that regardless of what the source is, right?
Yes.
And when there's a mixture, as you pointed out, of more than one source in a DNA, one might be from a liquid source and one might be touch DNA at the same time, right?
That is possible, yes. We can't distinguish where the DNA came from.
And if, for example, if I were to sneeze into my hand, as some people hopefully don't do, and then touch a doorknob, chances are that there might be a mixture of just me of both the skin DNA and maybe a liquid DNA on that doorknob, right?
That's possible, yes.
And then if someone else goes and touches that doorknob, they're not only going to maybe have a disgusting mess on their hand, maybe get some cold germs, but they're going to maybe get some of that transfer of the other person's DNA onto them. Is that right?
That's possible, yes.
Right. And then if I were to come over, or I don't want to use me, if that person was then to go over and shake someone else's hand, that's what secondary transfer is. If now my DNA or the first person's DNA is now on that hand of that second person, right?
That's possible, yes.
And that's regardless of whether someone's wearing gloves or not, right?
No, it can be picked. If they touch a doorknob with gloves on and then touch something else with the gloves on, the DNA would be on the gloves.
The DNA could then transfer to that other person as well.
Correct. Yes.
And to other surfaces that they then touch, right?
That is possible, yes.
And when you talk about, there were a couple of examples you gave where there may be 4 or even 5 contributors to a sample, right?
Sometimes we have 4 or 5, yes.
And it gets more complicated, more convoluted, if you will, to try and separate it out the more contributors you have, right?
And that's why we use star mix, yes.
Exactly, right? And then you're relying on star mix because it's just running this program to give you likelihoods of hypothesis A versus hypothesis B, right?
No, it's actually, star mix is giving us weights to best explain the different components that actually make up that mixture profile. That's what star mix is
But
doing.
what I'm trying to understand is it's not making a match to anybody, is it?
No, it's deconvoluting that mixture of 4 people to try and determine the best explanation of the 4 different people that are contributing to that 4%.
But in any event, the word is likelihood, not an actual, it's not identifying anyone, is it?
No, it doesn't identify anybody.
And when a report is inconclusive, I think you indicated, and you said it a few times, one of the ways that it's inconclusive is the sample is either too small for there to be enough allele locations to be able to be clear on who that person, who it might be connected with, correct?
I believe that's my insufficient conclusion, insufficient for comparison.
And inconclusive means either there's too many people that maybe have similar DNA, or it's just not enough points of reference to make a determination, right?
The inconclusive is when we do that likelihood ratio, and the likelihood ratio comes out to be in this range that is below a positive association, but above being eliminated. So
Right.
that's why we can't make a conclusion.
All right. And the danger, of course, with inconclusive is there can be false positives, and you could make mistakes if you try to subscribe an inconclusive result to anyone in particular, right?
Well, we just have that range that we say is inconclusive because it's not above what we deem positive.
Well, when you say it's a scientific level that's been established by the lab, right?
That it's not a positive association, correct?
And when you say someone is excluded, it's because there is an allele present that you know from the profile of the actual person is missing or is missing completely, right?
Well, it's not just one allele, it's the profile overall.
Oh, I meant to say that if you count all of the alleles that you produce, even if it's more than one person, that the individual you're comparing it against is actually does not have that allele at all, right? That's how you eliminate somebody.
It's not just from one allele. You have to look at the profile overall, the data, the number of contributors, the peak height. So it's a little bit more complicated than just not having one allele.
So other than in a couple of situations where there was inconclusive information, and I think you mentioned that every one of the people you mentioned had at least one inconclusive, right? Whether they were a contributor or not, right? All the children.
We're at least inconclusive once overall.
I'm trying to make a broad question. You went through 100. I could pull out the individual ones, but I'm
Okay.
just trying.
Yes,
There
the
were
children
some
were
where all the children were at least on one occasion inconclusive, right?
Yes,
And in others, they were actually contributors.
yes,
And then there's others where they were eliminated.
yes,
And then there was a 4th category you said, where I think you said it cannot be eliminated, right?
yes,
That was because it was a higher threshold than inconclusive, but less than identified as a contributor, right?
So the cannot be eliminated is a positive association that it was just a terminology that we used to use. And we've currently changed the way we report that as consistent with a contributor, which I defined also, because it was confusing to people for us to say cannot be eliminated because we were saying eliminated, but it was actually the opposite. You cannot be eliminated. So it's still a positive association. It's just the wording was a little
Yeah,
different.
but I want to be clear, when you say a positive association, it's below a threshold where you could testify that that person's DNA was actually present, correct?
No, it was a positive association. They were a match. They were a partial match, but they were a match and had a positive association.
When you say partial, you're again talking about that you could not testify that it was a match because it was only a partial identification or partial connection, right?
It was a partial match, but it had a positive likelihood ratio.
Again, that's the computer saying it's a likelihood ratio, right? Positive likelihood.
Well, we used star mix to calculate that because it would take us too long to do all those hand calculations.
And I take it you've never tried to mimic a SDR mix report by hand calculating out the odds, have you?
In my training, I only had to do it once.
All right.
Correct. I have not done it a million times. No.
A million times. No, and the machine does it, runs odds a million times, doesn't it?
It has many iterations to try and describe the components of the profile, and then it calculates the likelihood ratio.
All right. Let me ask you a different question. Let me put it to a different way. The program runs what's known as an algorithm, right?
Correct.
That's the proprietary source code for STR mix, right?
Within the mathematical process, yes.
And you don't know, you could not describe how that process actually, you don't know the code is what I'm trying to get at here.
I do not know the code of the algorithm. No, I do not.
But these kind of programs that run these kind of likelihood of a certain result are similar to what's used by the lottery for calculating the odds of winning the Powerball, right?
I honestly do not know what kind of calculation they use for that.
Are you familiar with the term the Markov chain Monte Carlo?
Yes, that's the mathematical process used in Star Mix. Yes.
Okay. Do you know why the word Monte Carlo is part of the name?
Right, because it was originating from a gambling. Yes, but I didn't know that that was used for the lottery.
All right. But, all right, so the gambling though, right?
Yep.
You're talking about Monte Carlo as the capital in Monaco in Europe, which is a big gambling mecca, right?
Yes.
And what they're doing is that kind of program calculates the odds of winning the jackpot on whatever machine, gambling machine, is being run with a giant jackpot, right? You don't know?
I guess, I don't know that.
All right. But if, using that as an example though, if two people, if the odds of winning the $1 billion Powerball, according to a program, an algorithm such as this, were 1 in 100 billion, right? Just assume for my hypothetical here. Does that mean if two people were to win it, that they were cheating?
That's different odds. You're saying 1 in 100 billion, where we're having the likelihood ratio with two competing hypotheses. So given my likelihood ratio is different than that.
And again, we're talking about hypotheses. Again, you're basing the hypothesis based on a prosecution's theory of a case, right?
No, we base it on the background information of a case and the actual profile itself.
Well, who decides on the hypothesis? You or someone else?
Yes.
You make the
The
determination of
DNA
the
analyst,
hypothesis.
yes.
And you have to read something about a case just to make that hypothesis, right?
You need background information on what the kind of case is, yes, and the pieces of evidence, yes.
Because otherwise, it's not like you're blindly taking a piece of evidence, putting it into a machine, and then coming up with a result without you having subjective input, right?
Correct.
Okay. And just so that I'm clear, I'm going to go back to the issue of, you already testified that what the STR mix is doing is not matching a sample to a particular person or two people or three. It's giving a likelihood of a ratio based on two hypotheses, right?
How likely that evidence is to occur given hypothesis 1 compared to hypothesis 2.
And when you say likelihood, we're talking about odds, aren't we? Mathematical odds, correct?
Yes.
And let me ask that. So these odds are not based on population numbers either, are they?
No, it's not a frequency estimate, no.
So when we hear large numbers like 10 billion or 4 billion or 150 or 250,000 or 100 billion, we're not talking about other people on Earth, are we?
No, we're not.
Those numbers have nothing to do with populations, correct?
Correct.
And when we talk about skin cell DNA, you refer to that as touch DNA, right?
So the forensic community is trying not to refer to some low-level DNA that might be collected from a surface as touch anymore, because we don't want to imply that someone actually did touch this counter and left their DNA. So we're calling it more trace DNA when it's small amounts recovered from an object or surface.
You are aware, though, that even at least at the time of 2019, the folder, some of the forensic folders from your lab still are using terms like touch in relation to this very case, right?
Well, yes. I mean, that's kind of also just for them to distinguish between when they have a piece of clothing that has bloody areas and then has non-bloody areas. They're just making that notation to say, like, I'm trying to avoid swabbing where the blood is. So this is an area that didn't appear to have a reddish brown stain. So I swabbed it, the touch area where something might have been touched versus having a body fluid on it.
And if somebody, for example, if I stay away from the word touch and instead use the term skin cells, that would be a better way to describe it, right?
Describe.
The word touch DNA.
Yes, I mean, touch DNA, yes. If you're saying someone touched something, you would get skin cells there, yes.
But if, let's say, I don't know, a police officer is walking through a house touching things, chances are that person's DNA might be found on those areas that were touched, right?
It could be, yes.
And if you have a result where you have unknown contributors to the DNA, it could be anybody who walked through that door who isn't separately tested to see if it belongs to them, right?
That's possible, yes.
Who told you to limit your DNA comparison to the children, to Lauren Almeida, to Fotis Dulos and Michelle Troconis and Pavel Gumieni?
I only can make comparisons to the knowns that are submitted from the agencies. So that's what I do. When I get a known that's submitted by an agency, it gets processed, and that's who I make the comparisons to. I don't ask for additional knowns unless it's for an elimination known, like the situation for a stolen car. We get a swab of a steering wheel. It's a two-person mixture. I don't know if that person who owns the car is on there too, so I would ask for their known. But otherwise, I wouldn't ask for particular knowns unless there was a.
And I don't think you were asked this by the state, so I just want to ask you this. When a swab is submitted to you, it's from some surface has been wiped. Let's set aside for a moment if an actual object or cloth, as you said, item of clothing or something is submitted. We're just talking about a swab.
Okay.
You have not observed how well or how poorly that swab has been administered, correct?
Yeah, if I did not make the cutting of the swab, I did not see it. Therefore, I don't know, what the swab looked like.
Do you get the actual cutting, or do you get the chemical or liquid that cutting of the swab was put into?
No, I get the actual swab in a tube.
But you get a snip off of, it's like a giant cotton tip applicator, right? So those of us who've had COVID testing know it's like these long sticks with a cotton tip at the end, right?
Correct, yes.
Bigger than a Q-tip that you might find in the hotel bathroom here, right?
So yeah, the forensic biologist would cut that swab, that cotton part off, and put it into a tube.
Put in a tube, then it's given to you.
Correct.
And then you do something where you copy that sample, is that right?
Well, first, we extract it first, get the extract, then we see how much DNA we have, and then we make all those many copies so we can hopefully generate a DNA profile.
And at least as of 2019, when most of this, 2019 and 2020, when most of these comparisons were done, you were able to extract some DNA from as little as 3 cells, right?
I'd have to go back and look at my quant values for all this thing to testify that I did have something that was that small amount.
Is that in?
I am reading something.
No.
Well, you used at the time, is it Fusion 6C?
Okay.
Fusion 6C was the STR kit for 2019 and 20, yes.
Random
And
person that
you
actually
would take
comes
the
in
sample.
here.
These are tiny amounts, right?
There could be tiny amounts of DNA, yes.
And so the jury has some kind of semblance of size. One cell, as I understand it, is 6.6 picograms in, is that weight or?
Now, the issue would be, how do they know? I mean, if you're like the handyman or the guy who comes by and does like the Green X or stuff like that, I mean, they might try to get a hold of you and get your DNA to clear you out, but there also might be some ideally you would just show up as an unknown DNA sample, like as an unknown male, like, because they can tell if you're male or female. They can do that, and you'd just be an unknown male. So, Frozen Cedar Rose says, how do lawyers survive the dry parts of trial? When you're in it, it's not boring. So, yeah. So it's not as bad. So, if that makes any sense. So, here we go. Let's get through it. We're almost there. We only got like 10 minutes, guys.
Or size.
Weight,
Weight.
yes.
And so that we're clear, you've got grams, you have milligrams, you have nanograms, you go down to picograms, right?
Correct.
And one picogram is a trillionth of a gram, right?
1 picogram.
You should know this is math, right?
Yes.
You should know
Yep.
that, right? Am I right?
Yes.
Okay. So if you have one cell is 6.6 picograms, we're talking about 6.6 trillionths of a gram, right?
Yep.
And if you're not disagreeing that you can get a sample out of it, as little as 3 cells.
So 3 cells would be 18 picograms, approximately.
Well,
6.6 times
so
3, yes.
more like 20.
So
right?
20 picograms.
Okay.
You might get a few peaks. We target for fusion, we were targeting 500 picograms.
That's your goal.
To get a full, correct, yes.
But if you don't have that, you run the test anyway. Right?
Correct, yes.
And that's how you get these partial results. Isn't that true?
That is true, yes.
And that's why in a lot of the places along the loci, it'll show NR, meaning no result.
No result is NR, yes.
So you then have just a partial DNA and the machine is still trying to run the ratio, the likelihood ratio against a partial DNA result, isn't it?
We could try and run a likelihood ratio for partial, yes.
And doesn't STR mix actually add in, like, presume, what if there was this extra allele in there? Isn't that part of its whole process?
The whole process is trying to explain what makes up that profile, yes, by how the PCR program works, which is the amplification process. It knows how it works. It is trying to use those, word I'm looking for, use the way PCR works in order to come up with the best explanation for that profile, whether it be a full profile or a partial profile. It produces these individual components with weights to them.
So this isn't like AI though, right? It's not artificial intelligence, but it's something like that, right?
No, we know how it works. We know the mathematical process that's being used, the MCMC as you refer to, and the biological modeling of the PCR reaction. And it's doing all these iterations to best describe that DNA profile.
I understand, but getting back to what I was trying to say is, it is filling in. It says, what if the missing allele was X or 7 or 12, whatever, and then runs the program again to see if it was that, how would it come out in the likelihood? Isn't that part of the process?
Not to do with the likelihood ratio. It's doing all those weights first.
But it also assumes missing data and it adds it in as a part of its probability, isn't it?
It's giving weights to possible explanations. So it does look at other things, but it's like a game of hot and cold. It's proposing this type to make up the profile. And if it is a hot or a good explanation, it goes towards that iteration. If it's not a good, it'll be a cold and it will go in a different direction to try and best explain the different DNA types that are making up that profile. And then those weights.
Ag, what do you mean by that? I don't understand what you mean. So, can you explain that? Because I don't get what that means. Okay, so you have questions about the actual science she's talking about here. Okay. I'm just curious what you meant by all that, because it's...
Are used then, after it comes to a conclusion on what is the best explanation, then it uses those weights to calculate that likelihood ratio.
And so you're accepting the calculations from the program for your conclusions that you've told us about today, right?
Yes.
When it comes to the sample, we talked about how little it could be. And just for reference, would a period on a daily newspaper be larger than the 20 picograms that we're talking about in terms of just being able to visualize it?
You can't visualize 20 picograms.
It's way microscopic, right?
Correct.
And the only way that you're able to even run this process is you do some kind of the equivalent of like photocopying the sample you have, right?
Correct.
So you have a process that's, not challenging, it's established. So you sort of mimeograph for those of us who are a little bit older, or you photocopy the data so you have enough to then run through your program, right?
We have enough so that we hopefully can develop a DNA profile.
Now, there's also a major and minor contributor to various samples if there's more than one contributor to a sample. Is that true?
Sometimes that can be determined, yes.
Who decides what those percentages of major and minor contributors is going to be?
Well, we can look at it as a DNA analyst and estimate, but when we run through star mix, it also gives a weight to what each contributor is contributing to that profile.
And again, this is calculating based on the quantity of what is now in the system based on your multiplication or photocopying of it into making a larger sample, right?
Based on, yes, the number of contributors I'm calling it, and then the DNA profile result that we obtained, yes.
And when we're talking about major and minor contributors, if it's, 60 or 70%, and the other contributors are 20 and 30%, the person, let me rephrase that, the sample with the higher percentage is considered the major contributor, right?
That would be yes.
And then all the lower numbers are the minor contributors, right?
Yes, but sometimes you can't determine a major contributor and a minor contributor.
Well, when you say you can't, but can STR mix?
Well, STR mix doesn't ever call anything a major and a minor. It just gives you those percentages to make it to 100.
Do you ever disagree with its percentages? Are you able to recalculate that, saying this is wrong?
We do. That's one of the parameters that we do check to make sure star mix runs correctly.
So Attorney Schoenhorn, if the next series of questions do not concern major and minor contributors, it's 3 o'clock.
That's correct. So I think this would be a good place to stop for the day.
Thank you. Ladies and gentlemen, we conclude the evidence for today. We suggest again that you would check the judicial branch website tomorrow because the weather may be such that there may be a delayed opening. And we would ask that you please do not discuss the case. And have a good evening.
Yes, sounds like she knew the word the whole time.
Off the record.
You may be excused.
Okay.
Thank you.
Okay, this is kind of making sense then.
Cross-examination is expected to continue tomorrow for this witness, correct?
Yes.
Okay, and how long do you estimate on cross, Attorney Schoenhorn?
15, 20 minutes.
Okay, thank you.
Oh, wow.
And the state has a lineup for tomorrow? Okay, thank you. We'll stand adjourned until tomorrow morning, right now at 10 o'clock.
Could we start at 10:15 with the court's permission?
We can. So adjourned until tomorrow morning, 10:15.
Thank you.
That's nice he's starting so late.
This honorable Superior Court now stands adjourned.
I feel like you'd be an excellent expert to cross as DNA expert. Well, here's the thing. You need to know what you're doing with that, because if you don't know why he's asking these questions, what he's getting to, as he said, there's going to be spots where he's defense counsel asking questions ahead of time that, they're getting answered now that they're using later to impeach with. So it's kind of one of those situations, guys. So that is... Well, yes, this is also a big question here. How can this machine calculate the probability of the match when the sites of comparison are missing? Yes, and they make it clear. I mean, they give it the parameters to operate in, and then it makes it work. So, yeah. I don't know. I don't know how else they would do that. So, well, it looks like it goes on for a little while tomorrow. And then apparently some big stuff happened. Some more juror problems happened, among other things. So, we're not going all night. We'll do day 6 tomorrow. So, we're not doing that. Bust out the cocaine, jump straight into day 5. We are on day 5. We just finished day 5. So, 24-hour stream. God, I'm never doing one of those. So, yeah, I'm sure he's going to be wrapping it up tomorrow, and hopefully that's where he's kind of sticking in the jab at that point. But we'll see where he gets to tomorrow with this expert, and then we'll be done. So, guys, I will see you tomorrow. We are probably going to be doing it tomorrow night. If that changes, I'll let you know, but it will be tomorrow evening. And yeah, from there we'll be caught up. So have a nice night, and yeah, we'll be ready. So good night, everybody. I don't actually, well, hold on. Who's live right now? Hold on one second. Okay, yeah, sorry guys, we're trying to figure out who's still going. I guess Jeff is still going. Oh, and looks like Nick is about to go. Well, actually, he says 1 a.m., so 1 a.m. his time is like... Yeah, that's going to be late, so never mind on that one. So let's see. I'll get you guys over to Jeff. How about that? Content. Show lives. Yeah, there we go. We got Legal Vices going, so I'll just send you guys over to Jeff. He's doing his Lady Bits stream. I don't know what all thoughtery he's got going on there, but we'll all go over and take a look together. So I will send you guys there. Oh, it's Jeff Titty's stream. Oh, okay. Saying it's midnight next time. Yeah. Oh. Yeah, good. You're right. It'd be 1 a.m. Eastern, midnight his time. So yeah, Vice is simping to everybody. So all right, guys, I will see you tomorrow. Good night, and take care in the meantime. Like I said, by the way, the big breaking news today, Alec Baldwin got reindicted, so that will be interesting to see how this shakes out. Good night, everybody. Take care.